Yes, fresh matters.
Fresh matters.
Fresh matters.
Yes,
My lords, with leave of this court, my lords.
sir. Yes, fresh matter.
My lords, we have moving the memo, my lords, for the listing the matter for tomorrow or day after.
Fresh
There is
matter.
urgency. No, my lords, it's old matter, but my lords
Old
have
matter
been
is not
heard.
not possible now, madam. Yes.
My lords, only with regard to
Not possible.
clarification from the government, my lord, it has
No, no,
been,
no. Not possible. Yes.
For pronouncement of order,
My lord, serial number 41, my lord. 41, my lord. And this
Much
petition
obliged.
respondent intimation
Adjournment.
adjournment next week, man. Already other side ಇಲ್ಲ.
41.
41.
ನೀವು ಒಬ್ಬರೇ ಅದರ್ ಸೈಡ್
Yes, ma'am.
serial number 41 at the request of learned counsel for the petitioner list this matter after winter vacation.
Obliged.
Yes.
for pronouncement of order, CL number 1, MM Patil.
Appellant terms.
Appeal is allowed in part. Judgment and decree dated 27th February 2016 passed in original suit number 20 of 2014 by the senior civil judge and Jevargi. With respect to item number 2 of schedule A property in respect of land bearing survey number 236 of Hipparagi SN village is concerned is set aside. Matter is remanded back to the trial court with a direction to provide an opportunity to defend number 8 and 15 to file the written statement in respect of item number 2 shown in suit schedule A property. After filing the written statement, the trial court shall proceed with the matter in accordance with law. As the matter is of the year 2014, the trial court is directed to dispose of the matter as early as possible.
CL number 2, Shankar or Patimani, party in person.
Agree.
Consequently, you proceed to dismiss both the writ petitions.
Admission matters. CL number 3. Harshvardhan R. Vani Patil.
Your Lordship, this first appeal is by the defendant, Your Lordship. Your Lordship, it is the case of the plaintiff that defendant and mother of the defendant executed an agreement for sale in favor of the plaintiff, which is dated 17th March 2016, Your Lordship. It is in the agreement for
Specific performance.
please, Lordship. It is the case of the plaintiff that
Dated for defendant.
I'm for the defendant, Your Lordship.
Defendant.
This is defendant's
Suit has been
appeal. Please, Lordship.
Ah.
So the plaintiff's case is that defendant and defendant mother executed an agreement for sale in favor of the plaintiff dated 17 March 2016, Your Lordship. So, Your Lordship, after that, the suit is filed in the year of 2023, Your Lordship. That is after a lapse of 7 years. The suit is barred by limitation, Your Lordship. And Your Lordship may kindly see there is a clause number 4 in the agreement for sale, which says that a time period is fixed, Your Lordship, of 2 months from the date of execution of agreement for sale. So that being the case, Your Lordship, the trial court has not looked into the clause 4 of agreement for sale and passed a order of decree, Your Lordship.
Issue notice to the respondent. Next para. It is the contention of the learned counsel for the appellant who has suffered a decree of specific performance, that a time frame of 2 months were fixed in the agreement. Nevertheless, the suit was filed after lapse of 7 years. And though such a contention is raised by the defendant, the suit has been allowed. Full stop. Next para. Consequently, we hereby direct the parties to maintain status quo in respect of the possession of the property in question. Consequently, there shall be an ad interim order of stay of the impugned judgment in invoice number 300 of 2023 till the next date of hearing. And ಅಂತ ಹಾಕೊಂಡು ಇದನ್ನ ಹಾಕೊಂಡು
Obliged.
Yes.
Seal number 4, Mahesh Patil.
Respondent number 3 in this case, man. But matter, my lord, for the appellant, my lord, is an, my lord,
Yes.
contractual employee, my lord. Is a contractual employee. My lord, he has been terminated, my lord, without there being any notice. Lord, on the ground of, my lord, misconduct. My lord, the order of the, my lord, learned single judge, my lord, is at page 9.
Where is the impugned order?
My lord, at page 9.
Yes. Yes.
For the recent, my lord, decision of, Lord, the Honorable Supreme Court, my lord, may I, my lord, pass on?
Yes.
My lord,
Yes.
page 9, my lord. Page 9,
Yes.
my lord, para 20.
Hmm.
Lord, in the light of the above facts and discussion, you are of the opinion that the order dated 31/2016 terminating the services of the respondent is bad in law and cannot be sustained. It has rightly been set aside, though on a different ground, that the respondent is a permanent employee
You have
having.
to point out that the facts are same.
Yes,
the
my lord.
Situation is same.
Yes, my lord.
Where is it?
Para 20, my lord.
Ah.
A respondent is a permanent employee having been appointed on compensate basis. The appoint. Para 20.
You are not appointed here on contractual basis, sir.
Yes, my lord,
You are totally misled. That is what the learned single judge has held. You were in contract with a agency,
agencies.
which was given the right to send a employee.
Yes, my lord.
There was no privity of contract between you and this panchayat.
Panchayat.
You are only a contractual employee of the agency.
Yes, my lord. In terms.
So you'll have to point out to such a situation.
My lord, here, I could say, my lord, that, my lord, once, my lord, even, my lord, when I'm with the, my lord, the panchayat, my lord, when I'm, my lord, terminated, my lord, based on, my lord, on a stigmatic, my lord, order.
AGA, ಆಯ್ತಾ ನೋಟಿಸ್ ಆಗಿದ್ಯಾ? Learned AGA takes notice for respondent number 1. ಆಗಿದ್ಯಾ?
ಆಗಿದೆ ಮೈಲ.
ಆಗಿದ್ಯಾ?
Yes,
ಹಾ.
on total.
ಆಗಿದ್ಯಾ?
ಆಗಿದೆ ಮೈಲ, both.
I had sought for, my lord, interim order, my lord.
Yes, yes.
Here, my lord. There was an, my lord, interim order, my lord, with the learned single judge, but it did not come to my aid. My lord, till the disposal, my lord,
If you want to say something, we'll say. It will be a problem for you for consideration of the matter also. What do you want?
my lord, in the meanwhile, my lord, I will try to find out, my lord, any, my lord, decisions.
I may be permitted to file wakalat including
ಹಾಕಿಲ್ವಾ?
Akila. I am directed to take notice.
ಮತ್ತೆ ಡೈರೆಕ್ಟ್ ಅಂದ್ರೆ ಮತ್ತೆ ಇಲ್ಲ ಟು ಫೈಲ್ ವಕಾಲತ್ then.
Yes, for the first time it is
Speech
appearing.
time is granted to learned counsel Shri Arun Kumar Amargundappa to file wakalat on behalf of
3 and 4.
response number 3 and we are not impressed with the submission of the learned counsel for the appellant for interim relief. Full stop. At this juncture, learned counsel for the appellant submits that the matter may be listed in B group. Yes.
Great.
Number 5, Muhammad Abdul Karam.
Insurance company appeal your lord. Diabetes question, he was rider of the two-wheeler, not covered.
Huh?
Insurance company appeal, new matter. There is no delay, stay may kindly.
No delay. So issue notice, huh? To all the respondents.
All the rest,
Issue notice to all the respondents.
stay may kindly.
Already liability question ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
He was right, two-wheeler. Deceased was a rider of two-wheeler. He claimed to be a pillion rider and got the award passed. As per exhibits P3 and P6 clearly shows that he fell from the bike while negotiating a speed breaker.
To notice to all the respondents. Full stop. In the meanwhile, there shall be an ad interim order of stay of the impugned judgment and award passed in MVC 600 of 2020 on the file of the MACT 6, Vijayapura till the next date of hearing, subject to the appellant depositing 50% of the award amount before the tribunal, within a period of 6 weeks from today.
Before the High Court, if it is liability is question.
No.
Not to be.
Yes.
Serial number 6, Preeti Patil.
I am appearing for respondent K-Waiter.
Yes, my insurance company challenge liability and about Contempt, my lord.
Huh?
Two vehicles involved in the rash and negligence of the own disease, my lord, and in this time of accident, my lord, he was the suspension of work, my lord. And he fraud and he take a bail of received a bail. And he fully entire about 71,000 is taken the tribunal, my lord. That's the higher, sir.
Learned counsel Shri Baswaraj Armat has entered appearance for
K-Waiter.
response number 1 and
1 and 2, my lord.
Respondent number
1 and issue notice to
Sir, respond number 3, respond.
If Malad's permit, I make in the submission Malad.
learned counsel copy ಬಂದಿದೆಯಾ ನಿಮ್ಗೆ?
Copy ಕೊಟ್ಟಿದ್ದಾರೆ. Malad here, the is a submission before the court Malad against his own appeal Malad. There is no question of liability is not questioned before this court Malad. Only they're looking into the Malad appeal memo averment. They are only challenging the Malad quantum on the ground that Malad deceased was a bank employee Malad. On that month, ಅದು ಒಂದೇ ತಿಂಗಳು ಫೆಬ್ರವರಿ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ 71,000 ಇದೆ ಒಂದು ಇವ್ರು ಹಾಜರು ಮಾಡಿದ ಮಾರ್ಚ್. He was under suspension on the point of 2-3 members are representing misappropriation of fund. That is not at all ended with Malad. The honorable court Malad have granted looking into the all documents. I am not involved in the case. Anticipatory bail has been granted Malad. Appropriation of misap fund ಕೊಡೋದೇ ಇಲ್ಲ anticipatory bail. ನೋಡ್ಬಿಟ್ಟು on the face of record, I have granted interim bail. So I have not done any committed. So that should not be, they have to be questioned before the court that Malad during suspension he wasn't getting this one. ಈ ತರ ಬರೋದೇ ಇಲ್ಲ. Their submission is against their own appeal Malad.
What do you want now?
The quantum challenge.
Quantum liability, middle of the road,
Quantum
this is
ಅವ್ರು
first
ಏನೋ
applicable ಇದೆ, sir, middle of the road of
Quantum challenge
rash and negligence ಅಂತ.
liability
Even
ಅಲ್ಲ.
curfew, that time is
So
curfew,
if-
well,
if
night
this
time, madam.
This honorable court is in a granted issue, madam.
Phone liability and both contempt, first ಇದೆ sir.
50% amanda.
ಎಷ್ಟು grant ಆಗಿದೆ?
63 lakhs ಇದೆ.
63
Yes, my lord.
There shall be an interim order of stay of the impugned judgment and award in MVC 200 of 2020 on the file of the second additional district and session judge and MACT, Raichur, subject to the appellant depositing 50% of the award amount before the tribunal, within a period of 6 weeks from today. Full stop. Next para. The respondent claimants are permitted to withdraw 50% of the said amount that would be deposited by the tribunal before the deposited by the appellant before the tribunal, which shall be subject to the final outcome of this appeal.
Much.
CL number 7, Bapu Goda, Siddhappa.
Before the appellant notes the appellant is being agreed by the order passed by the trial court notes the appellant has filed the application under order 13(1)(a) of the Hindu Marriage Act notes. The court below is considering 13(1)(b) notes, but it is totally. I'll produce the copy of the appeal memo notes in the claim petition copy.
Petition for divorce has been
Yes,
dismissed.
dismissed notes.
Issue notice to the.
Yes, ma'am.
Matters, CL number 8, Annaraya M. Patil.
My lord, as per honorable single bench order, page number 18, operative portion of the order, my lord. The second respondent is directed to continue the service of the petitioner, but second part, page number 19, wages, 2 months wages not given by the respondent authority to the complainant. So order is partly
Learned.
complied.
Government advocate takes notice for respond number 1. ಏನ್ರಿ, you have not included them by name. It's a contempt petition.
Second respondent, Putro GT.
Huh?
Putro GT.
ಅದೇನದು ಬೈ ಪುತ್ರ GT ಅಂದ್ರೆ?
ವೈ ಎಲ್ಲ ಮಾಡಲಾಡ ಪುತ್ರ GT ಅಷ್ಟೇ ಹೊಡೆದಕ್ಕೆ ಪುತ್ರ
The
GT.
description itself should be the name of the person. You have again shown it by the office.
I will make it correction. ಪುತ್ರ
ಬೈ ಪುತ್ರ ಅದ್ ಹೆಂಗಾಗುತ್ತೆ?
ವೈ ಎಲ್ಲ ಮಾಡಲಾಡ ಬರೀ ಪುತ್ರ GT ಇದೆ.
ಹೆಂಗಾಗುತ್ತೆ?
ಫಸ್ಟಿಗೆನೆ ಹೆಸರು ಬರ್ಬೇಕು.
ಫಸ್ಟಿಗೆ ಬರ್
ಹಾ. Learned the counsel for the complaint is directed to serve copies of the petition along with annexures on the learned government advocate. Full stop. Next para. At the oral request made by the learned counsel for the complainant, the description of response number 2 and 3 is permitted to be amended, showing the name of the officer. Full stop. Next para. Issue notice to response number 2 and 3. Please correct it. Returnable by second week date
14th of January.
14th of January 2025.
14th Raja.
14th ಬೇಡ.
13th already. 14th ಇರಲ್ಲ, mostly 15th ಇರಲ್ಲ. ಸಂಕ್ರಾಂತಿ ಇವಾಗೆಲ್ಲ 15th ಇರುತ್ತೆ. Anyway, 13th is already.
Calendar ಬಂದು
16th ಕೊಡ್ಬೋದು. ರಜೆ ಐತೆ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ಡೇಟ್
13th ರಜಾ ಇದೆಯಾ?
ಅಲ್ಲ ಅವತ್ತಿನ ದಿವಸ 16th ಡೇಟ್ ಕೊಡ್ಬೋದು.
ಹಾ?
16th ಇವ್ ವಾಟ್ಸಪ್ ಅದರ್ವೈಸ್ ಬಿಫೋರ್ ಫಸ್ಟ್ ವೀಕ್ 9th 10th ಆದ್ರೂ ಕೊಡ್ಬೋದು.
10th of January.
ಪ್ಲೀಸ್.
Seal number 9, Sanjan Baswa, B Patil.
Appearing for the petition, this matter, my lords.
Yes.
This is a matter, my lords, wherein the petitioners, both of them being veterinary doctors, they were sanctioned 2 loans of 73 lakhs and 74 lakhs by the respondent bank. For one for dairy farming, one for sheep rearing. And in 2018, the loans were renewed as per annexure A, my lords. Thereafter, what happened was that when the amounts were not disbursed and they were transferred to some other accounts, which are their criminal proceedings are pending. Subsequently, the loan could not be repaid because the loans were not sanctioned, granted, disbursed only. They filed a OA, my lords. In the OA, the paper book is not served upon me. Without paper book, I can't file the return statement. I was treated ex parte, and the decree was passed for 1.81 crores by the Honorable DRT1 Bangalore. Thereafter, challenging that one, I filed an appeal before the DRAT Chennai matters.
Yes.
Therein, 50% of the amount had to be deposited. The amount decree is 1.81 crores, my lords. And I don't have the money to pay also. I filed a waiver application, which was rejected. I am only praying only one thing, my lords, to reduce it to 25%. That's all, my lords. I am not praying for anything.
That is not within the powers of this court.
No, many matters it has been done, my lords. That is
No,
why I am asking not for waiver. I am
No,
only
sir.
asking for reduction. That's all, only,
No, sir.
because 23rd I had to pay 90 lakhs. Otherwise, my appeal itself gets dismissed. Although I have a very good case on merits. That's why I am asking only for that small indulgence. ಇಲ್ಲ ಬೇರೆ ಕಡೆ ಎಲ್ಲ ಮೆಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ಎಲ್ಲ ಕಡೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. 25%. I am not asking because under the Surface Act it can be reduced, it can be waived also by the Honorable DRAT. But I am not asking for the waiver also. I am asking only for reduction from 50%. Lordship can see at page number 63.
Notice to the respondent. Yes.
No, my lords, because the 23rd I had to pay the last date for payment, my lords.
This objection for first time, CL number 1, CL number 10.
Yes, I appear for the appellant, lords.
Yes.
Lords, there are only 2-3 office objection, lords. There is urgency in the matter. May I request to lordship to take up for admission?
Huh?
Lords, only 3 objections are raised, my lords, regarding legibility of papers, my lords. Lords, there is urgency in the matter. May I request to lordship to take up admission?
Office objections,
Lords,
not 3.
the others, I am told that, lords, the others were complied.
Annexures. Correction. Yes.
Notes. Please notes. The appellant corporation notes the respondent 1 to 19 were terminated in the year 1988, which results in filing of an industrial dispute. My lord. After 3 rounds of litigation, my lords, the corporation as well respondent, my lords, they settled the matter. May I request your lordship to see the volume 2, my lords. Page 404.
404.
4 minutes. Please notes. May I read the order sheet, my lords? With the assistance of both side counsels and conciliators, both parties have settled the matter for rupees 15 lakhs, and accordingly the respondent corporation has paid the check to the petitioner for 15 lakhs before the Lok Adalat. The compromise entered by the parties is not against the public policy, hence joint memo filed by both the parties hereby accepted, petition closed as settled before the Lok Adalat. May I request your lordship to see the joint memo, my lords, filed by
Next early.
lords. Again, after my lords, 1 year, my lords, again the respondent files an application under section 33C2 of the Industrial Dispute Act. Lords, again there is a settlement between the corporation and the respondent. Lords, my submission is, my lords, earlier there was a settlement which is a full and final settlement. Lords, by mistake, corporation employees take parts in the settlement. My lords, the corporation commissioner has wrote a letter to the government to take appropriate action against those officers. My lords. Lords, once settlement is done, my lords, there is no scope for the respondent to reopen it again, my lords. Lords, again, that
Lordship. Basically, my lord, it is intra-court appeal, and that apart, my lord.
Which is the impugned order?
Lords,
Impugned- may I
impugned
submit, my lord?
orders are Lok Adalat settlements, my lords.
Dalre.
Single judge order.
The writ appeal, isn't it?
Please note, writ appeal.
Which is the order of the learned single judge?
Please note, in the first.
That is
volume.
at ink page 31, my lord.
Volume 1, my lords.
31.
Please.
31. Operative portion is at ink page 54, my lords.
Para 34 is relevant.
34.
Please notes, page 51. May I read, my lords?
Ah,
It is to be stated here that workmen were entitled for not only reinstatement but also back wages from 1/1/1986 till the date of reinstatement or a death or a retirement of a workman. In a proceedings which related to the claims for back wages that had been initiated under the Payment of Wages Act, the corporation is now trying to contend that merely satisfying the sums payable under award of reinstatement and full back wages, their liability stands extinguished. If this argument of the corporation is to be accepted, it would amount to modifying the award of the labor code to one of just payment of back wages till the date of application filed under the Payment of Act. This obviously impermissible as an award of reinstatement with full back wages, which is specified to be paid till the date of reinstatement or retirement or death, would necessarily mean that the corporation would have to pay the entire back wages that fall due till the workman was either reinstated or died or retired. It is for
where is that joint memo?
joint memo in volume 2, my lords.
Ah,
Volume 2. At page 7, the please. 524 minutes.
524.
4. One of the joint memo.
Yes.
Please notes that the top noted case has been filed by the petitioners seeking recovery of a wages awarded in so and so by the Honorable Principal Senior Civil Judge and CJM Vijaypura, wide its order dated 15/7/2010, in which the wages of the petitioner had been claimed with effect from October 1988 to April 2005. Now, as per the compromise talks taken place on 10/1/2019 before this honorable court, the respondent one is paying a sum of rupees 15 lakhs through check bearing number so and so, UCO Bank, Vijaypura. The said amount is being paid towards full and final settlement of amount awarded in respect of criminals so and so. This is the joint memo. And kindly see notes the
Full and
application-
final settlement of the amount.
full and final settlement.
Ah,
Settle amount awarded in respect of so and so. Why the confusion is there, my lords? Earlier, there was a labor court award. Notes, instead of taking labor court award in execution under the provisions of Industrial Dispute Act, my lords, the workman files an application under Payment of Wages Act under Section 15, my lords. That creates a confusion. Notes, now the learned single judge held that, my lords, there is an award against the corporation and I am bound to, my lords, to pay all the back wages which is awarded by the labor court, my lords. Kindly see the impugned order, wherein, my lords, the learned single judge held that if the corporation argument is accepted, it amounts to modifying an award which is passed, my lords.
what is the law on the settlement between the parties?
No, my lord, settlement, it is final, my lord.
You have settled.
No, my lord,
And
I am not disputing.
Yes.
Settlement is there, but it was only in respect of the criminal miscellaneous petition which was pending as on that date. Your lordship may kindly peruse the joint memo itself. It says the said amount is being paid towards full and final settlement amount awarded in miscellaneous number 22 of 2006 only. Subsequent amount that we did not claim, my lord.
Huh?
The amount which was due as on the date of 2006, that was filed before the criminal miscellaneous petition, my lord, that is 22 of 2006. They agreed for settlement in respect of the amount which was.
Where is that petition? Copy of the memorandum of petition?
That is in the first volume, my lords. The
Yes, criminal miscellaneous number 22.
Ban.
petition copy in Hakila. So may 20,
And your lordship may
page
kindly-
187 minutes.
Hmm?
Page 187.
Then
Volume 1, page 187.
187.
187, volume 1. This is the criminal miscellaneous petition filed under section 15(2) of the Payment of Wages Act.
Second joint. number.
They claim wages under section 15(2). After concluding of these proceedings, my lords, they file an execution under section 15(5) of the Payment of Wages Act. Idರಲ್ಲಿ next page ಅಲ್ಲಿ 190 ಅಲ್ಲಿ they say it's the brief facts.
Illegally deducted amount to an extent of 6,31,895 with 18% interest accrued and the amount accruable till the date of disposal of the petition. What is this amount that has been deducted?
Hello, my lord, that was not,
No,
may I submit? my
no
lord?
That
deduction.
is your prayer.
No, I will submit. The award was passed by the labor court.
Yes.
That was taken in a writ petition. They suffered. Writ appeal, they suffered. Even writ SLP also,
SLP also
they suffered. Mel.
Yes.
We were entitled for the arrears of wages.
Yes.
And insofar as arrears of wages, as on the date of 2006, what were the arrears? We filed 22 of 2006. That was settled. Miscellaneous number 22 of 2006, my lord. That was before the labor, that is CJ. That was settled only insofar as 2006 is concerned. Thereafter, for remaining amount, again we have filed another the execution petition, my lord. Your lordship may kindly, there also they settle the matter. There also they settle the matter as per ink page, annexure 13, my lord, ink page 742. Your lordship may kindly. Against that settlement, they prefer the writ petition and that came to be dismissed. Again, settlement, one more settlement was there and they were party and they have submitted. Your lordship may kindly have a glance on 742, annexure N13, my lord.
Second one. Volume number.
Second volume,
742.
first,
Second one.
second volume, my lord,
Yes.
Please.
page 742. That was second, subsequent for
Arrears.
remaining arrears, man.
And as well as difference of wages
Ah,
to the tune of 17,31,000.
yes, sir.
Along with interest.
One petition I'm,
The date of disposal of writ appeal till date of realization. Now, after due negotiation in parties, respondent number one, City Corporation Vijayapura has agreed to pay sum of rupees 17,31,000 with interest at 9%. Instead of, only difference is instead of 18%, you agreed for 9%.
9%.
Instead of 18%.
as against that settlement, my lord, they approached the learned single judge. That is the issue involved.
How can you file?
They agreed.
Lords, my submission, there was earlier a settlement, my lords. The joint memo says there is a full and final settlement.
Asked you to file this joint memo.
Lords, actually, my lords, it's very unfortunate on the part of corporation employees, my lords, they did not objected it. Lords, therefore, my lords, the commissioner made a complaint against those employees, my lords, to the state government to take appropriate action against those persons, my lords.
Your
Lords,
lordship may
even
kindly,
if we calculate
Original award
award, my lords, in the first volume, my lord.
ಅಥವಾ ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ ಏನಾದ್ರು ಹೇಳಿದಾರಾ?
Yes, my lord.
ರಿಟ್ ಅಪೀಲ್.
Yes, ma'am.
Please show that.
Please. 140, my lords, the in
Page
the first
140.
140 ಅಲ್ಲಿ ಅದು ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಆಗಿರೋದು.
Writ appeal. 100.
Operative portion at 146.
Concealment.
ಇದು ಲೇಬರ್ ಕೋರ್ಟ್
ಹೌದು, ಆಫ್ಟರ್ ರಿಮೈಂಡ್.
ಅಲ್ಲ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿದೆಯಾ?
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ
Wherein the
Please.
corporation itself has considered that, my lord,
page
paying amount.
170, page 170, annexure E1.
ಹಾ.
E1. Para 4 ಅಲ್ಲಿದೆ.
Yes.
Page. No ground is made out by the appellant to take a view different from a view adopted by Leonard single judge after elaborate discussion of the arguments. Therefore, the learned counsel for the respondent was requested to submit a memo indicating the date of retirement of each of the respondent concerned. The appellant has agreed to pay to the employees concerned the total amounts of back wages till the date of their retirement. As per the cases in which the workman respondent concerned has not reached the date of retirement, he is required to be reinstated with full
But-
back wages.
146 ಹೋಗೋಣ.
Please, notes. The operative portion minutes, claim statement in KID 25 and 28
Are
of
ordered to be reinstated with full back wages from
From-
1/1/1986
till their date of reinstatement.
till their date of reinstatement. All these claimants would be restored
To
to
same state
same status
as on the
as on the date of their termination. Further,
Yeah.
these awards will not preclude the respondent municipality from taking action in accordance with section 25
F.
of the act.
Please,
ಏನು section 25F?
That is Industrial Disputes Act.
Industrial
Illegal
dispute.
retrenchment.
Huh?
retrenchment,
Against retrenchment.
retrenchment.
Municipality is not precluded.
Allah, sir, they can take action under section 25F of Industrial Disputes Act. That
Okay.
is giving notice and taking permission from the government, etc. my lord. That is the procedure which is required to be adopted for retrenchment, my lord.
Already.
And that,
Legal heirs of claimants in KID number so and so are entitled to full back wages from 1/1/1986 to till date of death of
Reinstatement.
'25, that is condition precedent for retrenching any employee, my lord.
so they were permitted to do it afresh
Yes, yes, they did
by
not do that.
following the
also.
due procedure.
Yes.
Corporation did not do it. notes.
Yes. What happened? You filed a criminal miscellaneous
May,
No,
may,
that, execution petition I have filed, my lord,
before.
before the CJM. There, they settled the matter as per their own memo, joint memo. It was only in respect of the total and amount, my lord. I agreed for less amount. That was settled only insofar as the amount pending as on 2006. For subsequent amount, my lord, I have filed another EP. There they agreed, they filed the joint memo. As per the joint memo, when I pressed for execution, they prefer the writ petition. Your lordship may kindly have a glance.
Where is your execution petition? Where is your execution
But-
petition?
Page 778, my lords, in second volume.
778.
Second volume.
Entitled to get a sum of rupees 10,34,184.
It is in respect of one
No.
petitioner, one of the petitioners.
There are 4.
13 miles.
13,
13
altogether 13 employees are.
Already.
Ah.
In page number 735, 778,
It is pertaining to one of the.
EP is filed by 4 persons.
Oh, yes, yes.
LRC.
LRC.
LRC, the ಒಬ್ರೇ work
LRs.
LRC.
ಏನ ಬೇರೆ ಬೇರೆ ಹೆಸರುಗಳು ಇದೆಯಲ್ರಿ ಏನ್ ಎಲ್ಲಾರ್ಸ್ ಅಂತ ಹೇಳ್ತಾ ಇದೀರ ನೀವು?
ಅಲ್ಲ ಸರ್, ಎಲ್ಲ
LRs,
ಹೆಣ್ಮಕ್ಳು ಸರ್.
ನೋಡಿ ಸ್ವಲ್ಪ ಹೆಸರು ನೋಡಿ.
LRs of original workman.
ವೈಫ್ ಆಫ್ ಅಂತ ಹಾಕೊಂಡಿದಾರ. ಕೆಳಗಡೆ
ಮಗಳು, ಮಕ್ಕಳು, ವೈಫ್ ಇದೆ ಸರ್, ಅವರು ಮ್ಯಾರಿಡ್
ಬಸವರಾಜ
ಡಾಟರ್ಸ್.
ಕಾಂತಪ್ಪ ಗೋಲ್ಡ್.
ಅವ್ರ workman, Basaraj Kantappa Gold is the workman.
So only one EP.
One
Are we concerned only with one
My lord, 13,
all 13 EPs.
13 employees, my lord.
in the writ petition?
Please, ma'am.
In the writ petition. So only one EP was filed. In
ಇಲ್ಲ,
respect
my lord.
of
Separate
13
EPs.
separate EPs.
ಎಲ್ಲ
were
ಮಾಡಿದ್ದೀರಾ?
House.
All were filed on the same date?
Yes, my lord.
ಹೆಚ್ಚು ಕಡಿಮೆ.
ಹೆಚ್ಚು ಕಡಿಮೆ.
Your lordship may kindly have it.
Ah.
I beg your pardon.
Yes.
Ink page of 54 of impugned order, my lord. That is writ appeal, my lord. Your lordship,
See, what happened in the execution case?
execution, they settle the matter.
How,
Ade.
by which order?
Present execution settle agila. We
May
called
I,
it.
my lord?
ಇಲ್ಲ, ಇಲ್ಲ. Execution
My humble
was-
submission is that, my lord, initially
What happened with this EP?
EP was came to be settled
ಅದು
wherein,
By which one, by which order or which joint memo? You please show.
please. The earlier joint memo is at
Latest.
latest.
Ah,
Earlier joint memo, execution petition which was came to be settled is at
ಈ force ಇದ್ರಲ್ಲ.
ಅದೇ the application of
Second one. ಇಲ್ಲಿ ಅದಲ್ಲ, ಇದೆಯಲ್ಲ.
is second subsequent application.
One of the joint memos, my lord, subsequent joint memo. Annexure 21, your lordship.
No, the EP which was came to be read by other side is presently pending, my lord. It is still pending.
Then what is that criminal?
Criminal misdemeanor. In that petition, my lord, the wages from 1986 to 2006 was
Six.
sought.
Huh?
From wages from 1986 to 2006 was sought.
How can you file a separate criminal miscellaneous petition only for a portion of that?
No, my lord, that was due as on the date of 2006.
Sir,
Yes,
the award passed by the labor court
Yes, my lord.
is that you are entitled for back wages
yes, my lord.
from 1/1/1986
Yes.
till the date of realization.
How, sir?
You filed an EP.
How, sir?
Thereafter, how could you file a criminal miscellaneous petition? For what purpose?
No, 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 my lord. I have filed a criminal miscellaneous petition for the pending of the due amount as on the date of
How
that
could you
petition.
file?
No, my lord, I cannot to go on waiting. As on that date,
Ah.
2006 ಅಲ್ಲಿ ಅವತ್ತಿನ ದಿವಸ ಎಷ್ಟು ಡ್ಯೂ ಅಮೌಂಟ್ ಇತ್ತಲ್ಲ my lord. For that I have claimed.
There are two execution petitions.
Yes,
you
my
filed
lord.
then,
Yes, my lord.
Yes.
Which is not permissible.
Allala, sir, your lordship, kindly. As on the date of 2006, my lord, execution petition, what was due on that day, I have filed it. For
You
subsequent.
have filed execution petition also.
No, my
Pardon, no. For, as per the division bench order and the award, my lord, I am entitled for full back wages till realization.
Yes.
Or till I am superannuated, retired.
Yes.
Or action is taken on 25F.
How can there be two execution petitions?
That is,
One as execution petition, another one as a criminal petition
sir.
for the same.
No, my lord.
Same period.
What I'm trying to persuade your lordship is, as on the date of 2006, what was due to me, I have filed it. They came forward for settlement.
Sir, you filed a EP in the year 2021.
This is
ಅಲ್ಲ
for
sir, that is
subsequent. period.
subsequent. ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Subsequent for,
You filed a criminal miscellaneous petition.
yes, my lord.
Huh?
That was settled earlier settlement. My friend is harping upon that, my lord. That was settled for the lesser amount since they towards full and settlement only insofar as the amount which was due in criminal miscellaneous 22 of 2006.
No, sir.
Your lordship.
No.
Your lordship.
There is something that has happened here.
No, my lord, your.
Why they are so vociferously
No. Your lordship may kindly peruse the.
purple.
Allala, sir, your lordship, kindly, my lord, your lordship may kindly. Allala, sir, your lordship, I may kindly be.
We will hear you, sir. We
Allala,
are
sir.
not disposing of the matter.
Allala, sir, your lordship may kindly have a glance. What I am praying your lordship is have a glance on the
Nitesh Padiyal
observation made by
has entered appearance for respond number 1.
all. ಒಬ್ಬರದಕ್ಕೆ ವೇಟ. Your lordship may kindly have a glance on ink page 54, my lord. Kindly.
For all the respondents.
All the respondents.
Has filed a caveat petition for respond number 1. Full stop. However, learned counsel submits that he will undertake to file wakalat for all the respondents. Next para. Learned counsel for the appellant, City Corporation, Vijayapura, submits that although a criminal miscellaneous petition was filed by the respondents herein seeking payment of arrears of wages in terms of the award passed by the labor court. And a joint memo was therein filed and it was admitted that the amount paid by the corporation will be for full and final settlement of the claim made in the criminal miscellaneous petition.
Only antides, sir.
Ade criminal miscellaneous petition.
Word only is used.
Thereafter, once again, an execution petition was filed by the respondents before the labor court.
33C2.
Full stop.
For remaining amount I have filed.
Subsequent period, my lord.
Huh?
This criminal miscellaneous was
It is also admitted that during the course of the execution proceedings, at the behest of one of the officers of the corporation, a joint memo was filed admitting the liability and undertaking to pay the entire amount with the interest at the rate of 9%, instead of 18%, as awarded by the labor court, it was later found that some of the officers of the corporation were hand in glove with the respondents and double payment was sought to be made to them. Full stop. It is thereafter that the writ petition was filed by the appellant and the learned single judge has not considered these aspects of the matter. Full stop. It is submitted. The learned single judge is of the opinion that the original award passed by the labor court was not only in respect of payment of arrears of back wages, but also for reinstatement of the respondents into service. Full stop. Learned counsel submits that if the joint memo filed at the behest of some of the officers of the corporation is permitted to be executed, it will be an act illegal and the respondents will be permitted to take advantage of such an illegal joint memo filed by some of the officers against whom action is already initiated by the corporation. Full stop. Next para. Matter requires consideration.
No, may I make a submission, my lord?
Accordingly, what is that you want now?
It's Leonard single judge order stay.
Adan stay ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ?
It's EP nil.
Huh?
Intra court appeal nagutte, sir. That is also not.
ಅಲ್ಲಿ EP warrant
Huh?
arrest ಇದು ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಲ್ಲ EP ಅಲ್ಲಿ.
EPL.
EPL.
So you are seeking stay of the order
Stay.
passed in the EP, not the order of the learned single judge.
Leonard single judge order stay ಕೇಳಿದ್ರು.
Huh?
Leonard single judge order stay ಕೇಳಿದ್ರು.
ಅದನ್ನ ಸ್ಟೇ ಕೇಳಿದ್ರೆ ಏನ್ರಿ ಸರ್ ಪ್ರಯೋಜನ? ಅದು what should happen to the original order? What was your interim prayer before the learned single judge?
Let's EP minutes,
ಮತ್ತೆ
please.
May I make a submission? Your lordship
We
kindly.
will consider, sir.
Hello, sir.
Please wait. Matter is,
No, no,
required to
I
be
am, no,
considered.
no, I am
We
not
will
disputing, my
consider.
lord. What I am
See, if
trying
there
to.
is some truth in what they are trying
No,
to
no, my
say,
lord, I leave
we'll
to
have
the
to
court.
look into it.
1 minute, my lord. 1 minute time may kindly be given. I will.
It is a fact that you filed a joint memo agreeing to receive that amount as full and final settlement.
In respect of,
You could not have firstly filed such a criminal miscellaneous petition
Ah.
only for part of the amount.
ಅದೇ sir.
ಅದೇ problem ಆಗಿರೋದು.
No problem is this, sir.
That is
As
the
of the
problem.
date,
But see, let us consider.
Allah, sir, your lordship may kindly have a glance. My prayer to have a glance, my lord. Your lordship may kindly.
There shall be an interim order of stay
Allah.
of the impugned order. Passed in WP number 202284 of 2021 and.
Please.
ಯಾವ್ದು?
EP, my lords.
Huh?
Annexure P series, my lords. EP,
And all further proceedings,
all for,
all further proceedings in the execution cases.
please.
ಎಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದೀರಾ?
Annexure P
ನಿಮ್ಮ
execution.
ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ ಫಾರ್ ಸ್ಟೇ?
ಬರೀ ಅದಿಲ್ಲ, ನೆಟ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಅಷ್ಟೇ ಕೇಳಿರೋದು.
My humble prayer, my lord, your lordship may kindly have a glance on one page, which I am.
Should we not consider the matter on merits?
No, no, my lord, I am not disputing. What I am submitting is, your lordship may kindly have a glance on the page number 54. And what my learned friend is submitting, my lord, that officer has, it is the commissioner who is representing the corporation, he has signed it. Joint memo. Not officer, my lord, no action. has been
Execution case numbers ಎಲ್ಲಿದ್ದಾರೆ?
My lords, EP, second volume ಅಲ್ಲಿ,
There, what is your, ಇದರಲ್ಲಿ
page 768 in the standard.
page number 34 ಅಲ್ಲಿ ಇದೆ ನೋಡಮ್ಮ. 34, the order portion ಇನ ಮೇಲೆ, learned single judge order portion ಮೇಲ್ಗಡೆ, all the numbers are given. Page number 34, 35, 36. 34, 35, ಎರಡರಲ್ಲಿದೆ.
34.
Ah.
Obliged,
The next date of here.
obliged.
Yes.
Date may kindly given.
In the meanwhile, I will comply the office.
The question of jurisdiction
Intra.
regarding the intra-court appeal will also be considered before this court proceeds to hear the matter on merits.
Okay.
Yes.
ಅದೊಂದು ಸೆಂಟೆನ್ಸ್ ನೋಡಿದಿರ್ತಾವ ಆಮೇಲೆ.
Yes.
I leave it.
Obliged.
ಅದರಲ್ಲಿ ಕಾರ್ಪೊರೇಷನ್ ಕಮಿಷನರ್ himself has signed the joint memo. my lord. What my learned friend is submitting, it is
Sir,
contrary to factuals.
even if he has misunderstood it,
Then it's.
this is a occasion for the court to reconsider
No,
everything.
no,
We
I
will-
fully agree, my lord. What my friend is submitting, that some officials have, it is not some officials. It is the commissioner himself has
ತಪ್ಪು ಮಾಡಿರ್ಬೋದು.
ಮಾಡಿರ್ಬೋದು, sir.
So
But submission of my friend.
therefore, even if the commissioner has
Yes,
committed
yes,
a mistake, it is a matter to
yes.
be looked into.
Yes, yes, my lord. I am not disputing what my learned friend has submitted, the some officials. It is not some official, factually incorrect, my lord.
Hmm.
Commissioner himself, he has signed it.
ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
ಆಯ್ತು.
ಆಫೀಸರ್ಸ್ ಎಲ್ಲ ಏನ್ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ತಂದಿರ್ತಾರೆ, ಅದನ್ನ
ಆಯ್ತು,
ಸೈನ್
sign
ಮಾಡಿ
ಮಾಡಿ.
ಕಳಿಸ್ತಾರೆ.
ಆಯ್ತು.
So he may admit, yes, I have done a committed a mistake,
Ah.
isn't it? Should we not look into it?
He has not, Allah, sir.
At any rate, you will not be permitted to take double account of the.
How, sir?
amount.
I am
Right.
also fairly considering, not double amount.
We'll consider.
Please.
But the problem is, you filed a joint memo saying, all right, I will accept this as full and final settlement.
Other, sir.
That is the whole problem.
As on the date of the filing of that execution petition, my lord, not subsequent.
Yes.
I cannot be left without
Yes.
bread and butter, my lord. As on the date I was unemployed and I was out of service and I have filed the EP for that period. Even similar will be in the maintenance proceedings also, my lord.
Right.
For the arrears, they will be making application. Admitted amount they have deposited now.
CL number 11.
They have deposited.
Yes.
Obliged.
Number 11.
Date, one date may kindly give.
ಇನ್ನು ಯಾವಾಗ after vacation date ಕೊಡೋದು.
There
Yes.
is some urgency, that is why I moved them.
Yes.
My lord, this is the land reforms matter. The petitioner's appellant's husband, my lord, had filed a declaration under section 66 of the land reforms.
Huh?
My lord, the land tribunal passed an order holding that there is an excess land of 5 acres.
ಯಾವ್ದು serial number 12
Yes,
11.
ma'am. 11.
11, man.
11.
The land tribunal passed an order holding that there is an excess land. My lord.
ಅದರಲ್ಲಿ ಆ previous matter ಅಲ್ಲಿ in the meanwhile office objection shall be complied with. Yes.
The excess land of 5 acres was held to be excess, my lord, by the land tribunal.
Excess.
How the matter pertains to land reforms matter. The husband of the supplicant had filed a declaration under section 66 of the Land Reforms Act, my lord, showing his holdings and number of members in the family. The tribunal earlier had passed an order holding there is excess land. Against that, my lord, writ petition was filed before this honorable court, and this honorable court passed an order. Now the respondent herein,
What order?
my lord, remanding the matter to the land tribunal to decide the case. In that case, my lord, they had produced, the respondent herein had produced a judgmented decree passed after 1374, my lord. 1374, your lordship knows, it is the cutoff date. Our decree was passed subsequently. That is why the honorable single judge, my lord, passed an order that that cannot be looked into, and whatever the holding is there, the matter should be inquired, and matter was remanded. That finding was not challenged by the respondents herein. They, my lord, claims to the paternal, maternal aunt of this, the petty appellant herein. They are not concerned with the suit lands. My lord, subsequently what happened after the remand, the land tribunal passed an order holding that there is an excess land of 5 acres. Against that, my lord, they filed a writ petition, my lord. Instead of I filing the suit, my lord, they filed a, my lord, writ petition. And the honorable single judge passes an order that the decree obtained in 1982 should be implemented, though there is not a prayer in the writ petition. And that is why, my lord, that operative portion is wrong. If they have any, my lord, they have to file execution petition before the civil court. Kindly come to the operative portion.
To set aside the impugned judgment and
Their prayer is only to set aside the land tribunal order.
24.
Page number 35 is the writ petition copy. Their prayer is only to set aside the order of the land tribunal.
You are not a party to the writ petition.
My lord, I was a party. I mentioned, my lord, this decree can't be executed because,
You are a respondent, huh?
yes, my lord, I
Respondent
filed
of
objections.
4D.
Yes, my lord.
Huh.
I filed objections also, saying that if they are, my lord, that's not the prayer in the writ petition also. Now, the order passed by the honorable single judge, he passes an order, my lord, to implement that said decree. Kindly come to page number 28. At the most, my lord, he could have remanded the matter or could have held that there is no excess land. This was to avoid, my lord, ceiling limits. The decree was obtained by all the members. That is why the earlier writ petition, the court refused to accept this decree. I have produced that judgment also at page number, my lord, page number 67, passed by his lordship, my lord. Holding that the said decree cannot be looked into because it is passed after 1374. So this portion, my lord, I am aggrieved. Now cleverly what has the petitioners have done is, my lord, this decree which was obtained in 1982, your lordship knows the limitation under article 136 of the Limitation Act. The period is 12 years. The decree is obtained in the year 1981. The cutoff date is 1374. Mother is not allotted a share in this property, but even the court says, my lord, mother share should be given. Internal page 13 of the Honorable Single Judge order. my lord. And that too, it is my declaration, husband's declaration.
Five acres, 27 gutta
Yes, it was held access.
in the hands of Chennappa,
Channapam.
the person who filed.
That is the
declaration.
appellant's husband.
Huh?
Appellant's husband. He had filed a declaration. He filed a declaration under section 66 of the Land Reforms
So
Act.
you are the wife of
Yes, my lord.
Chennappa.
Yes, I am the wife. So they could not have challenged my lord, order passed by against me. If they had any right, my lord, let them go to file execution petition.
That was only 5 acres and 27
Yes, my lord. Yes,
guttas
yes, my lord.
from out of your share.
Your share, my lord. 52 acres was, my lord, my holding as per the declaration. Actually, this portion, my lord, I am aggrieved. And even otherwise, my lord, I could have surrendered, the land could have been distributed to land persons, landless persons. ಇದು ಮದರ್ಗೆ ಶೇರೇ ಕೊಟ್ಟಿಲ್ಲ ನಾವು ಯಾರು 4 ಮಂದಿ. How can the share be, my lord, mother share can be taken? And even as per Article 130,
This order also is in your favor only.
my lord, my favor only, but the operative portion,
That 5 acres and 27
my
guttas,
lord, actually, my lord, it
which
could have.
was declared excess.
Yes, my lord.
Now it has been
No.
set aside
No, it has been
and it
set.
will come back to you.
No, my lord, what I'm
Why
submitting.
are you agitating?
No, 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 why I'm agitating is this my lord, the last operative portion wherein this court has passed an order saying that as per the decree in the year 1981, you implement it. That is not a my lord, decree. That is why I'm before this.
Said that the parties would be governed by the judgment of decree.
Yes, my lord.
What did you do when that decree was passed?
My lord, they did not file execution petition. It was only to avoid the ceiling limits, my lord,
Mhm.
that the decree was. Well, your lordship knows, my lord, 1374 is the cutoff date. 1981 dagindu, they my lord, obtained a decree, produced it before the land tribunal. So, my lord, this order, my lord, my submission is this observation made by the court is wrong. Because Article 136 of the Limitation Act, if they want to execute the decree, it is
See,
only.
This is what happens. If you wanted to take advantage by.
My lord, they
doing
produce,
else, now it has come back.
they produce the decree.
ಏನ್ ಮಾಡಕ್
Ah.
ಏನು ಮಾಡಕ್
What I'm submitting is, my lord, the mutation next, my lord, order, my lord, operative portion.
You accepted the decree,
My
you
lord,
accepted the judgment and decree.
my lord, what I'm submitting is only to avoid the, my lord, the ceiling limits, it was done. What I'm submitting is, this observation should not have been done. There is no prayer in the writ petition also. If there is a prayer in the writ petition matter, he has other rights.
All right. Learned AGA takes notice for response number
9 to 11.
9 to 11.
Yes.
ಅದೇನ್ರಿ ಮಧ್ಯದಲ್ಲಿ ಆಗ್ತವ ತಗೊಂಡೋಗಿ ಸ್ಟೇಟ್ ಮತ್ತೆ ಇವ್ರನ್ನ.
My lord, because they were the petitioners in the earlier.
So
bill.
what? It's always the state that should come first as a respondent.
Yes.
Issue notice to the other respondents. The appellant is also permitted to serve copy of the appeal memo along with annexures on learned counsel Sri Mahantesh Patil, who appeared for
Petitioners.
the writ petitioners. Full stop. Next para. Learned counsel for the appellant submits that although there was no prayer in the writ petition seeking a declaration that the parties would be governed or would be bound by the judgment and decree passed in OS number 143 of 1981, such a declaration has been given by the learned single judge. Full stop. The appellant is aggrieved of only that portion of the
Yes.
order passed by the learned single judge. Full stop. Learned counsel would therefore submit that the consequential direction issued at serial number 6 in the operative portion should be stayed. Full stop. Next para. Accordingly, the directions issued by the learned single judge at serial number 6 in the operative portion shall remain stayed and shall not be operated
Yes.
till the next date of year.
I will comply the office
Next
objection.
para. In the meanwhile, office objections to be compared.
CL number 12.
My lord,
National Government Advocate.
during the course of day, we will comply. Officer has come, affidavit has to be changed, my lord.
Huh?
Serial number 12, my lord.
Huh.
Only one office objection regarding filing of affidavit, my lord. Attestation has not been made, my lord.
On the last occasion itself, he had submitted.
Now, today,
They are
office,
purposely, they are not complying with the office objections, keeping this alive
no, my
so that it will cause inconvenience to the other side.
my lord, today officer has came, he is swearing affidavit.
Yes, come.
Yes, man.
Huh?
Yes, man.
Which is the ಯಾವ್ದು ನೋಡ್ರಿ office objection ಬಾಕಿ ಇರೋದು.
All other office objection compliant, my lord. Earlier, oath commissioner, before oath commissioner affidavit has sworn, my lord. Attestation of annexure has not done. Oath commissioner period has completed, my lord.
Competent authority.
ಅಷ್ಟೇ ಅದು ಒಂದೇನಾ? Learned AGA submits that the officer
Yes, ma'am.
competent to swear
Yes, ma'am.
the affidavits is coming today.
Alright.
And the only office objection which remains to be complied will be complied during the course of the
Yes, my lord.
full stop. Release this matter on 20th, day after tomorrow.
Yes, my lord.
Order seal number 13, send number.
Appearing for the appellant in this matter, my lords. As per the orders, my client is present in the honorable court, my lords. She is present before your lordships.
The respondent's counsel.
See, but that day there was some technical problem. We were not able to hear you.
Yes, my lords, that was a technical problem. Suddenly it went off.
Now, we have asked the appellant who was present that day.
Yes, along with the daughter.
Ah,
This time your lordship said that daughter did not come, isn't it, my lords?
yes, yes, yes.
She is here, my lords. The appellant is here.
See, we were telling her that she has taken advantage of the daughter
Visitation rights.
visitation rights,
Yes, my lords.
and thereafter she continues to hold back the daughter. That would amount to
my lords.
contempt.
But they have not initiated anything, my lords.
Huh?
They have not initiated. We have challenged the GSW, which was
So
dismissed.
you want them to initiate contempt proceedings?
No, no, my lords. No, 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 no. Not like that.
So you
So
should-
welfare of the child is the most
you
important
should be
thing,
fair-
my
You
lords.
should be fair to the court. You cannot, we will not permit a party to take advantage of one of our orders and thereafter permit, continue to agitate the matter. So you'll have to accordingly advise your client.
Yes, my lords.
If there has to be some give and take.
Yes, my
Otherwise,
lords.
these family matters cannot be decided like this.
I know, my lords. They are all
Otherwise, you will
emotional.
direct the mother to give back the custody of the child to the father. Agreeable?
No, what happens? The welfare of the child is a must, my lords. In all these
ನೀವು
matters.
ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು ನಿಮ್ ಇಷ್ಟ ಬಂದಂಗ್ ಮಾಡ್ಕೊಂಡು ಇವಾಗ ಇಲ್ಲ ಮಗು ಹೋಗಕ್ಕೆ ತಯಾರಿಲ್ಲ ಯು ಕ್ಯಾನ್ ಆಸ್ಕರ್ ಅಂತ ಅಂದ್ಬಿಟ್ರೆ
Because she has already joined in Bangalore. She is.
ಅರ್ಥ ಆಯ್ತನಮ್ಮ ನಾವ್ ಹೇಳಿದ್ದು ಸ್ವಲ್ಪ ಕೂತ್ಕೊಂಡು ಸ್ವಲ್ಪ ಸಾವಧಾನವಾಗಿ ಯಾವ ರೀತಿ ಮ್ಯಾಟರ್ನ ಸೆಟಲ್ ಮಾಡ್ಬೇಕು ನೋಡಿ ಮಾಡಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಕಾನೂನು ರೀತಿಯಲ್ಲೇ ಮಾಡಿ ಅಂತಂದ್ರೆ ನಾವ್ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಡೈರೆಕ್ಟ್ ಮಾಡ್ತೀವಿ ಮಗುನ ತಂದೆ ಹತ್ರ ಕಳ್ಸ್ಕೊಡಿ ಅಂತ ಮಾಡ್ತೀರಾ ಏನಮ್ಮ ಅದಾಯ್ತಮ್ಮ ಮಗು ನಿಮ್ ಜೊತೆಗೆ ಇರ್ಲಿ ನಾವ್ ಇವಾಗ ಬೇಡ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ಮುಂದೆ ಬನ್ನಿ ಸ್ವಲ್ಪ ಮುಂದೆ ಬನ್ನಿ ನೀವು ತಪ್ಪು ಮಾಡಿದೀರಾ ಆದ್ರೆ ಹಂಗನ್ಬಿಟ್ಟು ನಾವು ಆಯ್ತು ನಿಮ್ಮ ಮಗುನ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ವಾಪಸ್ ಕೊಡಿ ಅಂತ ನಾವ್ ಹೇಳ್ತಾ ಇಲ್ಲ ಇಂಥ ಮ್ಯಾಟ್ರ್ಗಳಲ್ಲಿ ಸ್ವಲ್ಪ ಕೊಡೋದು ಬಿಡೋದು ಇದ್ದೇ ಇರುತ್ತೆ ನೀವು ಇಲ್ಲ ನಾನು ಕಾನೂನು ರೀತಿಯಲ್ಲೇ ಆಗ್ಬೇಕು ನನಗೆಲ್ಲ ಅಂತಂದ್ರೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ ಮಗುನ್ ಕಳ್ಸ್ಕೊಡಿ ಅಂತ ನೀವು ಒಪ್ಕೊಂಡು ಆಯ್ತು ನಾವು ಕೂತ್ಕೊಂಡು ಏನ್ ಸಾಧ್ಯ ನೋಡಿ ಸೆಟಲ್ ಮಾಡ್ತೀವಿ ನಾವು ಒಪ್ಕೊಂಡಂಗಿದ್ರೆ ಮ್ಯಾಟ್ರ್ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀವಿ ನೀವು ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ಗಳ ಜೊತೆ ಕೂತ್ಕೊಂಡು ನೋಡಿ ಏನ್ ಸಾಧ್ಯನೋ ಸೆಟಲ್ ಮಾಡಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಿ ಇಲ್ಲ ನಾನು ಕಾನೂನು ರೀತಿಯಲ್ಲೇ ಆಗ್ಬೇಕು ನಾನ್ ಮಾಡಿರೋ ಪಿಟಿಷನ್ ನನ್ ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ ಮಾಡ್ತೀವಿ ಮಗುನ್ ವಾಪಸ್ ಅಲ್ಲಿ ಕಳ್ಸ್ಕೊಡ್ಬೇಕು ಅಂತ ಒಪ್ಕೋತೀರಾ ಇಲ್ವಾ ಹಿಂಗೆ ಮಾಡಿ ಹಂಗೆ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ನಾವು ಏನ್ ಸಾಧ್ಯನೋ ಕೂತ್ಕೊಂಡು ಹೊಂದಾಣಿಕೆ ಮಾಡ್ಕೊಳ್ಳೋಕೆ ಸಾಧ್ಯ ಇದ್ರೆ ಯಾವ ತರ ಮಾಡಬೇಕು ಅಂತ ನೋಡಿ ಪ್ರಯತ್ನ ಮಾಡಿ ಒಂದು ಇತ್ಯರ್ಥಕ್ಕೆ ಬನ್ನಿ ಬೇಡಮ್ಮ ಬೇಡ ಅವ್ರ ಜೊತೆಗೆ ಇರಿ ಅಂತ ನಾವ್ ಹೇಳ್ತಾ ಇಲ್ಲ ಅವ್ರ ಡೈವೋರ್ಸ್ ಕೇಳ್ತಾ ಇದಾರ ಸೊ ಏನಾದ್ರೂ ಒಂದು ಆಗ್ಬೇಕಲ್ಲ. ಇಲ್ಲ ನೀವು ಕಾನೂನು ರೀತಿಯಲ್ಲೇ ಮಾಡಿ ಅಂತಂದ್ರೆ ನಾವ್ ಇದ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
My lord, may I make some submission, my lord? My lord, on 29th of May 2024, my lord, this honorable court was called the party, my lord. In the chamber, my lord, the conciliation was held, my lord. In the chamber, my lord,
Sir, we are not going to sit and now conciliate. Not possible. We don't have that much of time now.
Not no, my lord. In the 29th of May, my lord, the girl, my lord, she herself says, my lord, before lordship in the chamber, my lord, she intended to
Sir, by
make an
that
admission
time,
at Bangalore.
lot of time was lost.
Yes, ma'am.
The child being with the mother naturally will feel like that. But the question is, how could you do it contrary to the directions given by this court? Have you not taken advantage of it?
ಇಲ್ಲ don't just go on the same.
Amata?
But
Custody was given to you only during vacation period.
yes, ma'am.
Was it not your duty to send back the child?
Yes, ma'am.
Then
But ಅವಾಗ ಏನ ಸ್ವಾಮಿ ಚಿಂಬರ್ದಲ್ಲಿ
if ಏನಾರ see, your explanation is not going to help. So we are saying, please try and sit and try to resolve the matter.
please, ma'am.
Otherwise, we'll also have to take a strict view and immediately we will direct the child to be handed over to the father.
My lord, it may refer to mediation, my lord, or
ನೀವೇ ಮಾಡ್ರಿ, sit across the table, both of you advocates sit with them and try to see what best can be done.
please, ma'am.
We'll do something in the vacation, my lords. Definitely,
You should make
I'll
up your
take my
mind
lord's
first,
advice.
advocates.
Please, my lord.
May I make only one submission with your lordship's kind permission?
Yes,
If your lordship may kindly consider, if my learned friend Mr. Ramana also, my lords, is in Bangalore, whether the matter could be, my lords, referred to the Bangalore Mediation Center, because the girl is also in Bangalore, mother is also in Bangalore. Father will travel to Bangalore for the mediation. My lords will also be there. We'll try to, my lords, work out some solution.
okay, Andre, Bangalore.
Yes, my lords.
Representing.
After hearing the learned counsels on both the sides sometime, it has been suggested that the parties may be sent for mediation at Bangalore. Since the mother and daughter are presently in Bangalore and it will be convenient for the father to go to Bangalore instead of calling the mother and daughter to Kalaburagi. Full stop. Next para. We have also made some suggestions to the parties. Full stop. Learned counsels on both the sides are requested to place all these suggestions made by the court before the mediator and try and see how best the matter can be resolved. Full stop. Next para. The parties are directed to appear before the Bangalore Mediation Center on
the reopening day, 6th of, or even earlier, subject to the.
6th will be a very busy day. So,
ಬೇಡ ಈಗ ವೆಕೇಶನ್ ಟೈಮ್ ಅಲ್ಲಿ ಹೋಗ್ರಿ. ವೆಕೇಶನ್ ಟೈಮ್ ಅಲ್ಲಿ ಹೋಗಿ.
vacation, 3rd or 4th lordship may have it, my lords. 3rd or 4th of, 3rd, which one?
Trial court in Brazil.
First, second. 2nd or 3rd, my lords.
Court reopens on 2nd, Lord. 4th should be all right.
4th will be all right.
No, not about trial court. We are talking of the mediation center.
Mediation center.
Mediation center, I don't think there is a holiday.
No, it's open, my lords.
There is no vacation. So you can choose any of the dates in the next 2 weeks.
No, 4th, my lords.
No, 23rd.
4th January.
Monday, 23rd, Lord.
No, Monday I am not in station.
ಅದಾದ್ಮೇಲೆ ಆಗೋದಿಲ್ವೇನ್ರಿ?
27th, my lords.
You choose because you have to go to Bangalore.
31st, Lord. 31st. May I request 31st, Lord? Because during vacation I may be in and out of Bangalore. 31st December, subject to the court. I'm sorry.
31st, you want 31st?
Please, Lord, my request.
31st of December, 2024. Release this matter on 9th of, 9th of January. Office is directed to forward the records to the Bangalore Mediation Center forthwith.
Grateful.
Adjournment.
Seal number 14, Sanjeev Kumar Sipati.
Needful is done. I have paid the process.
Huh?
Needful is done.
Learned counsel for the appellants submits that steps have been taken for service of notice on respond number 3.
Yeah,
Stop. Office to verify and issue notice.
Lord, in this case, the suit for partition of the FDP warrant has been issued. FDP, Lord,
No,
only drawing up, my Lord, final decree. may be-
partition.
Yes, my Lord, suit for partition, it is a first appeal. Drawing up, my Lord, final decree maybe, my Lord.
Why you didn't get that kind of an order when the matter had come up for admission?
No, this honorable court has issued a notice. There is a delay in filing the appeal and hence, my Lord, notice was issued on the main appeal as well as the delay application.
Delay.
Delay ಮೇಲೆ issue notice ಆಗಿತ್ತು. Before that.
705 days.
Yes. Because the
Next para, the trial court is directed not to drop final decree without express orders of this court.
Seal number 15, Mahesh Patil.
Connected up,
Yes,
appeal was filed, your lordship, so in the connected appeal, we have filed a memo
yes,
for withdrawal that appeal,
withdrawal.
withdrawals. That memo has not been put, yesterday only I have filed. Connected 3 appeals also we filed
Withdraw
for,
ಮಾಡ್ಕೊಂಡು ಇದು contempt.
we will execute, there are process under going on here, sir, we will execute the sale deed in favor of the complainant. There are number of matters were there, wherein the appeals were filed. So we withdraw those appeals and the process is under to get the sale
So
deeds
with that
executed.
observation, my lord, it may be dropped, my lord, and liberty may be given for me to review, my lord, if they won't comply further.
Yes, certainly we will comply that. Your lordship.
ಕೊಡಿ.
Memo is filed, your lordship.
Memo.
Withdrawal of that appeal.
ಅದಲ್ರಿ ಇವಾಗ ಕೊಟ್ಟಿದ್ರಲ್ರಿ
ಅಲ್ಲ ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಕೌಂಟರ್ ಅಲ್ಲಿ, ಅದು ಪುಟಪ್ ಆಗಿಲ್ಲ ಅದು.
ಕೊಡಿ. Please give.
4 ಮೆಮೊ ಹಾಕಿದೆ ನೆಸ್ಟೆಡ್ ಟು ಪುಟ್ ಪೋಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. 4ರಲ್ಲಿ ಒಂದೇ ಅಪೀಲ್ ಬಂದಿದೆ, ಇನ್ನು 3 ಅಪೀಲ್ ಬಂದಿಲ್ಲ ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ.
ಯಾವ್ದು ನಂಬರ್ ಕೊಡಿ.
ಎಸ್ ಎಸ್
ಅದನ್ನು ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಡ್ರಿ. ಲಿಸ್ಟ್ ಮಾಡ್ತಿ ಇದನ್ನ
3 ಇದೆ. ದೇರ್ ಆರ್ 3 ಅಪೀಲ್ಸ್. 3
learned counsel for the appellant has filed a memo dated 17/12/2024 seeking leave of this court to withdraw the appeal as not pressed. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the appeal stands dismissed as not pressed.
Yes.
Full stop. Next para. ಇದರಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ಕೇಸಲ್ಲಿ learned counsel for the respondent. Commissioner, Kalaburagi Urban Development Authority submits that the writ appeal filed at the hands of the authority has been withdrawn today, and therefore the commissioner may be permitted to comply with the directions issued by the learned single judge.
Yes, sir. Yes, it was there a consideration of the
Full stop. It is also submitted that the directions issued by the learned single judge will be complied within
4 weeks, your lordship.
within a period of 4 weeks.
4 weeks. Yes.
Full stop. Next para.
Receipt of
Learned counsel for the complaint submits that the petition may be disposed of, recording the submission of the learned counsel for respondent number 1. And liberty may also be given, may be granted to revive the contempt petition, comma, if necessary. So up next, accordingly, the contempt petition stands disposed of while directing the first respondent, Commissioner, Kalaburagi Urban Development Authority to comply with the directions issued by the learned single judge as expeditiously as possible and at any rate within a period of 4 weeks from the date of receipt of a copy of this order.
Much.
Seal number 16, Nitesh Padiyar.
I appear for the complainant.
Liberty is reserved to the complainant to revive the petition, contempt petition, comma, if necessary.
Much.
I appear for the complainant.
Yes.
Not appear for the respondent, my lord. He received the GO, my lord, for preparing the
On submission,
writ appeal was not
Lordship may
maintainable,
kindly
my lord.
peruse 2/12/2024 order.
Writ appeal was not maintainable, my lord. For that is the reason that was, my lord, dismissed as not maintainable. Now, my lord, against the order of the learned single judge, my lord, we have to prepare the SLP, my lord. GO is received, my lord, on 16/12.
It's almost from 6 times it is coming before your lordship, my lord. The same submission is been said, my lord.
Allah, same submission, Allah. Now we received the GO, my lord.
Your lordship may kindly peruse 2/12/2024 order. On that day also, your lordship said that next date of hearing, if they not prefer its SLP, court will pass for further orders.
Now, my lord, 16/12, my lord, GO is issued, my lord, government.
Till today, they have
But
not
we have
filed SLP.
Because we given the request to the government to issue the GO. Now, my lord, on 16/12/2024, they issued the GO. Permission as to, my lord, prepare the SLP against the order of the learned single judge. Because appeal is not maintainable before the sun.
Writ appeal was also dismissed, my lord.
Not maintainable. That was dismissed as not maintainable. Now, my lord, we have to prepare the SLP.
Writ appeal was dismissed on the ground of delay, my lord.
Not delay. Don't make so false submission.
Intra-court appeal and delay, my lord.
Intra-court
Yes.
appeal, right? It's not maintainable and we have dismissed the appeal.
Along with delay, it was dismissed, my lord.
Cannot be, sir.
Yes.
Learned government advocate has filed a memo along with copy of government order dated 16/12/2024. Wherein the advocate on record in New Delhi and the respondent officers are accorded sanction to file SLP before the Honorable Supreme Court. Full stop. Learned government advocate would also submit that the writ appeal filed by the state and the officers was dismissed on the ground that such an intra-court writ appeal is not maintainable.
Please.
And therefore, the SLP was required to be filed. Full stop. Next, list this matter after winter vacation.
Seal number 17. That's correct.
Yes.
Lord, I appear for the accused, respondent. I need time to file objection, my lord. The contempt itself is not maintainable against the present respondent. And there is, I'm told there is also an endorsement already issued to the complainant.
ಅಲ್ಲ ನೀವು
A compromise-
ಅಬ್ಜೆಕ್ಷನ್ ಟೈಮ್ ತಗೊಳ್ರಿ ಆರ್ಗ್ಯೂ
No,
ಮಾಡಂಗಿಲ್ಲ
I will do both.
Huh?
I will do both.
ಅಲ್ಲಲ್ಲ then I allow me to argue.
No, I am making my submission.
Complaint in RSN.
What has happened, my lord?
Ah,
The complainant and the second respondent entered into a compromise and a decree as per Annexure A is passed by this honorable court.
ah,
Annexure A is the decree, my lord.
ah. Hmm.
Then, my lord, on the basis, kindly, in page 18, my lord,
Hmm.
para 10.
Hmm.
The parties hereby declare that the above named Narendra, that is complainant, and Srimati Shivalila, that is second respondent, accused, are declared as exclusive owner and possessor of the above stated extent of land, so and so, so and so. The respective names, respective parties are entitled to have their above stated respective properties entered in their name in the relevant panchayat records based on this compromise decree. In view of the above, next paragraph. Above said settlement, the appellant Srimati Shivalila and respondent number 1 Narendra hereby declare that they will agree with the measurements and boundaries stated in prayer 1 of this petition as the measurements and boundaries stated in their respective earlier title deeds in respect of their properties as pleaded in their plaint and WS in OS number so and so. That is, they will not claim the measurement and boundaries stated in their respective earlier title deeds stated in the plaint and WS of the above suit. So, and the map of the site property division part is annexed to this petition. And thus it is further ordered and decreed that the judgments and decrees of the trial courts as well as so and so are are modified in terms of the compromise.
But the first respondent is not a party to the
Yes,
appeal.
not a party.
How can you
Yes.
file a contempt? petition?
Yes, yes, I will explain that.
Yes.
Kindly peruse section 2B of the Contempt Act. As per that, contempt means any disobedience to a judgment or order of a court. As per section 2B, kindly peruse.
ಹೌದು ಹೇಳಿ sir.
So here what happened? After this compromise decree, I approaches the first respondent.
So you will only have a right to file a writ petition, sir.
Allala,
There cannot be a contempt petition.
I will come.
He is not a party and that decree is not binding on
Allala,
the panchayat.
allala.
Yes.
Section 2B note. I am, my lord, I understood what my lords
Yes.
are having in mind.
Yes.
He is not a party to it.
Yes.
It is not binding on.
Correct.
This has to be tested with reference to section 2B of the
ಮಾಡಿ
Contempt.
ಹಂಗಾರೆ objection file ಮಾಡ್ಲಿ ಅವ್ರು. 2 weeks are granted at the request of learned counsel for the first respondent.
A copy of the contempt petition may be served, my lord, I have only been.
ಇಲ್ಲೆಲ್ಲ ಕಳಿಸಿವಿ ನಾವು ಈಗ ಹೇಳಿದ್ರೆ
That is no, ಬರೀ ಒಂದು ಪೊಲೀಸ್ ಬಂದು ಒಂದು ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
that is between office and.
Let there be a direction to the complainant to serve the copy.
They are simply,
To stop the learned counsel for the complainant is also directed to serve copy of the contempt petition along with annexures on learned counsel for respondent. Yes.
ಡೇಟ್ ಕೊಡ್ರಿ, ಇದು 1.5 ವರ್ಷ ಆಗ್ಯದ ಆರ್ಡರ್ ಆಗಿ ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ, ಯಾವ್ದನ್ನ ಕೊಡ್ರಿ ತಮ್ಗೆ ಅನುಕೂಲ ಇರೋದು.
Yes.
ಇಲ್ಲ ಡೇಟ್ ಬೇಕಾಗಿ.
No, sir.
Salali.
In this matter, my lord, I am appearing for the respondent. Last occasion, my lord, your lordship directed us to file necessary application before the learned single judge for clarification of that, my lord, order. We filed the, my lord, application before the learned single judge, my lord, on 12/11/2024 and also requested to post that matter also, my lord. So that matter is not yet listed, my lord. What date, my lord, is entitled for interest, my lord, that is not clarified by the learned single judge, my lord. We filed the, my lord, application for clarification that order, my lord. Defer this matter, my lord, till that.
Learned, the government advocate submits that necessary application has been moved to seek clarification of the order passed by the learned single judge.
Please.
Comma, in terms of the observations made by this court in the order dated 6/11/2020. Stop. Next para. Release this matter after winter vacation.
Please.
Case number 19, Nitesh Padiyar.
I appeal for the complainant.
Lord. Lord, I appear for respondents 1 to 3, my lord. And Lord, the order against which a contempt proceedings filed, my lord. Lord, department also filed a writ appeal in, my lord, 200291 of 2024. 200291. 2020. Today it is listed at 34, my lord, serial number. List agide. 34. Lord, what had happened, Lord, the judgment which, my lord, other side relies on, Lord, that is been, my lord, challenged in SLP and which are pending consideration before, my lord, Honorable Supreme Court. And in between, my lord, there's some accommodation.
Yeah, with consent, the matter is
consent.
disposed of.
Well,
Why have you filed the appeal?
my lord, consent in the sense, my lord, for fresh consideration, we
will reconsider.
for fresh consideration, my lord, we are ready, but anyhow, my lord, at this moment, my lord, the similar matters which, my lord, disposed of by this honorable court, my lord. Now, my lord, pending before, my lord, honorable Supreme Court in SLP, my lord, they are all about, my lord, 11 matters regarding, my lord, regularization in a similar, my lord, line of argument. Lord, the other side and we ourselves appeared and, my lord, concluded. And those are the pending consideration matters, my lord. That is how this also, my lord, some accommodation, my lord, in between, my lord, whatever the, my lord, outcome we will.
But this writ up is not maintainable.
My lord, sometime, my lord.
You have invited an order by saying, all right, we'll reconsider. You cannot file a writ appeal.
But fresh consideration, my lord, with liberty to, my lord, look into the documents and we pass, my lord, endorsement. My lord, within 4 weeks, please.
No, what should we do with the? Already, you are saying who has approached the Supreme Court?
My lord, the department has approached. There are, my lord, parent department and, my
then why
lord.
did you make this application for the learned single?
Lord, in between, my lord, there was that development was not aware of, my lord. We thought of, my lord, they are complying with, my lord, earlier order. And all of a sudden, it has, my lord, learned that, my lord, it is learned SLP being, my lord, advised to be preferred.
Just come.
Just come.
advocate.
I appear for the advocate.
Appeared before the learned
That's so, my lord. And I'm making, it's my, my lord, presence before the learned single judge.
Serial number 34. Learned Counsel Shri Nitesh Padiyal is requested to take notice for
Lord, respondents.
all the respondents.
All the respondents.
All the respondents.
Please.
Who are the original writ petitioners?
Please.
So, Learned Counsel for the appellant is directed to serve copies of the appeal memo along with annexures on Learned Counsel for the respondent. Full stop. Next para. Learned Counsel for the respondent submits that
Lord, in IA, it has been mentioned.
the writ petition
Stay.
filed by the respondents herein was disposed of taking note of a submission made by the learned counsel for the appellant corporation, that the corporation will reconsider the case of the writ petitioners for regularization, comma, as ordered by the division bench in writ appeal number 200147 of 2022. And therefore, this appeal is not maintainable. Full stop.
No,
Next
that-
para. However, learned counsel for the appellant corporation submits that the learned counsel was unaware of the fact that specially petitions have already been filed at the hands of the corporation.
Please.
Before the Honorable Supreme Court.
Yes.
And therefore, it would not be permissible for the corporation to consider the case of the respondents for regularization. Full stop. Not being aware of this aspect of the matter, that special leave petitions were filed and are pending consideration, comma, the said submission was made before the learned single judge. Full stop. Next para. ಅದು ಕಾಪೀಸ್ ಹಾಕಿದ್ದೀರಾ?
My lord, I stay early, my lord, I have shown the SLP numbers, my lord.
ಏನ್ ಮಾಡ್ತೀರಿ?
Please.
Call your senior. If this is the contention that by inadvertence such a submission was made, but SLP has been already filed.
There is no spare otherwise. I leave to you.
Allah, see, that was by way of a concession.
House
It is not a order passed on merits,
fully considered.
on the basis of a submission made by the learned counsel. All right, we will consider on. But he was not aware of the fact that similar matters have already been taken up before Supreme Court.
At least number ಕೊಟ್ರೆ
ಇದೆ
ಕೊಟ್ಟಿದಾರಂತೆ.
ಇದರಲ್ಲಿ ಇದೆ ಅವ್ರಿಗೆ ಕಾಪಿ
copy.
ಪಾಸ್ ಆನ್ ಮಾಡ್ತೀನಿ please, entire
Now,
set.
what should we do with the contempt petition is the question.
ಅದ್ರ ಜೊತೆ this may be clubbed along with the writ appeal, my lord. Any date may kindly be.
Allah, see, what we are saying is the writ petition was disposed of.
Yes,
on
my lord.
the
I
basis of a sub-
am not disputing, my lord. I am not aware of the writ appeal, the defense or the averments what has been made in writ appeal.
ಹೇಳ್ರದವ್ರು. This is
I
what
have
they-
not gone through, my lord. ಅದಕ್ಕೆ.
These are the.
Any date may kindly be fixed, my lord.
let
Along with
me-
that.
This matter shall be called along with the CCC number 20024 of 2020.
Please.
Full stop. List these matters after interview.
Please.
Huh? Like anyway, they have already filed contempt petition.
Please. Hello, my lord. May I seek, my lord, request this, my lord, whatever the development, my lord, this observation may be next date of, if it is in the, my lord, written.
You know?
This observation.
Ah.
My lord, my lord, whatever the, my lord, pending of, my lord, SLP. Lord, we may not, my lord, come under pressure, my lord, considering, my lord, other side case. Without looking into the merits, my lord, so.
That is why we are not
Yes.
said anything in respect
Yes.
of the contempt petition.
Yes.
We are asking, in fact, the learned senior counsel, what should we do?
Yes, sir. Along
Should
with
you-
that, if it is clubbed and if any date is given, I will. You may not have any
Alan,
reasons for
my,
that,
my,
my
my
lord.
humble submission, my lord, it may be, may I seek, my lord, it may be said so, my lord, subject to SLP, my lord.
That is unfair, my lord.
Alla,
It will be unfair. on
First
his part to
instance,
make
my
such
lord,
a
I am not
submission. He
asking
cannot
for
dictate.
subject to,
He cannot dictate.
Or you go file a petition.
Review or both, sir, because. He may
At
not
least
dictate.
an application before the learned single judge and seek for recall of the order.
yes, please,
As it is, we leave it like this.
yes,
We are not
Yes.
going to proceed in the contempt petition also.
yes. That if it is, my lord, come in the,
ಎಲ್ಲ ಹೇಳಿದಿವಲ್ರಿ, you have filed SLP, ಎಲ್ಲ ಬಂದಿದೆ.
right,
What more do you want now?
yes,
Yes.
not to press anta, my lord,
The club ಮಾಡಿದ್ಮೇಲೆ
You have not said anything.
right, please.
That contempt petition also is before us only.
Yes.
Then why are you worried?
Yes,
Yes.
much.
Number 20, KM Ghati.
But in this matter, my lord,
There was a direction to the second respondent, my lord, to consider the representations.
Huh?
There is a direction to the second respondent, my lord, to consider the representations filed by the writ petitioner. About 3 months time was given. But so far, second respondent has not attended, my lord, though the order was communicated to him.
Chief Officer, Town Municipal Council.
Town Municipal Council. Chief Officer, Town Municipal Council, Balki.
Learned Government Advocate. Takes notice for respondent number 5.
One, my lord. Yes, formal party.
ಅವರೆಲ್ಲ ಹೆಂಗ್ರಿ ಬರ್ತಾರೆ ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೆಕ್ರೆಟರಿ ಎಲ್ಲ ಯು ಆರ್ ಸೇಯಿಂಗ್ ಡೈರೆಕ್ಷನ್ಸ್ ಆರ್ ಇಶ್ಯೂಡ್ ಓನ್ಲಿ ಟು ದ ಚೀಫ್ ಆಫೀಸರ್.
Yes, my lord.
Then
They are the only formal parties. my lord.
ಅವ್ರು ಯಾಕೆ ಫಾರ್ಮಲ್ ಪಾರ್ಟೀಸ್ ಆಗ್ತಾರೆ ಬೈ ನೇಮ್? ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಇಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5.
Yes,
ಡೈರೆಕ್ಷನ್ಸ್ ಆರ್ ಇಶ್ಯೂಡ್ ಓನ್ಲಿ ಟು ದ ಚೀಫ್ ಆಫೀಸರ್.
please.
ಇಬ್ಬರನ್ನೇ ಮಾಡ್ಬೇಕಾಗಿದ್ದೀವಿ ಪಾರ್ಟಿ.
Hmm.
ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೆಕ್ರೆಟರಿ ಎಲ್ಲಾರನು ಬೈ ನೇಮ್ ಯು ಶೋನ್.
ರಿಜಿಸ್ಟ್ರಿದವ್ರು ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ ಮಾಡಿದ್ರು.
ದೇ ಇನ್ಸಿಸ್ಟ್ ಆನ್ ಸ್ಟೇಟ್.
Please,
ದಟ್ ಈಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5.
please.
ಅಷ್ಟೇ. Learned Government Advocate takes notes for respond number 5. Learned Counsel for the complainant is directed to serve a copy of the petition along with annexures on the Learned Government Advocate. Full stop. Next para. Issue notice to respond number 2, Chief Officer of the Town Municipal Council, Balki.
Please.
Yes.
Much.
Returnable by 13th of January.
Seal number 21, Sudarshanam.
Look, there is a delay in filing this appeal.
Hmm.
The appeal is directed against the order passed by the learned single judge, which your lordships will find at page number 19.
Yesterday connected appeal was
Where an application is
listed along
filed.
with the contempt.
Bidar.
Howd, Bidar.
This is Bidar.
Connected appeal
Yes.
200307.
Conversion.
Connected only.
Nenne.
Connected it.
There are many petitions.
I was not knowing that. Now, this is, my lords, an application under section 95 of the Land Revenue Act, which is now ordered to be. Since your lordships have heard the other matter, my lords, then I will only start with this. Kindly come to.
Only ordered notice ಅಷ್ಟೇ ಬಿಟ್ರೆ ಇನ್ನೇನಿಲ್ಲ ಅಲ್ಲ.
Howd,
There's only,
interim
there's-
relief is
there's only
rejected.
one thing, my lords,
But
Interim
we have
prayer.
rejected the interim prayer by
that case, my lords,
elaborate order.
I am not sure, my lords, my friend, if he is appearing in all the cases, he will be knowing that. I will point out two things, my lords, which I think the facts are not similar to that one. In this case, my lords, the Waqf board is the owner of the property. The property is a notified gazetted property. Kindly come to page number
Where is the
10
RTC?
103 and 104, my lords,
RTC.
the notification.
We are not concerned about the notification.
I will also show, my lords, the orders of the
RTC.
land tribunal.
RTC.
Yes, my lord.
Yes.
I will show the order of the land tribunal which speaks about my right over
We
the
want to see the RTC, sir.
RTC is not filed, my lords, here because.
That is why they are not filing the RTC because they know fully well that their name is not entered in the RTC. That is the whole problem, sir. ಅದಿದ್ದಿದ್ರೆ the deputy commissioner would have rejected it solely on that ground, that you are not the registered owner. Registered owner is the work property and.
Correct.
Without that, this kind of an order has been passed by the deputy commissioner. That is the whole problem.
I may only point out, my lords, what I have seen. I may only point out one order of the Honorable High Court in this case. Kindly come to, my lords, the order passed in LRRP number 1899, which is at annexure R4, page 118.
ಅದು ಏನೇ ಇರ್ಬೋದು.
ಇಲ್ಲಿ ನಂದು the
The
ownership of the
deputy
Waqf issue.
commissioner had to reject the application for conversion.
True.
It can be on the ground that you are not the owner of the property, it is someone else.
Annexure G is the order which shows that, my lords, it is someone else.
So we are asking you.
Yes.
Where is the RTC that shows your name?
That I have not, my lords,
The-
the documents are not produced
Yes.
to show that. But my lords, kindly permit me to show this, my lords, which will also in one way show that the Waqf board is also laying a claim of ownership over the property. My lords, the dispute is not between the respondent herein and the deputy commissioner.
And the deputy commissioner had taken up the matter before the Honorable Supreme Court. Waqf board was a party. Yes, sir.
Not in this case.
Waqf board. ಅಲ್ಲ
I'm
ಪ್ರತಿ
sure.
ಒಂದ್ರಲ್ಲೂ you don't expect an invitation from the court. If you are aggrieved of in one matter,
Yes.
similar matters, and you have suffered an order even at the hands of the Honorable Supreme Court, what can we do, sir?
Same matter, number 61.
ಅದೇನೆ
I'm
ಸರ್ವೆ ನಂಬರ್ 61 ನಲ್ಲೇ ಬೇರೆ ಬೇರೆ ಇರ್ತವೆ.
ನಿನ್ನೆ 61 ಇರಲಿಲ್ಲ, ಇದು 61.
ಇವತ್ತು 61.
ಹೌದು.
Same village,
Same village.
same facts,
Same.
same order.
Then I'm not probably
Yes.
fully instructed.
Circle.
Can I only show this one fact, just for the satisfaction of my friend? Page number 120.
ತೋರ್ಸಿದ್ರು ನೆನ್ನೆ ಇದೆಲ್ಲ ತೋರ್ಸಿದ್ರು ಅವರು.
ಇದು LRRP
We have
order.
seen all this. Yes.
Because in LRRP order, my lords, the High Court has held only page number 126, only 2 paragraphs I will read and I will stop there.
Pointed out, sir. Yesterday he has pointed out all this.
This portion, Lord, what has been.
ಹೌದ್ರಿ, ಈ ಆರ್ಡರ್ ನೆನ್ನೆ ತೋರ್ಸಿದ್ರು ಇಲ್ವಾ?
ಅದು ತೋರಿಸಿದ್ದೀನಿ.
Today.
This particular para he wants to.
ಇರ್ಬೋದು.
Para
We can't go into all that, sir. This is not the way we are going to look at things when considering the writ petition filed.
But my lords, the dispute is not between the respondent and the deputy commissioner. Deputy commissioner is not laying any right in the property. The right.
That is why we are coming down so heavily on the deputy commissioner. Why are you so interested ಅಂತ ಅವ್ರಿಗೆ ಕೇಳ್ತಾ ಇದೀವಿ. You may have a right.
Yes, that is the only. I am only protecting the.
Therefore, you protected in the manner known to law.
Known to. That is the only grievance I can raise here.
Do that.
The other thing is, my lords, if the conversion order is now held to be a deemed conversion order, obviously, my lords, the subsequent events will be sale of these properties to
You
several
can
persons.
still approach the competent authority, get an order of stay or injunction or whatever you want, you can do. Please do it, but not like this. Learned government advocate takes notes for response number 2 to 5. Learned counsel Sri Ravi B. Patil, who is present in the court, takes notice for response number 1. Writ petition. Full stop. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned government advocate as well as learned counsel for response number 1. Stop. Next para. Learned counsel for response number 1 submits that under similar circumstances, in a writ appeal filed at the hands of the appellant herein in
200307.
307 of 24.
This court has passed elaborate order
The party to the proceedings. Thereafter, my lord, what happens is under the Inams Abolition Act, the tasdik allowance and the annuities have to be paid to the landlord. Only then, my lords, the ultimate that ends into the entire process of conferment of occupancy rights ends only when the tasdik allowance and the annuity is fixed and paid to the landlord. Even that is not paid till today. The landlord has not even received the annuity or tasdik amount. My respectful submission is that the question about grant made in favor of the respondent herein is at large still. It has not attained finality. Is what
What did you do with that observation?
it is open.
You read out now.
Yes, nothing beyond that.
What can we do then?
Because my lord, tasdik is not received.
Such an observation was made long ago.
In fact, para 7.
And they have done nothing.
In fact, para 7, I will read more. The fact remains that the order of grant passed by the land tribunal was never challenged by Waqf board. And if it is still open to the Waqf board to challenge the order of the land tribunal or agitate the right of its ownership over these lands, it may take such steps as may be permissible in law in that regard. Now, my lords, only multiplicity of litigation should not happen. That's the only point I can now.
When was that order passed?
This was 2003.
Okay.
Ega,
I think it's better not to make that observation. We will leave it at that. Which comes to the rescue of the appellant. Full stop. Next para. Nevertheless, we are of the considered opinion that elaborate orders have been passed by this court declining to grant interim relief to the appellant. And therefore, the same holds good in this appeal also. Yes.
Seal number 22, Vishal Pratap Singh.
In this matter, my lords, in respect of accused number 9, an order is passed by this court. Similar order is applicable to this appellant also. Let's say he was accused number 9 in that case. He has also completed more than 12 years as an
office objection.
Office objection. First objection is with regard to the date which is wrongly mentioned in the trial court order itself. So, my lords, that submission
Order to,
the trial
certificate copy.
certified copy. I have filed a computerized copy of it, my lords, and I have also filed a dispensation. Now, my lords, in the course of time, once we get the certified copy, I have filed along with the dispensation also.
You cannot seek dispensation of production of a certified copy of the order that is impugned. We cannot dispense it. We can only grant you more time.
One week time maybe.
Dispense.
Allah, dispense. I have also, in fact, dispensation application like 1 week time. So, in terms of that, my office objection will be this thing. Similar order minutes. This is the order minutes which your lordship has passed. Same, this is the order which is applicable to this case also, because in this case, accused number 9 was granted. He is accused number 7 minutes.
ಈಗ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಮ್ದು ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಿ ಅಂದ್ರೆ ನೀವು ತಗೊಂಡ್ರಿ ನನ್ನ ಹತ್ರ.
Referring to
ಸಬ್ಮಿಷನ್ ಅದಂತ ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಅದಂತ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ. It's for council submission. Because of that, my lords, I have not filed objection.
Objection.
For suspension of sentence, my lords.
It had come up earlier, is it?
Yeah, it has come.
It had come up.
Yes.
We had granted you time to file objection.
No.
First
it has
it is
come.
coming up for the first time.
Therefore, it has come, my lords, but it was not reached.
Learned
Yes.
additional SPP takes notice for the respondent. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned additional SPP. Full stop. Next para, learned additional SPP seeks for a short accommodation to file statement of objections to IA number 1.
IA is first IA is for condonation of delay minutes. There is a delay that may be allowed. There is a delay.
IA 3 na.
IA 3.
IA 3 of 2020. Full stop. Next para. Condonation of delay.
Condonation.
There is a delay, my lords.
How long days?
Next per order on IA number 1 of 2024. Full stop. There is a delay of 344 days in filing the appeal. Full stop. Nevertheless, comma, having regard to the fact that the appellant is serving sentence, comma, we deem it necessary to allow the application while condoning the delay. Full stop. Accordingly, delay is condoned. IA 1 of 2024 is accordingly disposed of. Full stop. Next para. 2 weeks time is granted to the learned additional SPP to file objections.
ಅಲ್ಲ objection ಹಾಕಿದ್ದಾರೆ. Copy is given to me. ಅಲ್ಲ
Objection copy, it was ready there for study. What you have submitted me, that this is the second time. That's what I prepared the objection. Co-accused has been granted bail by this honorable court.
Huh?
Co-accused has been granted bail by this
Ah.
honorable court. To that effect, my lords, it was ready.
Oh,
But this is the first time wherein my friend has I made a wrong submission with me. That this is the second time.
wrong submission.
Then you would have told that this is the first time. That was not reached down by that time. When you are telling that the objection filed and filed. I have not filed before the honorable court.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ.
Copy served ಮಾಡಿದ್ದೀನಿ. It was about to serve, but it would not reach me.
All. Anyway, we'll have to take it up after vacation.
Yes, my lords.
This matter will be
15, my
before
lords.
suspension only, my lords.
Huh?
15.
In terms of Honorable Supreme Court, once the co-accused, the matter is taken up,
Yes.
it will come before that.
Formally. You
Formal
file the
objection has to be filed. my lords.
Application.
Yes.
Sorry, objections.
Yes, ma'am. Can it be posted on 15/1 or 19/1?
Huh?
Next week, after vacation.
13 ವರ್ಷ ಜೈಲಿಗೆ
13 ವರ್ಷ ಆಗಿದೆ ಜೈಲಲ್ಲಿ. There is also a Supreme Court judgment
Objection
also.
has
my
to
lord.
be filed.
Kindly, there is a Supreme Court judgment also.
Without objection ಬಿಡ್ಬೇಕಂತಿದ್ಯಾ ಕೊಡಿ. Then I had to be given a chance, my lords. I have to file objection. Even I was ready to file objection. By that time, he.
All
Objection is ready.
2 weeks time.
Please.
Granted to the respondents to file objections to IA number 3 of 2024. Full stop. In the meanwhile, office objection shall be complied with.
Much out.
Yes, minutes. Office objection number 2 minutes. One objection is with regard to the date which is mentioned by the trial court itself. That is a mistake done by the trial court minutes. I can't.
ಯಾವ್ದದು?
Objection 1 minutes plus submission.
ಹಾ.
ಅದರಲ್ಲಿ that submission I have to make before the court as to why the date is different. ಅಂದ್ರೆ try
ಇದು production of the
certified copy, it will be
Now,
done.
which objection is that?
That is for objection number.
At serial number 1. Objection at serial number 1. The other office objection is overruled. All.
Yep.
One more submission, my lords. Serial number 46, it's for further hearing, my lords. As per the direction of the honorable court, I have to go to district court, that generality question, my lord, to cross-examine the officer who has issued it. So today it is posted before the district court. So kindly it may posted
ಯಾವ್ದು?
serial number 46.
46.
Yeah, it is for further hearing, my lord. The same we shall do appellant, it seems.
ಡೇಟ್ ಇವತ್ತು ಅಪ್ಡೇಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು.
Tomorrow.
But arising from the same.
No, my lords, no, my lords. It's for further hearing, my lord. So I have to go to district court as per the direction of this honorable court.
Serial number 46.
Yes.
List this matter immediately after winter vacation.
Please.
ಯಾವ್ದು? Further hearing ಅಂತ ಬಂದಿದೆ. Release from parted. List this matter after winter vacation.
Please.
Then my application for suspension sentence will be considered, my lords, because
Sir, any other bench will consider what?
Seal number 23.
Lord, the last date of hearing, lords have directed government advocate to find out what is the position of a
co-employee who is similarly framed with the charges.
Co-delinquent employee,
Yes, ma'am.
pass over.
Right.
Bandru.
My lord, I have sent letter. I have not received instructions, my lord.
Then we will give the same relief to the
Great.
petitioner also.
Yes.
See, if two similarly placed persons are given different treatment, this court is not going to accept.
Now, one thing, my lord, it may be taken day after tomorrow. Meanwhile, I will secure, I will call, telephonic, I will take instructions.
Already, there is an observation made by the
Yes, my
CIT
lord, yes,
itself.
I have seen, my lord. Similar allegation against one.
You don't want to do anything, then it shows the you are trying to do treating different employees differently.
No, my lord. Kindly,
Should not happen.
kindly take a day after tomorrow, my lord. I will secure instruction, I will submit.
Don't day after tomorrow, tomorrow itself.
Yes.
At the request of the learned AGA, release this matter tomorrow.
Seal number 24, hearing the PM.
I'm appearing for the respond number 3, Your Lordship.
Here for petitioner. It was dismissed for default, my lord. Filed a recall application.
Your Lordship, the petitioner who is not entitled to be appointed is illegally enjoying the post of junior health assistant called by the respond number 1 and 2.
Huh?
The petitioner who is not entitled to be appointed is illegally enjoying the post of junior health assistant called by the respond number 1 and 2, Your Lordship.
Who are you?
I'm appearing for the respond number 3, Your Lordship.
Ah.
I being the more meritorious than the petitioner, Your Lordship, I have been denied the post, saying that on the ground that I have now completed SSLC from the Karnataka Open School, which is not equivalent to the regular SSLC. But that is wrong, Your Lordship. There is a government notification which clearly states that open school. Please,
You are saying the petitioner.
Please, Lordship. The respond number 1 and 2 had called by way of notification for the post of different, Your Lordship. The one of it was junior health assistant post, for which the petitioner and respond number 3 had applied, Your Lordship, and they had calculated the aggregate. And Your Lordship, as per the calculation of the aggregate, there it was 71%, Your Lordship. That is a petitioner number, petitioners, Your Lordship. Whereas mine was, Your Lordship, there was 74.64, Your Lordship. That is higher than the petitioners, Your Lordship. But I have been denied the post saying that I have obtained a SSLC from the Karnataka Open School, which is not equivalent to the regular SSLC.
He was appointed.
Please, Lordship.
Why should you file the writ petition then?
No, we approached the.
You approached the
KT, Your Lordship. Yes. KT upheld, saying that, Your Lordship, she cannot be appointed, petitioner cannot be appointed, and the respond number 3 is entitled to be appointed. And that order has been challenged by the petitioner before this honorable court.
Annexure C, na? Which is the order impugned?
Annexure C, page 96.
2017.
Yes, sir.
Oh, this writ petition also was filed in the year 2017.
Yes.
And dismissed
For non-prosecution.
DN
6th of August 2020.
In time I have filed application. Earlier, council was.
Order on IA number 1 of 2024. This application is filed by the petitioner seeking to recall the order dated 6/8/2024, whereby the writ petition was dismissed for non-prosecution. Why court notice had to be issued to the petitioner?
My lord, earlier advocate, their lordship, Ashok Kinigi was elevated. Thereafter, she could not appoint the other advocate. So notice was given to her. After that notice, he could not appear. So because of the matter was dismissed for default. So later on, she approached me. I filed this application.
Submits. That since the learned counsel on record for the petitioner was elevated as a judge of this court, court notice was issued to the petitioner. And it appears that the same is taken as served. Full stop. However, since there was no representation, the writ petition was dismissed. Full stop. Subsequently, the petitioner came to know of the order of dismissal and thereafter engaged the services of the learned counsel who has filed wakalat and has filed this application. Please stop. Next para. Having regard to the above stated facts, we are of the considered opinion that the writ petition is required to be heard on merits. Full stop. Accordingly, delay is
Yes. No, my lord.
huh?
Delay ಇಲ್ಲ.
In time.
6A dismiss ಆಗಿತ್ತು. On
Accordingly, the application is allowed
yes.
while recalling the order dated 6/8/2024. Stop. The writ petition is restored towards original file. Stop. Yes.
Your lordship, a date may kindly be fixed. Your lordship.
Yes.
Say number 25,
Obliged.
GS Biradar.
For appellant, my lord. I have filed application for return of exhibit D8, my lord, the original sale date.
Huh?
Since there is a encroachment made by the neighboring owners of the suit property, my lord.
22 days in filing the appeal. 2018 matter.
ಅಲ್ಲ,
RFS.
RFA.
RFS.
Hmm.
I filed an application on 4/12/2024.
Only for that one.
On IA ನು ಬಂದಿದೆ sir. Return of document
is also filed.
You know,
Return of document application has been filed, man.
for return of original document.
Original document. Exhibit
Original document.
Exhibit D8 sale date, my lord, filed by the appellant before the trial court during the evidence, my lord. Now some of the neighboring owners are creating trouble. They are trying to encroach upon the suit property, my lord. So in order to get the survey and get the to approach the competent authority, the original sale date is required, my lord.
Why do you require the original sale deed for that?
Allah, even if the appellant may approach the honorable trial court for seeking injunctions order, my lord. Okay.
Suit for partition.
Partition.
Suit.
What do you say?
Decreed. Original document can be returned, subject to obtaining the certified copy and production of this.
I will undertake to produce, my lord, sir.
Order on IN number 1/2024. This application is filed by the appellant
Yes, ma'am.
herein seeking a return of
Exhibit D8, man.
the original sale deed dated
Sale date dated 4/10/2003. Sorry, 10/4/2003, man.
Exhibit D8.
D8, man. 10/4/2003.
which is marked as exhibit D8.
8.
comma, on behalf of the appellant herein who was
Defendant, my lord.
dependent number
Defendant number 6, my lord. Defendant number 6.
dependent number six before the trial court. ಇದೇನ್ರಿ
D8, D8.
D8. Exhibit D8 ಬರ್ದಿರೋದು.
ನೋಡ್ರಿ ಕರೆಕ್ಟ್ ಆಗಿ ಎಕ್ಸಿಬಿಟ್ D19 ಅಂತ
D19. Sorry. Yes, D9. Sorry.
D19 ಅಂತ ಮಾಡ್ರಿ.
D9.
Registered sale deed.
Yes, yes, yes.
D19 ಅದು.
Please, ma'am, sorry.
ಅಲ್ಲ ಅಲ್ಲಿ ಯಾರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಅಂತ ಇದೆಯಾ ಅಲ್ಲಿ?
He has been marked DW2.
Dependent, ah?
Defendant, my lord.
DW2. Defendant number 6 has been examined as DW2.
ಅಲ್ಲ ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ
ಯಾರು mark ಮಾಡಿ?
ಡಿ
D19, my lord.
ಅಲ್ಲ ಸಾರಿ ಇದೆ
D2, my lord. D2 got marked.
D2 ಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ 2 ನೋಡ್ರಿ.
Page.
ಇದು ಎಕ್ಸಾಮಿನೇಷನ್ ಅಂಡ್ ಚೀಫ್ ಅಲ್ಲಿ
ಅವರೇ
ಅವರ ಇದರಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿ ಬಂದಿದೆ ನೋಡಿ.
page 42 of page paper book. man.
ಅವ್ರ ಎವಿಡೆನ್ಸ್
ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್
Malkaj,
ಅಲ್ಲಲ್ಲ ಕ್ರಾಸ್ ಅಲ್ಲ ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್.
examination chief.
ನೋಡ್ರಿ.
D9.
ಲಾಸ್ಟ್ ಇತ್ತು. ಎವಿಡೆನ್ಸ್ ರಿಕಾರ್ಡ್ ಆಗಿರುತ್ತೆ ನೋಡಿ ಅಲ್ಲಿ.
It has been marked by DW.
ಏನಂತ was examined as a
DW,
dependent witness 2.
DW.
Huh? Full stop. It is stated in the accompanying application that the neighbors are trying to encroach upon the property described in the sale deed. And therefore, the appellant requires the original sale deed to protect his rights. Full stop. Next para. On our asking, learned counsel for
Appellant.
respond number one, plaintiff submits that the original sale deed dated so and so was marked on behalf of the appellant hearing, and therefore the same may be returned.
Subject to undertaking.
So, next para. Accordingly, the application is allowed. Full stop. Office is directed to return the original sale deed dated so and so marked as exhibit D19
D9.
to the appellant, subject to the appellant placing on record a certificate copy of the sale deed.
Sale deed.
Yes. ಅಲ್ಲ ಅದ್ರ ಮೇಲೆ ಆಗಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ. ಆಗಿದ್ಯಾ? This property.
No.
ಈ ಪ್ರಾಪರ್ಟಿ ಡಿಗ್ರಿ ಆಗೈತಿಲ್ರಿ?
ಹೌದು.
Yes, sir. ಇದೆ.
ಪ್ರಾಪರ್ಟಿ is also decreed.
Partition has been granted, but
Even in respect of this property.
Property also.
but the third person is involved, it seems. Affidavit is filed to that effect for return of document.
it is made clear that the appellant shall not misuse the original documents to the detriment of the other parties to these proceedings. Yes.
Seal number 26, Vikram Vijay Kumar.
Appearing for the Vikram Vijay Kumar, on behalf of the Vikram Vijay Kumar, I have filed a application for paper publication, Lordship.
Yes, sir, notice.
3 times exist.
3 times.
Agila.
Agila.
You'll have to take out notice 3
Please,
times.
please.
Pending consideration of IA number 1 of 2024. The appellant is directed to take out fresh steps for service of notice on
R4 and
respond number 5, bracket 1, 2, and 4. Within a week from today.
Please.
seal number 27, Manvendra Reddy.
It's an appeal file, whenever there is a delay of 125 days in filing the appeal.
Don't.
So it may be condoned.
LAC,
Appeal under the old act
old act,
Old act.
can be condoned.
order on IA number 1 of 2019. Full stop. There is a delay of 125 days in filing the appeal. Full stop. Learned counsel for the contesting respondents fairly submit that the delay may be condoned. Stop accordingly. Delay is condoned and IA number 1 of 2019 is disposed of.
Enacted matter 50% deposit. Enacted matter, the stay has been granted.
Stay has been granted subject to deposit of 50%. Lord,
Please give a copy.
yes, yes. After deposit, withdrawal is also permitted. Lordships may say, not
Next para. In terms of interim orders of stay passed
MFA number 2015.
in MFA 201527 of 2019. There shall be an interim order of stay of the operation and execution of the judgment and award passed by the first additional senior civil judge, Kalaburagi in LAC 439 of 2013. Same,
Yes. LAC 436 of present case, my lord, 436 of
436 of 2013.
13.
Dated
Dated 11/3/2009.
3/2019. Subject to the appellant depositing 50% of the award amount before this court within 6 weeks from today.
8 weeks, my vacation on the
Huh?
taken 8 weeks because of vacation.
ನಿಮ್ಗೆ ಏನ್ರಿ ವೆಕೇಶನ್
ಅಲ್ಲ
Huh?
ಅಲ್ಲಿ ಸರ್
ಅವ್ರಿಗೇನ್ ವೆಕೇಶನ್ they will be working. In fact, they work 7 days a week.
ಇಲ್ಲ ಸರ್ 5 days.
Railways.
Railways ಇಲ್ಲ 5
Railways.
days. By Saturday ಇರೋದಿಲ್ಲ sir.
Let,
6 weeks.
let that deposit be before the reference court itself.
Huh?
The deposit, my lord, could be before the,
But ಇದೆಲ್ಲ ಮಿಕ್ಕಿದೆಲ್ಲ ಇಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ.
Lord, subsequent, we may be permitted to, my lord, withdraw. Because in that case also, my lord, subsequently on I am, lord, I was permitted to withdraw, the parties have withdrawn.
Next para. Learned counsel for the respondent claimant.
Yes.
Submits that
The first paragraph.
the claimants have been permitted to withdraw the amount deposited by the appellant. In MFA 201527 of 2019. And therefore, learned counsel prays for similar orders. Full stop. Next para. Accordingly, the respondent claimants are permitted to withdraw the amount deposited by the appellants, on the condition that the said respondent shall execute indemnity bond undertaking to repay the part of or entire amount withdrawn by the respondent, comma, subject to decision in this appeal.
Seal number 28, Vijay Lakshmi Melkundi.
Respondent claimants, my lord, because the state is also respondent. The withdrawal permission.
Respondent claimants, like. Yes,
Seal number
The
20.
appellant is present.
huh?
Appellant is present.
You know,
Appellant is present.
My lord,
yeah,
next
Connect.
28 matter,
28.
appellant counsel has retired from the case, my lord. The party has.
ಏನಮ್ಮ ಇವರು ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡ್ತೀನಿ. The appellant is present before this court. Full stop. She submits that she will engage the services of another advocate within a period of 2 weeks. 2 ವಾರದೊಳಗೆ ಮಾಡಬೇಕು.
Find a lawyer, I will definitely.
ಮಾಡ್ಲೇಬೇಕಮ್ಮ. ಇಲ್ಲಾಂದ್ರೆ ನೀವ್ ಮತ್ತೆ ಬರ್ಬೇಕಾಗುತ್ತೆ ಕೋರ್ಟ್ಗೆ. Period of 2 weeks. Full stop. Accordingly, list this matter after winter vacation. ಏನ್ ಕಥೆ? Delay 2020.
Seal number 29, RS Siddhapurkar.
Yes.
This is that archaeological survey matter, my lord.
16th,
the officer was directed to be present. He was present on that day. But the matter could not be taken up. Today he is not there.
My lord, it is not only, my lord, presence of appellant was directed, but he was directed to conduct survey. And my lord, issue NOC if it is beyond the prohibited area or protected area.
He has personally conducted survey, my lord. He says that from the edge of the monument, it is beyond.
where is the document?
ಅಲ್ಲ ಅವರು ಸರ್ವೆ ಮಾಡಿಸ್ಲಿಕ್ಕೆ ಅದಕ್ಕೆ ಅವರು ಒಂದು ಮ್ಯಾಪ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
This is the letter, my lord, issued to the.
Allah, he himself was directed, my lord, not with the assistance of anybody, my lord.
Why did you not mention on 16th?
I had mentioned. I had mentioned at 2:30. ಅವು ಬೇರೆ ಬೆಂಚ್ ಇದೆ ಅಂತ.
They requested us, my lord, on 10/12/2024 in the reference, my lord, to make the survey. Thereafter, my lord, deputy commissioner directed the, my lord, ADLR to make the survey.
My lord, kindly see, my lord, kindly peruse.
It was not in the presence
Yes.
of the superintending, what is that?
Archaeologist.
Archaeologist.
They requested us only, my lord. They had to do it, my lord. First, they gave a letter to us, my lord, to make the survey. For that is the reason, my lord, we requested the ADLR to make the survey. Directly, they can request to the, my lord,
What
ADLR.
is he trying to do?
Pardon?
What is he trying to do?
My lord, this has to be officially done. That is one thing. Your lordship directed this officer to personally go and
Correct.
conduct the survey. He has conducted the survey. and he
So
has
where is his report
sent
then?
Report ಹಾಕಿಲ್ಲ ಅವ್ರು ಬರೀ photographs ಕಳ್ಸಿದ್ದಾರೆ. And he says that from the edge of the monument, it is beyond.
Whatever he has to say it in writing.
Writing.
I will not pass orders.
He was directed to be present before the
Ah.
court on that day. He wanted to make some submission. ಅವತ್ತು ಆಗ್ಲಿಲ್ಲ ಅವತ್ತು. From the edge of monument, he admits that it is beyond. But since there are no boundaries fixed in the original notification, boundaries are not fixed in the original notification. From the edge of the monument, it is beyond. He admits that.
How far away? It is more than a kilometer away.
He is admitting that.
Then?
But what the problem is, my lord, it has to be done.
Prohibited distance maximum is 200 meters.
ಹೌದು.
This has to be with reference to the revenue records which are available with the district administration. Therefore, we have requested him to conduct a proper survey in the presence of both the parties. That is being done now.
ನಿಮ್ಮ ಇದು ಇನ್ಫಾರ್ಮೇಶನ್ ಪ್ರಕಾರ ಏನು?
Beyond the, from the edge of the monument, beyond there.
12/12, we written letter to the ADLR, madam. 12/12, madam. 10/12,
DDLR.
10/12/2024, they requested the deputy commissioner to make the survey. Then after we, deputy commissioner, my lord, issued letter on 12/12/2024 to the ADLR to make the survey, my lord. This is the first letter, my lord.
DDLR, Upanirdesh,
ADLR, deputy
DDLR.
director of,
Deputy Director.
what is that?
ಉಪನಿರ್ದೇಶಕರು ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್.
ಹೌದು, deputy director of the
Land
survey, my
records.
lord.
Land records.
ಅಷ್ಟೇ
ಹೌದು.
ನೀವು ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, now we requested to the deputy director.
Huh?
We are the deputy commissioner, my lord.
Your additional DC has submitted.
This is written letter to the, my lord, deputy director.
Your additional DC Raichur.
My lord, my humble submission is, my lord, this court has specifically directed the officer. He cannot, my lord, finger at, my lord, other officers.
That's what I am submitting. He has gone,
Now,
he
he
has
is not
measured
an
the
expert.
land.
ಅಲ್ಲ, ಅದು distance,
Additional
ಅದಕ್ಕೆ,
DC.
that was considered by this court, my lord.
Additional DC ಮಾಡಕ್ ಎಲ್ಲಿ ಬರ್ತದೆ?
Additional ಅಲ್ಲ, archaeological survey ದವ್ರು ಮಾಡಂತ ಹೇಳಿದ್ರು.
ಸೂಪರಿಂಟಿಂಗ್
ಹೋಗಿ ಒಂದು ಕಿಲೋಮೀಟರ್ ಅಳಿಯಕ್ಕೆ ಅದೇನ್ ಎಕ್ಸ್ಪರ್ಟ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ. No, no, no.
He had directed the superintending archaeologist to himself go personally find out
Yes.
as to what is the position.
That's what I am.
So he was required to file a report or an affidavit.
ಅವತ್ತು ಹಾಕಿಲ್ಲ.
Huh?
He has not filed any affidavit on that day, but he has sent me some photographs wherein he has conducted the survey himself. And he says,
what is the opinion? There has to be some opinion, isn't it?
writing ಅಲ್ಲಿಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ ನಾನು ಹೇಳ್ತೀನಿ.
Why not in writing, sir?
From the edge of the monument, it is beyond. He admits that.
ಬರ್ಕೊಳ್ಳಿ. ಏನಿದು ಅಪೀಲ್?
ಹೌದು.
Why have you filed this appeal?
Because deemed conversion order was taken by the other side.
Now you are satisfied.
Lord, if it is officially done, then there will be no problem for them also and me also.
Who has to do it officially, sir?
Survey department. That's why survey department.
Then how can you raise objections then?
With reference.
You only know to raise objection. You do not want to have the matter properly surveyed.
Lord, we have written bunch of letters to the deputy
Then how did you
commissioner.
raise an objection that it is coming within the prohibited distance?
Because there is a revenue map.
And it is also a fact that you have given permission to other persons in the same survey number.
There is a old revenue map which shows that it is within the prohibited area.
This writ appeal has been filed at the hands of the superintending archaeologist.
Two writ appeals. There are two writ appeals.
And these appeals being aggrieved of the impugned order passed by the learned single judge, who allowed the writ petition and held that the petitioners are entitled to the benefit of deemed conversion in respect of the subject land bearing survey number 401/1. ಇನ್ನೊಂದು ಯಾವ್ದ್ರೆ?
401/7.
Measuring 3 acres and 27 guntas and survey number
401/7. 3 acres.
7 measuring
3 acres.
3 acres.
Please.
Situated at Maski Taluk, Raichur district. Full stop. Accordingly, the deputy commissioner was directed to effect conversion and issue conversion certificate in favor of the petitioners after receipt of necessary charges for such conversion, in accordance with law. Full stop. The deputy commissioner was also directed to comply with the directions within a period of 3 months from the date of receipt of a certified copy of the order. Full stop. Next para.
But thereafter, my lord, we requested them to, my lord, give the opinion but they're not turned up, my lord. This is the letters, my lord. Whether these letters are coming under the jurisdiction or not, but they not bother to reply to our,
To all that.
because my lord, they are objecting, my lord, for that
Yeah.
is a Archaeological
government.
department.
So if they are aggrieved, they have come before this
That's
court.
what- before
Why are you unnecessarily trying to do something which the appellant has to do?
That's why,
There is a direction issued by the
that's why,
court.
my lord, because of the writ appeal, my
It
lord,
has to-
even we sought the clarification also through letter, my lord. They're not given the reply to that.
During the course of these proceedings, several directions were issued by this court, including directions issued on 3/12/2024, which is extracted herein for easy reference. Purti extract ಮಾಡ್ಕೊಂಡು. Next para. Learned counsel for the appellant submits that the appellant superintending archaeologist did visit the spot and he has taken photographs and he has expressed his opinion to the learned counsel, stating that it appears that from the edge of the monument, the property in question is beyond the prohibited distance. Full stop. Next para. Learned government advocate submits that the deputy commissioner also had
Okay, sir.
requested the superintending archaeologist to furnish his opinion.
No letter dated, my lord. 12/11/2024. ಇಲ್ಲ ಇದು ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಲೆಟರ್ ಇದೆ ಇಲ್ಲಿದೆ.
Through communication dated 12/11/2024. Stop. Next para. Having regard to the admitted fact that various other lands in the same survey number have already been converted and constructions have been put up.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯಾವ ಆಗಿಲ್ಲ, ಬರೀ ಕನ್ವರ್ಷನ್ ಆಗಿದೆ.
Conversion, sir.
Construction ಆಗಿಲ್ಲ.
Construction, police station and other municipal offices are there.
ಅವ್ರದೇ ಇದೆ.
ಅವ್ರದೇ.
ಏನು ಹೇಳಿದೆ? And there are existing buildings belonging to
State government.
the state government and municipality.
Yes.
We are of the considered opinion that there is no merit in the appeal. Full stop. Next para. Accordingly, the writ appeals stand dismissed. Starting ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೇನ್ರಿ? Seeking leave.
Yes.
ಹಾಕಿದ್
Huh?
ಹಾಕಿದ್
ಇದು considered along with the appeal ಅಂತ ಹೇಳಿ. A4 ಅಲ್ಲ, IA number 4.
The interlocutory application filed at the hands of the appellant seeking leave of this court to prosecute this intra-court appeal is allowed, while permitting the appellant, who was not a party to the proceedings before the learned single judge, to prosecute this appeal. Yes. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. Yes.
My lord, in contempt, my contempts are there. Contempts. Contempt petitions, my lord. Yes.
Contempt petition. The writ appeal filed at the hands of the superintending engineer, archaeologist in writ appeal number so and so have been dismissed by order of even date. Full stop. Therefore, the respondent deputy commissioner is granted 2 more weeks time.
One single judge granted 3 months time, my lord. But now Lord writ appeal is dismissed, my lord, at least 2 months time may be granted.
2 more months time from today to comply the directions issued by the learned single. The contempt petition is accordingly disposed of. Yes.
Please. Subject to my lord reviewing.
Liberty is also reserved to the complainant to revive the contempt petition, comma, if necessary.
Good.
Yes.
Public.
Learned government advocate takes notice for response number 1 and 2 contempt petitioner. Please.
Bill number 3030, additional government advocate.
In this matter, my lord, we filed the IA formal IA 1 of 2024. That is my additional grounds, my lord. IA 1 of 2024. IA 1 of 2024, my lord. This additional grounds, my lord, we filed.
That will be considered
Yes,
along
my
with the
lord, because
main.
now, my lord, this was not communicated to the my lord, learned AG, my lord. But that is not instructed this matter to the learned AG. That's why he seeks some time, my lord. Immediately after vacation, my lord, will also file.
This is the matter, my lord, where your lordships wanted to consider, my lord, whether Justice Dikshit's judgment, my lord, regarding reduction in from 50% to 25%. Matter.
Immediately after vacation, any date may be fixed. Additional grounds, my lord, that was not communicated. That is a problem.
Additional ground.
We raised the additional grounds, my lord. Whatever, my lord,
We are not considered on that. One, sir.
Other than that, because of the, my lord, one of our colleague, my lord, is not feeling well, my lord. But that is the reason, my lord, not instructed to the AG.
So this is beyond.
Beyond,
It is beyond, my lord. Connected matters, my lord, your lordships have granted 50% stay subject to deposit of 50%. They, my lord, proposed that it should not be 50%.
Adunu madala bida idralli. We will not do that also. We will dismiss the appeal only on the ground of delay.
After vacation, it is there is on the
Young madrunu, you will come up with some excuse. At the request of learned AGA, list this matter immediately after winter vacation.
Seal number 31, Gurraj B. Achilkar.
But in this case, I filed for stay for execution operation of judgment of trial court, my lord. I am the respondent in family court, my lord. I am the wife of the respondent. Petitioner is the wife of the respondent, my lord. Now in this case, now respondent ready to marry to some other woman. Respondent is ready to day, he was searching the woman for marrying. ಬೇರೆ ಒಂದು ಮದುವೆ ಮಾಡೋಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಯಾವಾಗ್ಲೂ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿರ್ತಾರೆ.
ಇಲ್ಲ ಸರ್.
ಈ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿರೋದು ಜಡ್ಜ್ಮೆಂಟ್ 6th of March 2023.
ಹೌದು ಸರ್.
ಮತ್ತೆ
ಅಲ್ಲಿ ಇಪಿ ಕೇಸ್ನಾಗ ಅಬ್ಸ್ಕೊಂಡಿಂಗ್ ಇದ್ಮೇಲೆ ಪೆಟಿಷನ್ ಆಲ್ಸೋ
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ.
ಹೌದು ಸ್ಟೇ
1.5 ವರ್ಷದ ಮೇಲಾಗಲಿ ಯಾವ್ದೋ ಬೇರೆ ಮದುವೆ ಮಾಡ್ಕೊಂಡಿರ್ತಾರ ಆಗ್ಲೇ.
ಇಲ್ಲ ಸರ್, ಆಸ್ ಪರ್ ಇಲ್ಲ, ಬಿಕಾಸ್ ಆಫ್ he was absconding from Gulbarga city due to non-depositing of arrears amount of EP amount.
ಏನು ಗುಲ್ಬರ್ಗದಲ್ಲೇ ಮದುವೆ ಆಗ್ಬೇಕು ಅಂತಿದ್ಯಾ?
ಇಲ್ಲ ಸರ್,
ಇಲ್ವಲ್ಲ.
ಇಲ್ಲ, ಅದಕ್ಕೆ
ಎಲ್ಲರೂ ಬೇರೆ ಕಡೆ ಆಗಿರ್ತಾರೆ. ಮತ್ತೆ
ಅದಕ್ಕೆ ಆಗ್ಬಾರ್ದತ್ತೆ ನಾನು.
There is a delay, we can't do that.
Yes.
And 1.5 years. Even if we pass an order, it will be of no consequence because ಈಗಾಗಲೇ ಮದುವೆ ಆಗಿದ್ರೆ nothing can be done.
At least to
issue notice to the respondent. Held sufficient.
ನೋಟಿಸ್ ಆಗಿದೆ, ಸಫಿಷಿಯಂಟ್ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಮೇಡಮ್.
ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ ಆಗ್ಲೇ.
ಹೌದು. Notice is issued and summoned before the municipal court, family court, Kalaburagi, in the presence. Summons for issued, notice for served.
List this matter after winter vacation. ಈಗ ಸ್ಟೇ ಮಾಡಿ ಏನ್ ಪ್ರಯೋಜನ? ಒಂದೂವರೆ ವರ್ಷ ಆಗಿದೆ.
ಇಲ್ಲ sir. He was absconding for non-depositing of arrears amount.
ರೀ
Hence he
ಮತ್ತೆ
was-
ಅದೇ ಹೇಳ್ತಿರಲ್ರಿ, ಅದಕ್ಕೂನು ಇವನ್ ಮದ್ವೆ ಆಗೋದಕ್ಕೆ ಏನ್ರಿ ಸಂಬಂಧ?
This is a petitioner collecting all the information regarding the activities and
But despite
attempt-
service of notice, there is no representation for the respondent. Full stop. Consequently, IA number 5 of 2024 is allowed while condoning delay of 54 days in filing the appeal. Full stop. Next para. There shall be an interim order of stay of the impugned judgment in MC number
57 of 17.
file of
Municipal Family Court Kalaburagi. Principal Judge, Family Court Kalaburagi.
comma till disposal of the appeal.
57 of, sorry, madam, 57 of 21, madam. MC number.
I'm not on, but yes.
Seal number 32, Jayashree Bhimaraya.
Appeal against
Yes.
the dismissal of the divorce decree. So husband's appeal. And
Notice. Your petition seeking dissolution of marriage was dismissed.
yes, sure.
Huh?
Yes.
Issue notice to the respondent.
Number 33, AM Maharaj.
This matter, my lord, RCP 9/12/2024 directed me to get the original records, my lord. We received the original records.
ಇದೆ ಮಾಡಿ. ಇದು ಬರ್ತದೆ ಅಲ್ಲೋ. ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲ. ಅದೊಂದು ಚೇಂಜ್ ಮಾಡಿ ಈ ಕಡೆಗೆ ಹಾಕು. ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಇದನ್ನ ಅದನ್ನ ಹಾಕು. ಇದು ಒರಿಜಿನಲ್ 2 ಸೆಕೆಂಡ್ಸ್. ಹಾ.
Yes, ma'am, we received the records, my lord. We intimated to the, my lord, all the voters regarding the defaulter, first, my lord, defaulter list was published in the notice board. Thereafter, my lord, ineligible, my lord, voters list also, my lord, we sent the notice to the ordinary, by ordinary post, my lord, that is.
Who is for the contesting respondent? ನೀವೇ ಚೆಕ್ ಮಾಡಿದ್ರನ್ರಿ?
ಇಲ್ಲ ನೋಡಿ. ಈಗ just ಹೇಳಿ.
ಹಾ?
Just now they told me, now they are making.
ನೋಡಿ ಚೆಕ್ ಮಾಡಿ we will go through it at 2:30.
Please.
ನೀವು ಚೆಕ್ ಮಾಡಿ ಒಂದ್ಸರಿ.
Please.
ಎಲ್ಲ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. We will go through it at 2:30. Yes.
Serial number 44, madam. In this case, party is not present, madam. This daughter is not well, madam. Candidate after vacation.
ನೀವು ಅದರ್ ಸೈಡ್
ನಮ್ಮ ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ ಮೇಡಮ್, ಮಗಳಿಗೆ ಆರಾಮಿಲ್ಲ ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ 44 ಮೇಡಮ್.
ನೀವು ಅದರ್ ಸೈಡ್
appellants.
ಅಜೆಂಡ್ ಮಾಡ್ಬೋದಾ? ಅವ ಅಜೆಂಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದಾರೆ. ಏನಕ್ಕೆ?
ಅವ್ರ ಮಗಳು ಆರಾಮಿಲ್ಲ ಮೇಡಮ್, ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ ಅವ್ರು.
ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ.
ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ ಮಗಳಿಗೋಸ್ಕರ. ಸೊ ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀನಿ.
Learned counsel for the respondent wife
Yes, my wife.
submits that the daughter is unwell
Yes, ma'am.
and therefore the respondent is unable to attend to the court proceedings today.
Yes.
Full stop. Release this matter on 8th of January, 8ನೇ ತಾರೀಕು,
Yes.
2025.
Publish.
Yes. Yes. Huh?
Three appeals which were filed memo for withdrawal.
Same order,
Ade,
same order.
that one was tagged with the contempt.
Ade, ade.
Yes.
That man, I'll take notice for statement. Let it pay the notice of.
Really? State-
ಇದೆಯಾ?
Response number two.
ಅಷ್ಟೇ ಇವ್ರದ್ದು ಬೇಕಿಲ್ಲ. ಅಮರ್ ಗುಂಡಪ್ಪ ಅವ್ರದ್ದು ಬೇಕಿಲ್ಲ. ನಾಟ್ ನೆಸೆಸರಿ. Yes.
Number 33.
I am for the respondent man.
Yes. ನೋಡಿದಿರೇನ್ರಿ?
ನೋಡಿದೆ ಅದರಲ್ಲಿ ಯಾವ್ದು ಸರ್ವ್ ಮಾಡಿರೋದಕ್ಕೆ ಇಲ್ಲ ಥ್ರೂ RPID there is no such documents. Even I inquired with them. I'm not I verified. There is no documents forthcoming that they have issued the notice through RPD and that was served to the all the members.
No, the final list of eligible and ineligible candidates is issued by whom?
ಇಲ್ಲಿ ಇವರು ಇದರಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿರೋದು
ಇದು corporate
ಮ್ಯಾನೇಜರ್
rules. Last time
ಹೌದು
we were
ಹೌದು.
noticing, it
ಹೌದು.
is only the district
election officer
election officer
Election.
who is empowered to issue that list. Although all information is required to be forwarded by the CEO.
CEO, but the voters list has to be.
Final list has to be issued by the district election officer.
ಹೌದು.
Who has issued this?
ಮ್ಯಾನೇಜರ್ ಅಂತ ಸಿಗ್ನೇಚರ್.
ಅದೇನೆ.
ಅಲ್ಲ, ಚುನಾವಣೆ ಅಧಿಕಾರಿಗಳು ಅಂತಾನೆ ಇದೆ ಸರ್. 228, 227A ಅಂತ ಇದೆ ನೋಡಿ ಸರ್, ಪೇಜ್ ನಂಬರ್ ದಲ್ಲಿ. 267A. ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಸಹಕಾರ ಸಂಘದ ಜಂಟಿ ನಿಬಂಧಕರು ಕಲಬುರಗಿ ಪ್ರಾಂತ.
ಅವ್ರು ಇಶ್ಯೂ ಮಾಡಿ
ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರಲ್ಲ,
ಹೌದು.
ಯಾರು ಇಶ್ಯೂ ಮಾಡ್ಬೇಕಂತ
ನಿಮಗೆ ಲಿಸ್ಟ್ ಪಬ್ಲಿಷ್ ಮಾಡಿ ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಗೆಲ್ಲ ಕಾಲ್ ಫಾರ್ ಮಾಡ್ತಾರೇನ್ರಿ?
ಇಲ್ಲ ಅದೇ ಯಾವ್ದು ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ
ಇವನ್ ದಿ
requirement is that
voters
you have to informed. Objection should be called for.
ಹೌದು ಅದು ಆ ಟೈಪ್ ಯಾವ್ದು ಇಲ್ಲ.
ಮತ್ತೆ
13D, my lords. Your lordship is referring last 13.
yes.
ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
Sub rule 5.
Yes. The election officer has to hear and dispose of the
The chief
objection.
executive of every cooperative society shall prepare a draft list of the eligible members or representatives and delegates with a right to vote, a list of members whose repayments will fall due before the date fixed for publication of final electoral roll, list of defaulters, a list of other members
representatives
or representatives and delegates
who are
who are not eligible to vote at a general election, indicating the reasons for ineligibility member wise on the basis of entries in the updated membership register specifying the name so and so and submit the said lists to the election officer along with the related books, records and documents and any other information as the election officer may require at least 60 days before the date of election. The cooperative election authority shall call upon the chief executive of the cooperative society to obtain from the member society the name of an authorized member so and so. The final electoral roll shall consist of the following, so and so, so and so. A copy of such electoral roll in respect of each society shall be kept open for inspection in the office of such society, as also in the office of the election officer. Subsection 3. The election officer
shall take steps for publication of voters list in the following manner, namely for publication of draft
election
eligible.
officer. ಅದಕ್ಕೆ ಮೇಲ್ಗಡೆ
2A. By registered post and an opportunity.
ಅಲ್ಲ 2 sub-rule 2 ಓದಿ.
The cooperative election authority shall, on receipt of such reports from the election officer containing the list of cooperative societies where the elections are due, publish the calendar of events for preparation of electoral rolls and the conduct of the elections of the boards of the cooperative societies, indicating the name and address of each society. The election officer shall take steps for publication of voter list who are not eligible to vote in the following manner, namely for publication of draft ineligible electoral list, the chief executive of every cooperative society shall prepare notice in respect of members not attending 3 out of the last 5 annual general body meetings and members not utilizing such minimum services or facilities in a cooperative year as specified in the bylaws for 3 consecutive cooperative years. The chief executive of every cooperative society shall send above prepared notice to all ineligible members 15 days prior to 6 months to the date of election of the board by registered post, and an opportunity shall be given to such member to file their objections, if any, within 15 days from the date of notice. The chief executive officer.
Election officer definition may kind. Aito. Let us take it that the election officer only. All these procedures have to be followed, registered notice have to be sent.
The apex court judgment, my lord, writ petition itself is not maintainable. Subsequently, my lord, this honorable court, however, my lord, single judge, may I request, my lord, may I rely on this judgment? Total, that exercise is also, my lord, sir, by virtue of single judge order. May I request, my lord, one judgment of this honorable court while. Single judge order. Single judge. I may be permitted to rely this. Para 10, my lord. Earlier 13, rule 13, T2A, after referring that, my lord, these provisions do not leave any room for doubt that an excluded member with a publication of a draft eligible electoral list must have an opportunity by way of an individual notice to file objections on exclusion from the electoral list
it must be shown that the concerned chief executive has prepared and sent a notice to the affected members. The public notice dated 8/11/2021 does not meet these requirements. In fact, it is admitted on the behalf of respondent that there are deficiencies in the preparation of final electoral after publication of the draft eligible electoral list, and the petitioners have not been issued with individual notices. The Honorable Supreme Court, my lord, just now, last date of hearing, I have referred that judgment, my lord, para 7 has extracted.
Yes.
Para 12, my lord. In view of the above our finding that preparation of electoral roll is being an intermediate stage, the process of election of the managing committee of a specified society, the election process having been set in motion, it is well settled that the High Court should not stay the continuation of the election process, even though there may be some alleged illegality or breach of rules while preparing the electoral roll. It does not dispute that the election in question has already been held and the result thereof has been stayed by the in order of this court, and once the result of the election is declared, it would be open for the appellant to challenge the election of a returned candidate if aggrieved by the means of an election petition before the election tribunal. It follows from this decision, the adjudication of all questions must be as provided under section 70 subclass 2 of the Cooperative Societies Act. Dispute which may refer to the registrar for the decision or notwithstanding, they have referred the 70s. The respondent, despite admitting deficiencies in finalizing the final electoral list, want to invoke the rule alternative remedy. This court is of the considered view that the peculiarities of this case, the petition should be disposed with a direction to the concerned respondent to announce the results, counting if even the vote cast by the petitioners with a liberty to all the concerned to the avail remedy under section 72. Even though, my lord, this court has held that, my lord, they can approach the tribunal for the election dispute after conclusion of, my lord, election. In the present case, my lord, that stage of, my lord, nomination.
If you see the last paragraph.
Yes.
Of that order.
Yes.
It is clear that all those persons were also permitted to take part in the election.
Voting, they are permitted to vote. That in that case, my lord, the vote is permitted. Earlier, my lord, they have come before the court, my lord. In the present case, my lord, 12/8/2024 was notification. And nomination for filing the nomination was on 23/8/2024 is last date. 31st after, my lord, 7 days, 31st/8/2024 date of election was fixed. Writ petition was filed on 19/8. 23/8/2024, there was, my lord, completion of, my lord, filing nomination. After 3 days, my lord, writ petition came to be allowed.
Yeah, see, we have been noticing this kind of discrepancies. I don't know from how many years now. In all our judgments, we have found the same thing. That you are not following the procedure. You don't want to follow the procedure. But you will come and say, no, let them raise a dispute under section 7. Despite all these observations, that there is deficiency, they have not followed the procedure, there is no notice issued, and they have placed in the list of ineligible candidates. They are not allowed to take part in the election. And only those persons, very few, not even 10% of the members are now eligible for contesting in the election. And they want the elections to go on.
There is
Should we
fault
hold
of
that the officers are doing it deliberately?
Deliberately,
Then,
my lord.
in spite of all this,
But election officer, my lord, issued the notice to the, my lord, kindly see, this is the order, my lord, directing the court of.
see, registered Post. Notice have to be issued to every candidate.
Ordinary
Calling
notice.
for objections.
Ordinary
ಮತ್ತೆ
notice.
ಏನ್ ಮಾಡೋದು?
Really, can you see, but this is the order, my lord, issued to the, my lord.
ಏನು?
Ordinary notice.
ಏನಿದು?
This is the order by the, my lord, election officer to the, my lord, issue the notice and get the, my lord, finalize the.
ಯಾರು ಮಾಡ್ಬೇಕು? ಯಾರಿಗೆ ಹೇಳಿರೋದು ಇವ್ರು ಡೈರೆಕ್ಷನ್?
ಈ ಚಿಕ್ಕರಿಗೆ
ಹಾ?
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಮೇಲೆ ಕಳಿಸಿ. ಬಿಲೋ ಕೆಳಗಡೆ ಅಡ್ರೆಸ್ ಇದೆ.
Election officer,
ಎಲೆಕ್ಷನ್ ಆಫೀಸರ್ ಕೊಟ್ಟಿದ್ದು.
ಅಧೀಕ್ಷಕರು
joint register of cooperative societies, ಅವರೇ election officer.
ಅವರೇ election.
ಅವರೇ ಇಶ್ಯೂ ಮಾಡಿದ್ದು.
Joint
He
register
only
of
issued the
cooperative
order.
societies and election officer.
ಅವರ ಆರ್ಡರ್ದಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ ಬರ್ತಾರೆ ಸರ್.
ಎಲೆಕ್ಷನ್ ಆಫೀಸರ್.
ಹೌದು.
Election officer.
ಆರ್ಡರ್ದಲ್ಲಿ ಎಲ್ಲ ಬರ್ತಾರೆ.
Our superintendent of.
No, that is why we said it is the district election officer who has to do all this.
ಸರಿ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಹಾ.
ಆದೇಶ ಮಾಡಿ.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
That is the order is issued by him, my lord. Thereafter, next page is the, my lord, that is the list, my lord. We requested the, all the members to pay that, my lord, arrears.
Registered notice to every member.
ಅವರ ಆರ್ಡಿನರಿ ನೋಟಿಸ್ ಕಳಿಸಿದ್ದಾರೆ.
We said,
ಆರ್ಡಿನರಿ ನೋಟಿಸ್ ಕಳಿಸಿದ್ದಾರೆ.
do not send the
Registered
arrears to post, my lord, but it is communicated to them. In spite of that one, they not
Calling
made
for-
any objection.
Calling for objections.
Yes, well, we call for the objection.
ಎಲ್ಲರಿಗೆ ಆರ್ಡಿನರಿ ನೋಟಿಸ್ ಕಳಿಸಿದ್ದಾರೆ. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಮೆಲೋಡ್ಸ್ ಆರ್ಡಿನರಿ ನೋಟಿಸ್ ಕಳಿಸಿದ್ದಾರೆ ಎಲ್ಲರಿಗೆ.
ಕಳಿಸಿದ್ದಾರೆ, ಅದು ಮುಟ್ಟಿದೆ ಅಂತ ತೋರಿಸೋದಕ್ಕೂ ಇಲ್ಲ, ಆರ್ಡಿನರಿ ಪೋಸ್ಟ್ಗೂ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
This was second page, my lord, it was.
Ordinary post ಕಳಿಸಿರ?
ಹೌದು.
ಎಲ್ಲ ಐತೆ ಅದು ಲೆಕ್ಕ?
ಅದೇನ
How much amount you asked, ಸ್ಟಾಂಪ್ ಬೇಕಲ್ಲ, ಎಷ್ಟು ಸ್ಟಾಂಪ್ ಖರೀದಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದು?
ಅದ್ರಲ್ಲಿ
ಅದೆಲ್ಲ ಇಲ್ಲ.
ಎಲ್ಲ ಇದೆ, ಅದನ್ನು ಕೂಡ ಕಳಿಸಿದ್ದು. ಕೆಲವು ವಾಪಸ್ ಬಂದಿದ್ದಾವೆ ಸ್ವಾಮಿ, ಕೆಲವು.
ಅಲ್ಲ, ಅದಿದ್ರು-
ಹೊರಗಿದೆ. ಅದರಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ, ಆರ್ಡಿನರಿ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ವಾಪಸ್ ಬರಲ್ಲ ಅವು.
ಬರಲ್ಲ.
ಬರಲ್ಲ.
Acknowledgement ಇರಲ್ಲ.
ವಾಪಸ್
ಬರಲ್ಲ. ಈ ಸರ್ವ್ ಆಗಿದೆ ಅಂತ ತೋರ್ಸಕ್ಕೂ ಏನಿಲ್ಲ.
ವಾಪಸ್ ಬರಲ್ಲ ಅವು. ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಆದ್ರೆ ಮಾತ್ರ ವಾಪಸ್ ಬರ್ತದೆ.
ದಟ್ ಈಸ್ ವೈ ದಿ ರೂಲ್ ಸೇಸ್
Admittedly, my lord, substantially there is no compliance. Substantially there is no compliance. Notice is issued by ordinary post. Even then also, my lord, apex court held that, my lord, these appellants are, my lord, there are no fault on these appellants. They have contested and at the stage of declaration of results, my lord, order was passed. Election has been held. ಇಲ್ಲ ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಆಗಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ.
Date election ಆಗಿಲ್ಲ. Correct. Even before all that, the writ court has interfered. Yes, yes. 12, date of election is, my lord, on 31/8/2024.
Calendar of event ಏನೇ ಮಾಡಿದ್ರು ಅವ್ರು ಹೊಸದಾಗಿ ಆ ಇದನ್ನಲ್ಲಿ ಮಾಡಕ್ ಬರಲ್ಲ.
Lord, this is the notice, my lord. They only acknowledge the some of the notice.
Acknowledgement.
ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ
ಇವೆಲ್ಲ complaint
they will have to give opportunity.
ಹೌದು ಮಾಡಿ.
They do not want that.
ಅಲ್ಲ, ಈಗ ರಿಟರ್ನ್ ಏನಂತ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿ ಎಲೆಕ್ಷನ್ ಡೇಟ್ ಮುಗಿದೋಗಿದೆ.
ಅಲ್ಲ, ಮಾಡಿದ್ರು ನಾವು if we ask them to issue fresh calendar of events,
ಅವಾಗ
but
ಆಫ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ ಆಲ್ ದಿ
no, they do not want all that complaints.
ಯಾಕಂದ್ರೆ
They want them to go raise a dispute under section 70.
because the reason that only few members were made eligible.
Not conducted, and therefore they are relying upon the judgment of the Supreme Court, which says no court should interfere. But
ಸಿಂಗಲ್ ನೇಚರ್ ಆಲ್ರೆಡಿ
ಆಯ್ತು. From where election was stopped, my lord, from that day your lordship can, this court can, my lord. Adene, you want from that stage? Yes. Exactly, ma'am.
The few of the constituencies.
Acknowledge ಮಾಡಿದಾರೆ ಕೆಲಂದ್ರಲ್ಲ.
ಕೆಲವೊಬ್ರು ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ, substantially not complained, my lord.
Last
3,000-4,000 ಜನಕ್ಕೆ
3,000-4,000 ಜನ ವೋಟರ್ಸ್ ಇದ್ರೆ ಇಟ್ಸ್ ಡಿಫಿಕಲ್ಟ್ ಮೆಲೋಡ್ಸ್.
ಹಂಗಾಗಲ್ಲ ಸರ್. This will not be in compliance.
Because their knowledge of this.
If a no. If a particular procedure is prescribed, you have to follow the same thing.
That is the register post that means, my lord, it has to be served to the society. That is
You
the.
can't interpret it in a different way. Only if there is some ambiguity, you can say so. There is no ambiguity. The requirement of law is that you will have to send it by registered post.
That is, my lord, that is not certain.
So that is why we are saying these kind of observations have been made by this court from at least 4 or 5 years now, or maybe even before that. Why do you not want to follow the procedure?
Some lack of the.
Already, the cooperative department is concerned with all this.
Yes.
When it has suffered orders like this at the hands of this court, saying this is the procedure prescribed, you are not following it, and therefore we are quashing the action and asking you to redo it. ಎಷ್ಟು ಸರಿ ಹೇಳಬೇಕು ಅದನ್ನ?
Next other.
Once if it is said so, should you not circulate the information to all the election officers and say this is the procedure prescribed and please follow it?
There is a circular also. My lord.
What is the use?
It's the practical difficulty, my lords. In case of a credit society, it depends on their financial status, my lords. If their NPA is more than 20% and the members were 3,000 to 4,000, my lords, it's not possible for them to, my lords, to issue register post because of the financial this thing, my lords. And your lordship may kindly see section 39 capital A, which contemplates, my lords, 6 months before prior to the date of election.
Correct.
Rule 13D says, my lords, the election officer has to collect all the information within the district within 120 days, my lords. Subsection 2A contemplates, my lords, in regard to 15 days, 30 days. As regards issuing of a register post is concerned, my lords, practically impossible, my lords. If in case there are 3,000, 4,000 members, my lords. My lords, it is the member who has to take interest in the cooperative movement. It's always not the fault of a officers, my lords. Sometimes members, they don't come forward and participate in AGM, my lords. AGM, my lords, section 14AJ contemplates, my lords, it's not possible to issue notice to all. Therefore, my lords, there is a provision contemplating that, my lords, the cooperative society may publish the notice in the newspaper, my lords.
That was done.
That was done, my lords, in the instant case.
Page, my lord, you know,
14,
page 1.
as regards AGM, my lords.
No.
Annual general body meeting.
You can't try to read in some other provision for this. ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
My submission, my lords, 14AJ contemplates the members needs to participate in all 5 general meeting, my lords. The cooperative society issues a notice in the newspaper, my lords, in terms of the provision. They did not turn up, my lords. Later, at the time of election, my lords, they rushed to court for voting rights.
ಇದರಲ್ಲಿ on 10/7/24, one of the member made an specific objections, my lords, by filing a representation. Since from last years there was no meeting was held, and now you are issuing the notice. Therefore, that first notice meeting has to be held. Then the proceedings may be conducted. ಅದಾದ್ಮೇಲೂ ಕೂಡ ಅವರು ಇದಕ್ಕೇನು ರಿಪ್ಲೈ ಮಾಡಿಲ್ಲ. ಇಬ್ರು ಮೆಂಬರ್ಸ್ ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ. who are residing at Manvi town. Because they will available, they know not newspaper and all other things.
Meeting ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. Audit ಎಲ್ಲ returns file ಮಾಡ್ತಾರೆ. There is a procedure under the act. Every year returns file ಮಾಡ್ತಾರೆ ಅವ್ರ authority. ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ it's a default, my lords. Then there are other consequences in the act.
And few of the constituencies, my lords, there are no eligible candidate is also there, not there. Eligible voters is not there.
And there is a classification of members in the bylaw, my lords. In the instant case, there are borrower members, non-borrower members, government is also a member, and other cooperative society is also a member, my lords. As regard borrower is concerned, my lords, they are saying they send the notice by way of register post, my lords, to all the defaulters. If they did not come forward and file objection, my lords, there is no question. The chief executive officer to
See,
put
this
all the
order
files
was
to.
passed on 22nd of August 2024.
Yes.
Huh?
Oh,
reserving liberty to the authorities to comply with the requirements of law, publish the list of ineligible voters, and thereafter conduct the election. If you had kept quiet, by this time election would have been held. ಇಷ್ಟೇ
I have filed the writ appeal on 21st
ಅದೇ.
September. Since I am not the party to the writ petition.
Correct,
I
sir.
have filed the separate IFR leave.
ಹ್ಮ್.
ಇವ್ರಿಗೆ
If-
ತಾವ್
if-
ಹೇಳ್ದಂಗೆ
if- If you had not
Declaration.
filed, if you had not filed this appeal, by this time election would have been held.
Someone has
After-
contested to, I am uncontested. Some of the appellants are uncontested.
ಇಲ್ಲ
Only
ಮತ್ತೆ
single candidates
ಮತ್ತೆ
are there.
ಇನ್ ಪರ್ಸನ್ ಟು ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿರ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಇಲ್ಲಿ ಇಷ್ಟುವರೆಗೆ ಎಲೆಕ್ಷನ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಅಗೇನ್ ವಿ ನೀಡ್ ಟು ಕಂಪ್ಲೈ ಮಿಲೋಟ್ಸ್ ಆಲ್
6 months ಆಗ್ತಿತ್ತು.
ಅಗೇನ್ 6 months ಆಗ್ತಿತ್ತು.
ಅಲ್ಲಿ ಆ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಕ್
6 months ಆಗ್ತಿತ್ತು. ಇಷ್ಟೊತ್ತಿಗೆ ಎಲೆಕ್ಷನ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
August 2024.
ಇಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ ಆಲ್ ವಿ ಆರ್ ಇನ್ ದಿ ನಿಯರ್ ಅಬೌಟ್ 6 months.
ಹೌದು. ಇಷ್ಟೊತ್ತಿಗೆಲ್ಲ ಆಗೇ ಹೋಗ್ತಾ ಇತ್ತು.
ಅಲ್ಲ ರಿಪೀಟ್
Probably
ಮಾಡಿ
in a few days time
ಎಲೆಕ್ಷನ್ ಇರ್ತಿತ್ತು ಈಗ. And by complying all the necessary procedure.
If, my lord, they are ineligible, they are now also ineligible.
ಇವನ್ ಇನ್ ಕೇಸ್
Correct.
ಇನೆಲಿಜಿಬಲ್ ಆಗ್ತಾರ.
Ineligible act.
ಹೌದು.
Only compliance of 13D ಅಷ್ಟೇ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಹಾ. ನೀವು ಸುಮ್ನೆ ಇದ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು ಇಷ್ಟೊತ್ತಿಗೆ.
ಅವ್ರ ನಾಮಿನೇಷನ್ ಫೈಲ್ ಸ್ಟೇಜ್ ಬಂದಿದ್ದಾರೆ ಹಂಗಾಗಿ ರಿಟ್
Stage of nomination file ಮಾಡಿ. Dates may be kindly seen, my lord. Nomination last date is 23/8/2024. Date of election is 31/8/2024. Writ petition was filed on 19/8. 22nd writ petition allowed.
Even my lord, 2 meetings were they are not appeared, not present.
See,
Appear.
we can't go into all those.
You see, we published it.
ಡಿಸ್ಪ್ಯೂಟೆಡ್.
See, this court is not going to go into all these aspects. But it is a fact that even after going through your original records, it is clear that you are not followed the procedure. And what is the direction issued by the learned single judge?
Comply the
Follow the
procedure.
procedure.
ಮಾಡಿ ಅಷ್ಟೇ ಹೇಳಿರೋದು.
Because of this writ appeal, my lord.
ಹಾ. ಏನ್ ಮಾಡೋದೀಗ?
Next time, my lord, there may be direction to comply this section 13, rule 13(2)D, my lord.
Hmm.
And this time, my lord, from
Please
the-
understand the consequences. Despite observations of the High Court that there is no compliance of the procedure. And if this court were to allow your appeal only on the ground that this is the law laid down by the Honorable Supreme Court and therefore we should not interfere. Immediately they'll raise a dispute under section 70. Only on the basis of the observations of this court, that petition has to be allowed.
An entire election has to be.
that is there.
Do you understand the
Yes, yes.
consequences? What purpose would be served? Please take instructions from your client.
Yes.
We have to make such observation.
Yes, yes.
That we are now, since now we have secured the original records, we will say,
There is not a compliance.
Ah.
Yes.
so therefore, we allow them to go and raise a dispute. Only on the basis of this observation that petition should be allowed.
We'll seek. Instruction.
Hmm?
I will seek instruction.
The learned government advocate has secured the original records from
ಎಲೆಕ್ಷನ್ ಆಫೀಸರ್, ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟರ್,
joint registrar
ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ,
of cooperative societies and district election officer.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಎಲೆಕ್ಷನ್ ಆಫೀಸರ್.
Full stop. The learned counsel for the appellant as well as learned counsel for the contesting respondents were also permitted to look into the original records. Full stop. It is quite clear that many of the procedures prescribed in Rule 13D have not been followed before publishing the list of ineligible voters. Full stop. Next para. However, we have requested the learned counsel for the appellant to secure instructions at the hands of the appellants to enable the withdrawal of this appeal so that the directions issued by the learned single judge will be complied and thereafter the elections could be held to the society. Full stop. Next para. Yavag beku? After vacation, or day after tomorrow?
Day after tomorrow, it may have taken, I will seek it.
Ade, stay kotilla, they are required to comply that direction issued by the learned single judge. ಅದನ್ನು ಏನು ಮಾಡಿದ್ರು ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ ನನಗೆ.
ಅದನ್ನು ಇನ್ನು ಏನು ಅವರು process is not started. ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನು ಸ್ಟೇ ಇಲ್ಲ.
No stay.
ಒಂದ್ಸಲ ಫೈಲ್ ಆಯ್ತಂದ್ರೆ ಅವ್ರು ಸುಮ್ಮನೆ
ನೋಡಿ ಹಿಂಗೆ ಆಗೋದು. Release this matter on 20th of December.
After vacation.
After vacation ನಾವು ಸಿಗ್ತೀವಿ. After vacation. List this matter after vacation.
Number 35, Subhas Mallapur.
Original records is not required, my lord, that you also say that.
ಇದೇನಾಯ್ತಿದು?
The previous matter ದಲ್ಲಿ
ಮುಂಚೆ
previous matter ದಲ್ಲಿ original records is not necessary ಅಂತ ಹೇಳಿದ್ರು. Original records, my lord, not necessary to produce.
We have not taken it on record. Yes.
Insurance of the. Insurance of the.
Accident between motorcycle and trailer. The trailer was stopped.
The same insurance company appeals ಅಲ್ಲಿ. Delay of 2 days.
Yes.
Is condoned. We will condone. 50%. Yes. Issue notice to all the respondents,
Yes.
Yes.
Case number 36, Sudarshanam.
My lordship, I am appealing for the appeal, my lord. It is a KNL matter, my lord. KNL has preferred the appeal. It is similar to the yesterday matter, my lordship. They have filed execution petition in this matter, my lord. So we have sought for a stay.
ಅದೇ ರೀ, which is that order of stay that we have passed.
Yesterday matter, my lord, 201014 of 24.
Same order.
Case number 31.
Yes.
Obligement.
Case number 37, GG Chakshakti.
My lord, I appear for appellant in this matter, my lord. My lord, I am appearing for claimant appellant, my lord. The trial court has awarded 8,35,000 in this matter, my lord, against which we have filed an appeal for enhancement. In the meanwhile, we have filed an application seeking release of amount in deposit, my lord. And along with the trial court records, the said application is submitted to this honorable court, my lord. Hence, an application is filed, my lord, to send the trial court records to the trial court, my lord, to consider my application seeking release of amount in deposit, my lord.
This is claimant's appeal.
Claimant's appeal, my lord. Insurance has not referred. Claimant's appeal, my lord.
Claimant's appeal for enhancement.
Yes, my lord.
And 2024 matter.
Yes, my lord. Amount in deposit, I am seeking a release of amount in deposit, my lord.
PCR record prescribed, IA number 2/2020.
Order on IA number 2 of 2020. This application is filed by the appellant claimant to return the trial court records to the tribunal, to enable the appellant claimant to seek release of the amount deposited at the hands of the respondent insurance company. Full stop. Next para. Accordingly, we allow the application and the office is hereby directed to return the trial court records to the Motor Accident Claim Tribunal number 7, Vijayapura. Full stop. After completion of the formality of releasing the amount to the claimants, the tribunal shall re-forward the trial court records to this court.
Number 38, for the appellant, the claimant's appeal for seeking enhancement. There is a delay of 71 days in filing the appeal. Notice was served in the my appeal.
My lordship, my humble submission, connected is the company appeal, my lordship. Challenging liability, there is a 9 days in delay in filing the appeal, my lordship. Please, and also meanwhile, the
Notice
stay
has
may
got-
be granted in company appeal, my lordship.
At least 50% may be permitted to withdraw the lordship.
Idರಲ್ಲಿ connected appeal ಅಲ್ಲಿ
I will take notice for respond number 1 to 3 minutes.
ಕೂಡ ಸಿದ್ದಪ್ಪ undertakes to appear for
1 to 3 minutes. Respond number 1 to 3.
Please,
ಆಮೇಲೆ
Issue notice to the respond number 4 minutes. Owner of the vehicle.
owner of the vehicle,
respond number 4.
please.
Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned counsel for response number 1 to 3. Delay of 9 days expira in filing the appeal is condoned. Full stop. In MFA 20244 of 2024 ಅಲ್ಲಿ
72 days.
condone delay of 71 days in filing the appeal is condoned. And accordingly, IN number 1 of 2024 is disposed of. Idರಲ್ಲಿ IN number 2 of 2024. Yes.
In connected matter, stay may be granted, ma'am. Company appeal, challenging liability.
Appeal ಅಲ್ಲಿ there shall be an interim order of stay of the impugned judgment and award passed in MVC 25 of 2022 on the file of the principal senior civil judge and MACT 5 at Vijayapura, subject to the appellant depositing 50% of the award amount before the tribunal, within a period of 6 weeks from today.
It's a
Public,
Next para. Liberty is also reserved to the claimants to seek release of 50% of the amount which is directed to be deposited at the hands of the insurance company
along with interest. 50% along with interest.
along with interest.
public,
Number 39. In this case, the claimant's appeal for seeking enhancement, the respond number 2 is the company is also prepared an appeal. Madam is filing the respond number 2 is direct to take notice. In my appeal, claimant's appeal.
Learned counsel Srimati Sangeeta Bhadrashetty.
For respond number 2 minutes.
So,
Respond number 2 minutes.
respond number 2.
Notice has go to respond number. Issue notice to
Full stop. Issue notice to respond number 1.
in their appeal. I already filed.
9.19, it is,
Connected appeal ಅಲ್ಲಿ
ಇದರಲ್ಲಿ I have filed
Learned,
second set of appeal.
counsel Sri Papakoda
Already gave it filed 1 to 4 minutes.
has entered appearance for response number 1 to 4.
And notice has been go to respond number 5 minutes.
Is to respond number 5. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned counsel for response number 1 to 4. Full
My
stop. Next para.
My lord, this is a ECA case, my lord. Statutory deposit, we have entire amount along with interest we have deposited before the tribunal, my lord. Hence, interim stay may kindly.
Statutory amount
Statutory amount, my ECA Act case this is,
Hmm.
we have to deposit entire amount before the tribunal, we have deposited.
Entire amount.
The entire amount with interest, my lord, 18 lakh it is.
Hmm.
We have deposited interim stay.
There is a there is no application, Lord. There is
I have filed my-
non-compliance of office eviction is there, Lord.
It's a, earlier it was, my appeal was filed before single bench, my lord. Today I have filed a second set
ಏನ್
also.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಷ್ಟೇನಾ ಅದೊಂದೇನಾ?
Objections,
ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಂತೆ?
delay is also there, my lord.
Huh?
In our appeal also delay is
ಅಪ್ಲಿಕೇಶನ್
there.
ಹಾಕಿಲ್ಲ.
ಹಾಕಿದ್ದೀನಿ.
ಕಂಡು-
Today I have filed, my lord.
You have filed.
Yes, my lord.
ಆಮೇಲೆ
Second set is also filed.
ಹಾಕಿದಾರಂತೆ.
Also filed
ಹಾಕಿದಾರಂತೆ.
today.
So you have complied.
Yes, my lord.
You have complied with all the.
I have to terminate appeal, ma'am. Meanwhile, I will comply the office.
Maintainability.
The receipt has not produced, Lord. That is,
I have produced it today, my lord.
That also you have produced.
Yes, I have.
Learned counsel for the appellant submits that all the office objections have been complied
Yes,
except the pagination,
pagination.
which will be done
Yes,
in a couple of days.
yes, my lord.
Next paragraph. Since the appellant insurance company has deposited the entire award amount
With interest, my lord.
along with interest,
Yes, ma'am.
accrued interest, comma, there shall be an interim order of stay of the impugned judgment and award
Yes, ma'am.
until further orders.
Yes, ma'am.
Yes.
at least 50% amount release the claimants, Lord. They are already deposited the amount, Lord.
Huh?
Subject to result of the appeal, Lord.
We have challenged liability, my lord, and as per the act, we have deposited the entire amount, my lord.
Alla sari.
That-
Even if you
Yes.
Immediate-
challenge liability in all the cases, we are directing at least release of 25%.
Please.
Yeah? ಎಷ್ಟು ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ ಇದ್ರಲ್ಲಿ?
Entire
18
amount.
lakhs, 18 lakh. 18 lakh have deposit.
12 lakhs, 25,000 along with interest.
18 lakhs.
12 lakh is the award and with interest it is
18 lakhs.
18 lakh 30,338.
Ian, what is the ground you are saying you are not liable?
That risk of the disease was not covered on that.
Huh?
Risk of the disease was not covered.
ಇಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
With the-
ಅವ್ರದ್ದು
Already the policy is covered, Lord. It is seating capacity 2+1.
Huh?
Seating capacity is 2+1 is covered, Lord. There. As per the package policy, moreover, the arising up in the course of the employment, Lord, he was died, Lord.
The insurance policy issued by the appellant does not cover the risk of coolies or laborers. That is your contention.
Yes, ma'am. Disease was a coolie ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ.
Even though the section 100 of the motor vehicles rules, 7% are covered. 7% are legally covered in the act. Driver, including driver.
ಏನ್ ವೆಹಿಕಲ್ ಇದು?
A lorry.
Truck it is.
Lorry.
Rule 100 of
Yes.
Karnataka motor vehicle rules.
All of ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರಾ
Yes,
ಇದ್ರಲ್ಲಿ
cancel ಮಾಡಿದ್ರು.
impute order?
The package policy is to say that the moreover is the package policy, including all the including labors covers. The liability policy is not covered.
I thought the owner has denied that he was engaged. Only for loading and unloading ಅಂತಿದೆ. The owner has denied the employment itself, my lord.
ಏನಮ್ಮ?
The owner has appeared and he has filed a return statement and he has denied the employment itself, my lord. He says,
Employment.
yes, my lord, he has not engaged the deceased for loading and unloading ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Then who is he? You please see rule 100.
That is there for, that is for loading and unloading only, my lord, not for
Okay.
traveling, my lord.
No, provided that the owner or the hirer or a bona fide employee. You claim to be an employee,
Yes, my lord, employee.
but he is denying that you
Owner
are.
has denied, my lord.
My lord, the admitted fact that the accident is occurred on my lord, during the course of the employment, FIR is against my lord, charge sheet is filed against. They are not challenging the charge sheet before any competent authority, before this court or my lord, any authorities. My lord. He is on that basis, my lord, all the papers, records, police records, my lord, the tribunal commissioner has rightly concluded that even though policy is the package policy, rules as per the 100 is cover 7 persons.
What?
He's working
evidence
as a
have you-
pulley, my lord.
Huh?
He was working as a pulley in the lorry.
Evidence have you placed on record?
My lord, he is in the complaint itself is dated, my lord, the
What evidence have you placed on record, sir, to show that you are his employee?
or he is engaging them also with stones.
Evidence have you placed?
Plus, the husband is the complaint before the also. He was doing the pulley works also. Both of them are working as in the respond number 1 mercy.
Wife died, my lord.
Yes.
Question frame ಮಾಡಿಲ್ಲ. ಇದುವರೆಗೆ ಪೂರ್ತಿ question of fact. ಇವ್ರು ಎರಡೇ question ಹೇಳಿದ್ರು. ಇವ್ರು ಆ question ಹೇಳಿಲ್ಲ. Substantial question of law ದಲ್ಲಿ. They have not raised that.
Whether the trial court
Insurance company.
is justified in passing liability upon the appellant insurance company to pay compensation without applying provisions of law. You have to be specific, madam. ಸುಮ್ನೆ ಈ ತರ ಜನರಲ್ ಆಗಿ ಹೇಳ್ಕೊಂಡು ಹೋದ್ರೆ it cannot be called as a substantial question of law.
Relationship ಡಿಲೇ ಮಾಡಿಲ್ಲ. Between employer and
Relationship-
employee.
relationship- Regarding relationship, I have not taken the.
ಮತ್ತೆ ಅದಕ್ಕೆ
substantial
ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿದ್ರಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದ್ರು.
But in the
You have not raised
judgment,
that point in your substantial question of law.
I have not raised that point. But he has stated in the, before the tribunal.
ಇದಕ್ಕೆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡೋದಕ್ಕಿಂತ ಮುಂಚೆ we'll have to say this is substantial question of law. ಅಲ್ವಾ?
Question frame ಮಾಡಿ.
At the time of admission,
Admission ಏನೋ ಮಾಡ್ಬೋದು.
admission time.
ಅಲ್ಲ ಅಡ್ಮಿಟ್ ಆದ್ರೆ ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಇಲ್ಲ ಬರಲ್ಲ.
Unless and until
Frame ಮಾಡೇ ಕೊಡ್ಬೇಕು.
ಇದರಲ್ಲಿ ಇವ್ರದ್ದು ಕಂಪನಿ ಅಪೀಲ್ ಅಲ್ಲಿ the substantial question of law framed by the appellant is as follows ಅಂತ ಹಾಕೊಂಡು extract ಮಾಡ್ತೀನಿ. Next para, however, on hearing the learned counsel for the appellant and the learned counsel for the respondent claimants, we find that it is the contention of the appellant insurance company that the owner of the vehicle has entered the witness box
No,
and has
yes.
stated
He has
that
filed, he has filed written statement.
You have not entered a witness box.
No, my lord.
ಮತ್ತೆ ಅದಕ್ಕೆ ಏನ್ ವ್ಯಾಲ್ಯೂ ಐತಿ?
has filed a written statement clearly stating that the deceased,
Yes, deceased Gangubai.
the deceased Gangubai
Yes.
was not his employee. Full stop. It is therefore contended that having regard to the provisions of law more particularly, Rule 100 of the Karnataka Motor Vehicles Rules, 1989, which provides that no person shall be carried in a goods vehicle, subject to the provisions of the said rule, it is contended that the claim petition filed by the claimants was required to be rejected. Stop. This, according to the learned counsel, is the substantial question of law which is required to be decided. Next para. The substantial question therefore is whether, having regard to Rule 100 of the rules, 1989, whether the trial court or commissioner for employees compensation is justified in fastening the liability upon the appellant insurance company. Question mark. Next para. Adadmele stay. Yes. Ivaga Saddika, I don't think we should permit release of the amount. Though they have deposited the entire amount.
It is mandatory, it is mandatory provision to deposit.
At least they have to take steps.
Immediately after service of notice.
Application ಹಾಕಿದ್ರಲ್ಲ 171 ಅಲ್ಲಿ.
Yes, my lord.
MA Act ಅಲ್ಲಿ.
Easy.
You have taken steps to examine the owner of the
For,
vehicle.
for examining owner, we have not filed application.
171 ಅಲ್ಲಿ.
He has appeared through advocate.
But is also reserved to the claimants to get
171 ಅಲ್ಲಿ
25% of the
ನೀವೇ steps ತಾವು.
amount deposited by the insurance company released from the trial court. Yes. ಅವ್ರದ್ದು ಏನು ಬಂದಿಲ್ವಲ್ಲ.
Notice to respond.
Yes, sir, claimant's appeal is also there. Yes, ma'am.
Respond number 5 ಗೆ notice.
ಅಡ್ಮಿಟ್ ಮಾಡಿ ಅದನ್ನ ಸ್ಟೇ ಏನೋ ಮಾಡಂಗಿದ್ರೆ ಅದನ್ನು ಏನ್ ಬೇಕಿಲ್ಲ.
My lord, respond number 5.
Enhancement, ma'am.
So ಅದರಲ್ಲಿ
ಅದನ್ನ they are entitled for enhancement.
Yes.
My lord, in insurance company appeal, in insurance appeal 1 to 4, they have filed a cavatory. He is there. For respond number 5, you notice.
against ಅದಕ್ಕೆ
ಆಯ್ತು.
yes. Okay.
Number 1 is with regard to the dispensation of certified copy.
Huh? Of office objection,
ಹೌದು.
ಇದು office objection.
ಹೌದು, ಆನ್ಲೈನ್ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದ್ದೆ. I have secured the certified copy now. Dispensation ಹಾಕಿ.
Learned counsel for the petitioner submits that he has secured certified copy of the impugned order.
Yes.
Full stop. Learned counsel is requested to file the same in the office.
Second IA is with regard to dispensation of Kannada translation.
Next para. Order on IA number 1 of 2024. Full stop. This application is filed by the petitioner seeking dispensation of
Translation.
Furnishing the translated copy of
Kannada document.
the annexures which are in Kannada language. Full stop. Next para. For the time being, the requirement of furnishing the translated copy of the annexures which are in Kannada is dispensed with. Full stop. IA number 1 of 2024 is accordingly disposed of. Yes.
Matter pertaining to transfer, my lord, had approached the honorable KT. KT rejected, my lord.
Ah. Huh? correct. IA1 was for idu, as per the idu,
One
IA2.
minute. My lord, transfer of my lord, the petitioner was a subject matter of challenge before the Honorable KT. And by virtue of interim order, impugned order, my lord, the KT refused to consider. May I take your lordship to page number 60, annexure A9, my lord, was the order under challenge. My lord, this is the individual order, my lord, passed in respect of the petitioner. ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಶಿಕ್ಷಣ ಅಧಿಕಾರಿ ತತ್ಸಂಬಂಧ ಹೊಂದದ ಅಧಿಕಾರಿಯಾದ ಶ್ರೀ ಮೊಹಮ್ಮದ್ ಗುಲ್ಸಿನ್ ಹಿರಿಯ ಉಪನ್ಯಾಸಕರು ಜಿಲ್ಲಾ ಶಿಕ್ಷಣ ಮತ್ತು ತರಬೇತಿ ಸಂಸ್ಥೆ ಡೈಟ್ ಬೀದರ್ ಇವರ ವಿರುದ್ಧ ದೂರಿನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಹಾಗೂ ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಹಿರಿಯ ಉಪನ್ಯಾಸಕರು ಜಿಲ್ಲಾ ಶಿಕ್ಷಣ ಮತ್ತು ತರಬೇತಿ ಸಂಸ್ಥೆ ಡೈಟ್ ಮಂಗಳೂರು ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಇಲ್ಲಿನ ಖಾಲಿ ಹುದ್ದೆಗೆ ವರ್ಗಾಯಿಸಿ ಆದೇಶಿಸಿದೆ. ಐ ಹ್ಯಾವ್ ಬೀನ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್ 900 kilometers away from the place of the work. On the alleged complaint, may I take your lordship to page number 52. There was some vague complaint lodged against me, which was duly inquired into, and I was exonerated of the charges. Page number 52. Operating portion. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಲಾದ ಕಾರಣಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ಮೊಹಮ್ಮದ್ ಗುಲ್ಶೀನ್ ಹಿಂದಿನ ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿ ಬೀದರ್ ಪ್ರಸ್ತುತ ಹಿರಿಯ ಉಪನ್ಯಾಸಕ ಡೈಟ್ ವಿರುದ್ಧ ಆರೋಪಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಒಪ್ಪಿ ಸದರಿಯವರ ವಿರುದ್ಧ ಆರೋಪಗಳಿಂದ ದೋಷಮುಕ್ತಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. And then same was also
August 2024.
ಹೌದು.
ಏನ್ರಿ?
There is no pending allegation or complaint against
One
me as of
submission,
now.
madam.
Hmm.
KT is next hearing date is 3/1/25, my lord. Next,
Alri.
yes, my lord, I have seen, my lord.
If the
There is no
party
allegation.
makes out a case,
Yes,
should the tribunal not consider it?
that's why I request to direction to tribunal to consider and pass order, my lord.
No, we will pass orders, will stay and then dispose of the writ appeal, writ petition, Berkeley. Learned government advocate takes notice
Respondents.
for all the respondents. Learned counsel for the petitioner is directed to serve copies of the writ petition along with the annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that despite the fact that an inquiry was conducted against the petitioner and by government order bearing number EP 23 DGO 2024 dated 7th of August 2024 at annexure
A6.
huh?
A6.
A6. The petitioner being exonerated of all charges. Come on, nevertheless, the impugned order was passed in notification dated 26/11/2024. Keeping the petitioner under suspension.
The suspend transfer.
Ilva?
Transfer. Mangaluru transfer.
Transferring the petitioner from Bidar to Dakshin Kannada, Mangaluru, on the ground that there are certain charges against the petitioner. Full stop. Yeng start aitu. The tribunal has failed to pass interim orders of stay. Full stop. The petitioner is before this court being aggrieved of the fact that only notice has been issued by the Karnataka State Administrative Tribunal without passing interim orders of stay, despite the petitioner making out a prima facie case. Full stop. Next para. We are satisfied with the submission made by the learned counsel for the petitioner. Full stop. The petitioner has furnished copy of the government order dated 7th of August 2024 at annexure A6 along with the application filed before the tribunal. And the tribunal was required to take note of the same and consider the interim prayer made by the petitioner. Full stop. Next para. Consequently, we proceed to allow the interim prayer made by the petitioner in the application number 21637 of 2024. And pass an ad interim order of stay of the impugned order dated 26/11/2024 at annexure A9, till the next date of hearing. Full stop. Next para. The writ petition is accordingly disposed of, while directing that the interim order of stay passed by this court shall continue until further orders at the hands of the tribunal. Yes.
I am permitted to discharge my services because of this. I may be permitted to discharge my services.
See, you have sought for that interim prayer. We have granted the interim
Please.
prayer. Yes.
CL number 42, Ron Kumar Mutt.
Yes.
Lord, the order at annexure E, especially at page number 66, which is in fact an administrative order of the Honorable Chairman of the Administrative Tribunal, Karnataka. That is challenged before your lordships in view of, I can assume
I
that it
appear
is-
for the respondent number 1, madam.
page number 66, my lords will see. It says 7/8/2024 order.
B group.
Okay.
Huh?
B group.
Huh.
They have not filed their statement
I
as
appeal
such.
for the respondent number 1, madam.
Yes.
My objections are ready for the KAT, but I could not able to file it, but I am ready with the matter. ma'am.
An interim order mela athwa
This is
ಅಲ್ಲ,
only
main
an
matter
interim
ಗೆ ready
order
ಇದೆ.
whereby the Honorable Chairman, my lords, takes up this application which is filed at the Kalaburagi bench of the Administrative Tribunal and now continues to hear the matter at Bangalore by virtue of this note in the order sheet at page 66, which says as per administrative order of Honorable Chairman at para 946 dated 5/8/24 in administrative order number so and so. This application is posted for further orders on 9/8/24 before CH-2 clubbed with so and so. One page earlier, your lordships will see the Karnataka, the Kalaburagi bench of this administrative tribunal had, in fact, my lords, it was hearing this matter. This matter before the Kalaburagi bench was filed by the applicants, the petitioners, because earlier round of litigation, few of the respondents had filed certain applications before the very same Kalaburagi bench with regard to the seniority insofar as HK region is concerned. There was a direction and a remand order passed by the tribunal to redo the entire exercise so far as the HK region's seniority list of the forest officers is concerned. After that, my lords, there is an order passed wherein the applicants, the petitioners before your lordships are now fixed at a particular place below certain other respondents 3 to 4 to 17. That is now challenged before the very same bench again after the remand. Now, my lords, the statement of objection filed by one of the respondents, caveators, stated that if there is a seniority of the state level officers, then this should be heard not by the benches but by the principal bench alone. Upon that, my lords, the court first granted an interim order, continued to hear the matter, and on page number 63, your lordships will see, it noted that the learned GP has filed reply statement for respondents 1 and 2 in connected application 20674 and 678 of 24. That's the main petition now. Respondents 5, 13, 14 called out absent. Postal authority has endorsed stating summons written insufficient. So and so. Then Sri so and so counsel appeared through video conference, submits that he has filed wakalat for respondent number 9 and 12. Post these matters on 13/8/2024 in view of submission interim order granted earlier in application number 20674 of 24 is hereby extended till next date of the. After extending this, my lords, on the next date, probably the tribunal felt that it should take the opinion of the chairman. And the opinion of the chairman is not made available to the applicants. Nor, my lords, the case is posted before the Kalaburagi bench after this opinion is received. But the matter is now directly heard before the principal bench.
So this annexure R1
Yes.
is the notification.
Annexure R1 is the notification.
You are challenging the notification.
Yes, my lords, because now annexure R1 says, in exercise of power conferred under section 18 and 5, read with section 22 of the Administrative Tribunals Act and all other powers enabling thereunto, and in continuation of notification bearing number so and so dated 12/9/2019, it is ordered that the following category of applications, namely applications challenging seniority list of officials in the state level, common cause applications filed by employees filed by employees registered associations, and applications against KS80 shall not be entertained by benches of KS80 at Belagavi and Kalaburagi with immediate effect and until further orders. This is passed by the Honorable Chairman.
Yes.
Now, my lords will see sections 18, 5 and 22. Section 18, in fact, is about the distribution of business among the benches, where the government has to decide, my lords, what is the jurisdiction of each of the bench. And if there is any dispute about that,
Read with
section 5 and 22.
18 and 5.
5
Read with
and
section 22.
yes.
Kodri.
If the administrative tribunal files the statement, my lords, I will be having the opinion of the chairman. I don't know why the honorable chairman has given that opinion to post it before the principal bench. It is not even a case of withdrawal and transfer. It is continuation of the hearing, not at Kalaburagi bench, but at the principal bench at page 66. Even assuming
No,
that
in fact, my lord, I have prepared the objections, but I could not file it, my lord, because only 2 days was there. But I will file shortly, my lord.
You are appearing for whom?
Respondent.
I am for the K80, my lord, first respondent, my lord.
K80. You are appearing for the K80.
K80, my lord. K80, my lord, by exercising the power under 5(6), read with section 18(2) and 25, notification came to be issued, my lord.
Yes. 18.
Yeah,
Distribution.
first, my lord, your lordship may see, my lord, 5(6), section 5(6), my lord, in the Administrative Tribunals Act.
5.
5. Composition of tribunals and benches is there in the section 5. Your lordship may look into 6, my lord, subclass 6.
Yes.
Notwithstanding anything contained in the foregoing provisions of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers and authority of the tribunal in respect of such cases
Such classes
and
of cases.
or such cases of cases or such matters pertaining to such cases of cases as the chairman may general or special order specify.
Yes.
This is first power conferred to the chairman, my lord.
Yes.
And section 18(2). My lord, section 18(1), my lord, it is constitution of the different bench which is to be done by the government. Section 18(2), my lord.
The appropriate government may, from time to time, by notification, make provisions as to the distribution of the business of the tribunal amongst the benches and specify the
This
matters
is the general.
to be dealt with by each bench. If any
Bench.
question arises as to whether any matter falls within the purview of the business allocated to a bench of a tribunal, the decision of the
The
chairman
decision of the chairman, there shall be final.
alone shall be final. Although
Final.
if there is any question arises,
No,
of
no,
a
this has
of a
been
particular
interpreted by the
matter.
apex court judgment.
Please.
Subsection 1 of section 18 empowers the state government.
To constitute the, my lords, different benches, my lord.
No,
That
no,
has
no.
benches has
No,
been
no, no,
constituted
no.
in the year 2020.
No. Appropriate government may, from time to time, by notification, make provisions as to the distributions of the business of the tribunal.
That allocation, my lord, it is the allocation of, my lord, the district in which the tribunal comes, my lord, that is empowered to the government. Benches has been constituted, but power, my lord, to regarding roster and subject matter and everything, it is decided by the chairman only, my lord.
But the
Your
provisions.
lordship will take, my lord, one more section, my lord, one more section is there, my lord, your lordship may see section 25. 25, my lord. Other 22 into there, wrongly spell agide 22 anta, 25 your lordship is see, my lord. Power of the chairman to transfer cases from one bench to another.
That is on an application. That is on an application made by any of the party.
The application of the parties and after notice to the parties and after hearing such of them as may be desired to the heard or on his own motion. Without such notice, the chairman may transfer any case pending before one bench for disposal up to any other bench. Here, under power under these three sections, my lord, section the 2019 notification came to be issued, where, my lord, state level cadre is there regarding seniority, because it will be conflict of interest will be there from my lord. Cases will be filed with the different benches in Belagavi, and Gulbarga and Bangalore. Therefore, my lord, notification came to be issued, which is, my lord, marked as annexure R1.
All right. What has happened in the present case?
Present case, my lord, one case is filed before the Belagavi bench.
Is there any other application filed before any other bench other
Please,
than what
one
was
case
going
is-
on
one
before the
case is-
Kalaburagi bench?
One case is filed before the Belagavi bench and one other case is filed before the Kalaburagi bench. In the Belagavi bench, my lord, interim order of stay was granted, and Gulbarga bench, my lord, the application was, but my lord, interim order passed subjected to result of the application. Then, my lord, the Gulbarga bench sought, my lord, opinion from the honorable chairman. Chairman, my lord, exercising this under these three powers, my lord, transferred the case to the Bangalore bench because it is a state level seniority cadre, my lord. An administrative order is passed by the honorable chairman, which is, my lord, I have my lord, producing along with my objections, my lord. Objections is ready.
All right. You please proceed. We'll have to go
Whether
through
two,
the information.
Yes.
If it is
Section-
true that other applications have been filed in other benches
That,
and thereafter the opinion of the chairman was sought.
no, even in
He has got
Belagavi,
powers.
yes, even in Belagavi bench, there is one application filed which has now no connection with this subject matter of the applicant. Yes,
They are
he-
saying yes, it has been filed.
and
therefore
there,
the
there
opinion
was,
of the
what I am
chairman.
instructed is in Belagavi bench's case, opinion is sought for, thereafter the application is continued in Belagavi bench. Whereas here, the application is not even transferred under section 25
How then
or
is it
withdrawn.
correct that the application before the Belagavi bench continues to be there only?
no, my lord, it will also be heard in Bangalore bench only, my lord, because it is a state level seniority cadre is there. Then
No,
it
no.
will be heard by the
Going by your submission, is it correct that the application filed before Belagavi bench continues there only, and only this application from Kalaburagi has been transferred to the principal bench?
No, my lord, it is not correct, my lord. I will take instructions regarding this. It is not correct, my lord.
Okay.
And already, my lord, your bench has already granted an interim order of stay is there, my lord.
Learned.
That interim order
We are
may be
not
extended.
hearing in Bangalore.
There is an
Bangalore
interim
now.
order here that may be extended.
Huh?
There is an interim order here in this case, which may kindly be extended also till he files.
Learned Counsel Shri Raghavendra G. Gayatri
May I take leave, Manoj?
appearing for the first respondent,
First
Karnataka
respondent,
State Administrative Tribunal, submits that the statement of objections are ready and the same will be filed. Yavaga?
My lord, within a week, my lord. ರಜೆ ಬರುತ್ತೆ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜನವರಿ ಒಳಗೆ ಹಾಕ್ಬಿಡ್ತೀನಿ.
Date may be fixed. Date may be fixed, my lord.
Huh?
Date may be fixed.
Will be filed within a week from today.
Yes, my lord.
Full stop. Copy of the same shall be served on the learned counsel for the petitioner. Full stop. Next para. released this matter on 8th of January 2024.
Right.
Full stop. Interim order granted earlier stands extended till the next date.
CLM 43, Siddharuda B. Pujari.
My lords, appearing for the petitioner in this matter, my lords.
Yeah.
My lords, last occasion, Senior Counsel D.R. Ravishankar had argued this matter, my lords. It's a matter with respect to premature transfer, my lords. My lords, on 24/8/2023, the petitioner who was working at Bagalkot district was transferred to Vijaypura, my lords. It's at page number 32, my lords. On 20.
Posting has been given, whatever directed to
My lords, that subsequent event will not be of any consideration, my lords, because as on the date, my lords, now the KT has dismissed the application on the premise that I'm ineligible to hold the post, my lords. That has to be borne out of the records, my lords. In the transfer orders, nothing has such is reflected, my lords. The transfer order is at page number 36, my lords. 3/9/2024, my lords.
Because it is a matter through counseling posting is given. Once it is given, it is required to be 3 years.
And no posting is shown. It's covered by CMA's judgment and my lords, and the judgment of this honorable court in 16363, my lords. Last occasion, learned senior counsel had given this judgment, my lords.
Issued by this court on 10/12/2024. Learned additional government advocate has filed a memo enclosing copy of the notification dated 4/12/2024, whereby the petitioner has been posted as
CMO.
Chief Medical Officer
medical officer.
through counseling. That is what it is required under the Act.
Government hospital, Sorab.
Government hospital, Sorba,
Yes.
after the counseling that was held in accordance to the rules 2011.
Act and rules, Your Lordship. Act and rules.
Huh?
Act and rules. Act will prescribe the procedure will be in the rules. Medical officers transfer act and rules.
Act ado.
Act to the rules.
Both my lord, act and rules.
The Karnataka State Civil Service Regulation of Transfer of Medical Officers and Other Staff Act and rules. I have placed that to you. Copy ಕೊಟ್ಟಿದ್ದೆ ನಾನು.
My lords, may I kindly refer the judgment of this honorable court, my lords? The division bench, my lord. The question of ineligibility does not arise at all, my lords.
Terms of the Karnataka State Civil Services, bracketly regulation of transfer of medical officers and other staff, close, Act 2011, and the rules therein. Full stop. List this matter after winter vacation.
Senior counsel is
My
there.
lords, I'm sorry, my lords, I'm appearing on behalf of the petition in this matter. Lords, a very, sorry, my lords.
Posting ಕೊಟ್ಟಿದ್ದಾರೆ. After counseling,
It's now
posting
now,
has been given.
lords, the question is this, my lords. The posting, I have not taken the posting. They say that it's a suo motu posting which
No,
has
no,
been
it's all
given.
right. See, whether
Yes.
you take posting or not, that's a different
Yes.
issue.
Yes, my lords.
But merely because you go and take charge, it doesn't mean you will not be permitted to prosecute this matter.
Lords, this
You'll definitely have that
this
right.
matter, my lords, lies in a very narrow compass. If I just take 1 minute of your lords, it's not more than that, my lords, because I can't argue even more than that in this matter. Lords, a case of premature transfer is sought to be defended on the ground that the person who is displaced is not eligible. Lords, whether the question of eligibility can be gone into at a point of time when the premature transfer is effected. This is addressed by two coordinate benches of this honorable court. The first judgment, my lords, is Biradar's case, that is writ petition number 226622 of 2020, which says that if the initial order of posting itself was not under challenge and it is not set aside, then it would not be permissible to, that is Devendrappa S. Biradar.
Yes.
Para 8.
Now I. Para 8.
Para 8, Lords. The arguments of the learned senior counsel for the petitioner so proceeds on the premise that the deputation of the fifth respondent to the post by the petitioner being arbitrary, illegal, and contrary to the KCS rules, inasmuch as fifth respondent being a Group B employee could not have been deputed to Group A post in the different department, and the said illegality having been set right by the repatriating fifth respondent to the parent department by order dated 11/9/20, KT should not have set aside the order, and the same could not have been given effect to by the government. This argument, in our view, suffers from the fallacy of red herring and is totally misplaced. Undisputedly, the deputation of the fifth respondent was not under challenge before KT, nor was it subject matter of the transfer order passed by the respondent number 1. No doubt, incidentally, this question might have cropped up for consideration while deciding the order of transfer passed by the first respondent annexure A6. But without there being any challenge to the order of deputation and consequent transfer, posting and respondent number 5, the said order cannot be allowed to be nullified in the guise of posting the petitioner to the place of the respondent number 5. This is one view taken. But in the present case, though there was a challenge to the posting of the present petition at page number 51, annexure R1, the KAT has not interfered. KAT only issued a mandamus at page 60. So this decision is not taken yet.
One nimsha. These are the submissions made.
Yes. No, this is the no. What I now read to your lordships at paragraph number 8. Yes, Milords. No, the last two lines, Milords, in para 8. This argument, in our view, last two lines. This argument, in our view, suffers from the fallacy of red herring and is totally misplaced. And thereafterwards, Milords, is the finding of the coordinate bench. The contention in this regard, Milords, if I remember, is it's recorded. At para 5, Milords, it is recorded. The contention is recorded at para 5, is answered in para 8. And then, Milords, kindly have a look at page number 51 at page 60. Milords, the order of posting was challenged, Milords, by one Suresh Chavan, Dr. Suresh Chavan, where I was the fourth respondent. And at page 60, the direction is only to consider the representation. Here, there is a specific direction as to whether I am entitled to hold the post, so on and so forth. Everything had to be considered pursuant to the orders of the KT. That is not done even today. So that order remains. Now, so far as this post is concerned, there is a mandate by the orders of the tribunal that my displacement cannot take place until and unless that representation is considered. The authorities are bound by the mandamus. They cannot wish away, Milords, the mandamus which has been issued. This is number 1. Milords, the second judgment is Mahibubi Saab case, Milords, para 41.
One nimsha. You are referring to annexure R1.
Lordships, annexure R1.
Page number 51.
51
Please.
Dr.
Page number 51. Suresh Chavan, fourth respondent is Dr. Basavaraj Hubballi, the petitioner. Milords, here, the same contentions were raised. Milords, what my learned friend read was the contentions which were raised. Page 57, Milords, is the finding given at the last 4 lines. The first respondent issued the notification dated 24/8/23 by posting the fourth respondent as District Health and Family Welfare Officer Vijaypura from the post of RCH Officer Bagalkot since it was vacant. As such, the applicant has no locus standi to question the posting of the fourth respondent. It is further urged that the order dated 28/4/23, which the fourth respondent is posted, the medical officer so-and-so service. Now, this is the contention raised. Then para 6 is the answering. Upon considering various contentions raised, the applicant who is working as a casualty medical officer has approached the tribunal with a request to consider the representation dated 30/10/23 to pass appropriate orders, including not limited to posting him as a district health and family welfare officer, Vijaypura district, if he is otherwise eligible, forthwith at any rate not later than 1 month. Applicant wanted the post of so and so, alone which he is not entitled to claim as a matter of right. In this regard, the Honorable Apex Court in the case of Chief General Manager has held government employees no right to stick to a particular place. As urged by the applicant, he was posted earlier to the said place, which was questioned by another person upon his disturbance, and ultimately the ending in displacing the applicant. Thereby, he was provided with posting. Being a government servant, the applicant is required to work at the place he is posted. On the other hand, the relief sought for by the applicant is to consider him posting to a particular place to which he is entitled to. Authority should have given or informed him, indicating the post to which he is seeking is not available to be posted. This being the fact, without expressing anything about the requirement of consideration of applicant's case to the post or not, authorities are required to consider his representation dated so and so.
Yes.
Now there is a requirement, Milords, that there is this application is required to be considered. They are bound under the mandamus so far as this post is concerned to consider his representation, without which there cannot be a displacement. At any rate, his representation saying that I was not eligible to hold, etc., was not addressed in paragraph number 6. It has never gone into this question, but there is only a consideration. Now, Milord, the other judgment is Mahbubi Saab, which refers to earlier judgment, Milords, in Hitlemani's case, para 41.
Last date of hearing.
This is in writ petition 16363 of 2021. That's last page number 48. Para 41. As noticed by us in the earlier part of this order, impugned order was contrary and in the teeth of law settled by this court in Hitlemani's case, that it was premature as the petitioner had not completed the minimum fixed tenure. There was no simultaneous movement order moving the petitioner out of the post while transferring and appointing the second respondent to the post occupied by the petitioner. This is important. The order appointing and transferring the second respondent to the post held by the petitioner was not preceded by any order of removing the petitioner from the post of director on the ground that he is ineligible to hold the post. In that view of the matter, in the absence of an order of removal, the case of the petitioner was squarely covered by the law laid down by this court in Hitlemani's case, which has been relied upon by the petitioner both before the tribunal and before this court. So I will not read anything further. The requirement as held by the coordinate benches, if eligibility does not form part of the transfer order, then there is no question of interference as long as it's a premature order. But to consider as to whether or not the premature order can be justified on the ground of ineligibility, there's a requirement of passing of an order saying that the post held by the petitioner, the order by removing the petitioner from the said post saying that he is ineligible. This admittedly has not taken place. So therefore, Milords, my respectful submission is that this is purely a case of premature transfer for administrative exigencies, not on the ground of eligibility or ineligibility. This question cannot be, Milords, if your Lordship Mohinder Singh Gill's case says that what reasons are assigned in the order alone has to be looked into, and it would not be permissible for some other reason to be read into the proceedings to justify the order which has been passed. So therefore, Milords, I respectfully pray that the petitioner's continuance to the extent that his tenure gets completed will have to be directed, Milords, by interfering with the orders passed by the tribunal. I'm grateful for the hearing, Milords.
It is your writ petition.
Yes, ma'am.
It is my writ petition, Milords. I am replaced, Milords, by the contesting third respondent. Milords, I was posted on 24/8/23. I am replaced on 3/9/24 within about 13 months.
The impugned order is annexure A.
Milords, yes, Milords, page 36.
36.
Yes.
Yes.
Page 36.
Order passed by the tribunal.
Milords, sorry, Milords. Order passed by the tribunal, Milords, is at annexure A. That is at page number 10.
Page 10. Page 10.
Milords, what the tribunal does is, though what was referred to, Milords, before the tribunal is para 41 Mahbubi Saab's case, the tribunal refers to para 43 and 44, which was purely on the facts of that case, where both of them are not eligible. The petitioner and the respondent both were not eligible, therefore directions were issued. But on principle, Milords, what is stated is never, Milords, adverted to by the tribunal. Tribunal should have considered the principles, not the factual determination of a given dispute.
Yes, Mr. Sarthi.
Am I audible, Lordship? Am I
Yes.
audible, Lordship?
Yes, yes.
Before I address the point of law which the senior counsel has contested, I want to
Yes.
place two materials.
Yes.
Lordship, insofar as district health officer posts are concerned, these posts are exempted under the Transfer Act. Proviso 3 to Section 3. Lordship, audible,
Yes,
Lordship?
yes. Yes.
Which says these posts have been exempted. These posts have to be filled on the basis of the qualification prescribed in a separate government order. That is 26/2011.
You heard what the learned senior counsel is
I
saying.
I got the point. What
You cannot supply all these reasons now. That order should have contained the reason saying this person is ineligible to hold this post, and therefore we are removing him from this post and posting him elsewhere.
It is not so.
ಅದೆಲ್ಲ ಏನು ಇಲ್ಲ ಅದರಲ್ಲಿ.
It is not so, Your Lordship. Since the tribunal in another
Reliance sought to be placed on the judgment of the coordinate bench, which clearly says this point has been considered in Hittalmani's case, and it is clearly held that even if a person is holding a post and he is not eligible to hold, unless there is an order passed by the competent authority holding that he is ineligible to hold the post and therefore we are removing him, by order of transfer, simpliciter, he cannot be removed.
I understood Your Lordship point. Your Lordship, that point is already considered by the tribunal in another appeal.
The learned senior counsel has pointed out, instead of referring to paragraph 42, it has gone by paragraph 43, 44, which is on the facts of that case.
I request Your Lordship. Sorry, Your Lordship.
ಹೇಳಿ. Stuck ಆಗ್ಬಿಟ್ಟಿತ್ತು ಹೇಳಿ.
I request Your Lordship kindly take Chandrakala case which the judgment I have given, so that it will emphasize the issue which the senior counsel is mentioning. On that day I placed this. That is the reason. This is pertaining to the very same department with regard to district health and family welfare officers. Para 21, page 17, Your Lordship got it. In summary, we are considered the view. The applicant has made out any case, not made out any case for grant. I will skip that. Para 2. However, prima facie, since the 4th and 5th respondent are not entitled to hold the post of deputy directors, their posting as a deputy director shall be reviewed in terms of the government order dated 2/6/2011 within 1 month from the date of this order. In the said period, the 4th and 5th respondent shall not exercise any statutory functions related to their areas of work. Subjects assigned to them and shall be entitled to perform only the routine administrative tasks. If no order is passed within period of 1 month, the 4th and 5th respondent shall cease to hold their post. Next. On the conclusion of 1 month period from the date of this order, shall report to the second respondent for posting to a medical officer's post in terms of the statutory rules through counselling. Governing such posting or posted to a vacant post for the time being until the next counselling only. 3 is very important. The first respondent shall also conduct a review of certain others who are alleged to have no eligibility to hold the post of DD or JD. Kindly mark this. Which have not been disputed by the learned government pleader in this proceedings within a period of 1 month and take necessary action to rescind the appointments made in violation of the government order dated 2/6/2011 and appoint eligible persons only through credible selection process within 1 month thereafter. It is made clear that the orders persons who are appointed to the post and are ineligible to hold the post shall be non-est in the eye of law. Next, 22, para is 22 is important. A copy of this order shall be made available to the Chief Secretary of the State and the Secretary of DPAR to intervene the matter of ensuring compliance with the order dated 2/6/2011. Since appointment made is violation of the said order, has the effect of reducing the orders issued by such authority being ab initio void and non-est in law in the eyes of at the instance of affected parties. This case is taken into the High Court. In writ petition number 7566.
This is not pertaining to the parties herein.
No, no.
This is not pertaining to the party. This is with the very same post.
Yes, yes.
It is. This is with the very same post. It is.
So it shows the apathy of the government and the higher authorities. They do not want to follow the rules. What can we do?
That is the reason I am submitting, Your Lordship. Even the High Court has also issued the directions on that.
Despite
Court has
all
also-
that, this is what they're doing.
That is the reason the tribunal considered once the person is ineligible to hold the post, is void ab initio since from the beginning, his eligibility has to be made. Merely that is the reason the finding is given by the tribunal is, Your Lordship, kindly, it is only a temporary. Because since he is not eligible, till the eligible person to hold that post, the posting given to that ineligible person should be considered temporary.
This is not a writ of quo warranto. You cannot make all these submissions. You are also one such officer, and if you are eligible, they can post you, provided they follow the requisite procedure. If he is ineligible, they should first pass an order saying he is ineligible to hold this post, remove him and give a posting to him. Thereafter, in the vacant post, they can fill up anyone who is eligible. They don't want to do that.
This posting cannot be done through counseling. Once he is removed, he has to be taught through counseling only. He has participated, he is notified in the counseling, he has given posting. Now, once again, he cannot come back and say that it is supposed to be given to him. Now, Your Lordship, right or wrong, the posting is given as required under the Act. I request Your Lordship kindly take the Act for a moment. Once the suo motu proceeding is conducted, counseling is given under the Act. The person who gives the posting is required to serve in a particular post for a period of 3 months, 3 years.
Ravi Shankar.
He has no right unless that is already set aside.
Is there an interim order of stay passed by this court?
No,
my lords.
No. You did not have the benefit before the tribunal?
No, man.
No.
No, my lords, I did not have.
Now,
Lords, it was disposed of at
subsequently,
the
if
first hearing
counseling
itself.
has been held and you have
Lord,
been given
this
a different posting,
My lords, now this was during the pendency of this
how
proceedings.
can we put you back into the same post? It's not
My lords,
possible.
now if your lords were to set aside the order which was impugned before the tribunal, my lords, that will be the effect of the order. Lords, how the government wants to interpret the order is a different matter, but the question is only this, my lords.
Sir,
Now,
ultimately,
now,
we
now
also are-
displacement,
the-
that
this court is
displacement
also
cannot be
required to-
unceremonious.
This court is also required to consider whether you fulfill all the eligibility, and merely
my
on
lord.
technical grounds, we cannot put you back into that place.
Lords,
Not
I
possible.
would put it this way, my lords. Even if your lords were to put me back into that place, your lords will be giving a direction that appropriate decision will have to
No,
be
no,
taken so far as my
no,
posting is
no, no.
concerned.
Those orders were passed in that case where you continue to be in that post. Now
Yes,
it is
sir.
not possible.
My
We
lords,
can't
now
put
that's
back
the
an ineligible person into that post
no,
and
no,
say,
my lords, even
thereafter you
even
pass
that
orders.
case,
No, sir.
lords, even if your lords were to see Mahbub Saab's case, there was a specific direction because he was not working there. He was already replaced by the transferee. Then the transferee approached the High Court where they said that since both are ineligible, it should not be. But insofar as the other case is concerned, my lords, Biradar's case is
Ultimately,
concerned.
that is what the court also has to do.
Yes.
It has to see whether the proper person is holding the post. Merely
Yes.
on technicalities, he cannot pass an order which would make an ineligible person come and occupy a post.
Lords,
Not possible,
that is the view expressed, my lords, by two coordinated benches, which says that displacement can take place. I will,
because both of them were ineligible.
Lord, that is insofar as
Appropriate
Mahbub
directions
Saab
were
is
issued.
concerned, my lords. Lord, that is so far as Mahbub Saab is concerned.
Yes.
Lords, the writ petition in Devendrappa Biradar is concerned. One is eligible, one is ineligible. Devendrappa Biradar, your lords, may kindly take, my lords. In that, para 5, my lords, is the argument which is advanced, which is not accepted. Lords, here also he was not in the place. And Devendrappa Biradar, my lords, was the person who challenged. If your lords were to see in the course of argument, learned senior counsel, so and so appearing for the.
Ultimately, what has happened in this matter?
Lords, ultimately that order was set aside.
No, as
Order
a result,
of transfer is set aside.
the writ petition itself is not maintainable and is liable to be dismissed on that score alone. For all the above reasons, the writ petition is dismissed with cost of rupees 5,000
Yes.
on the writ petitioner.
Lords, the application was allowed at page number 3.
Here also there was a subsequent notification on 6/11/2020 where I was given, the petition was given, the respondent was given a different posting. Kindly have a look at page 3 minutes. Aggrieved by the orders passed by the Karnataka State Administrative Tribunal at Kalaburagi dated 20/10/20 in application number so on. So petitioners preferred the writ petition 226, 227 of the Constitution to set aside the order at Annexure A and the subsequent notification bearing number so on so dated 6/11/2020 issued by the first respondent, by virtue of which there was a subsequent posting order given to the petitioner therein. Lords, in this, if your lords were to see para 5, lords, this is what they had clearly stated. This is the contention raised. And in para 8, lords, it is answered. But the requirement, lords, unceremonious exit is something which the courts have frowned upon. You permit an exit, but let it be ceremonious. That's essentially what the courts have said. Para 8. The last 2 lines.
You read it earlier.
Yes, my lords. So therefore, lords, I am not saying, my lords, that your lords will be giving a seal of approval for whatever is happening, but the rule of law, what has been laid down by this honorable court, has to prevail. Procedure once contemplated that when an ineligible person is posted, even if assuming if he is ineligible, first remove him, declare that post is vacant and post somebody else to that post. That's essentially the procedure prescribed.
So
lords, every time they cannot come back and say,
lords, you want a declaration that you are ineligible.
Lords, now, lords, if it is a factual, lords, if it is a factual determination to be undertaken by the authorities, it can be undertaken, lords. It should not be a difficult task.
You should think twice before you make this submission.
Lords, I consciously make this statement. Lords, I am consciously making this statement. Lords, 2/6/2011 is concerned. It's merely an executive instruction.
Don't take technicalities too far. In the present context, now after a posting is given to you, would it be right on the part of this court to issue directions to put you back into that post?
Lords, the holding of,
Lords,
I'll just say this, lords. The releasing of the petitioner from this post is the only reason why I was put into the counseling list. Otherwise, I will not be in the counseling list at all. Because they will have to list out the doctors who should be in the counseling. I will not be in the counseling list at all. Now, if I am not in the counseling list, the question of giving me a posting would not have arisen. Now, if the matter is list pendants, lords, before your lordships, and a subsequent act cannot, lords, undo whatever is required to be done in this writ petition. That's my respectful submission. And I leave it at that, lords.
I want to add only one factor, Lordship. It is not only the petitioner hearing. There are 20 other persons who are ineligible to have been called for counseling. That is what I submitted on last occasion. I placed the material also. All are holding an administrative post who are ineligible to hold the post. It is the only petitioner who has not appeared for counseling.
Others cases is not before the court, lords. Nobody is. The milk is given only to the crying child.
And this post is to be filled up by counseling.
Yes, counseling only.
Yes,
yes. Lords, this post is not required to be filled up by counseling. This is an administrative post for which there will be only a posting. This is not a counseling post.
You are
only
right.
medical officers only through counseling.
You are right. You are right. Purple.
Grateful.
The petitioner is aggrieved of the impugned order passed by the Karnataka State Administrative Tribunal, Kalaburagi, in application number 21375 of 2024, and the impugned notification dated 3/9/2024 issued by the
First respondent government.
The first respondent, state government, through its secretary, Department of Health and Family Welfare, Full stop. Next para. The petitioner was appointed as medical officer on 27/1/2005. And he has worked in various places. Full stop. While the applicant was working as a reproductive and child health officer, bracketally RCH, Bagalkot. He was transferred and posted to a vacant post of District Health and Family Welfare Officer, Vijaypura, by order dated 24/8/2023. Full stop. The petitioner took charge on 25/8/2023. Full stop. It is not disputed that the post of the District Health and Family Welfare Officer is a Group A post. And the tenure prescribed under the general transfer guidelines is 2 years. Full stop. It is contended that having regard to the Karnataka State Civil Services, bracketly regulation of transfer of medical officers and other staff, close Act 2011 and rules made thereunder. ಕೊಡ್ರಿ ಅದು. More particularly, the proviso to section 3, the provisions relating to transfers through process of counseling shall not apply to the posts identified as inter-alia to the District Health and Family Welfare Officer. Full stop. All the other transfers or promotion are required to be done through the process of counseling conducted in such manner as prescribed. Full stop. However, the impugned order dated 3/9/2024 was passed, posting the third respondent herein as the district health and family welfare officer, comma, in the place of the petitioner. Full stop. It was therefore contended that the petitioner has been disturbed before completion of the minimum tenure in terms of the transfer guidelines. Full stop.
Without providing the posting to the petitioner.
It was also contended that no posting was given to the petitioner. Full stop. Next para. However, it was contended by the learned, contended on behalf of the respondent state that the petitioner is not eligible to hold the post of district health and family welfare officer. Full stop. However, when subsequently it was noticed that the petitioner has not completed 20 years of service, comma, which is the minimum requirement to hold the post, comma, the third respondent who is eligible to hold the post has been posted as the district health and family welfare officer, comma, Vijayapura. Full stop. It was also contended that the post of district health and family welfare officer is an administrative post, and such post is not covered under the provisions of the Transfer Act and rules. Transfer Act 2011 and the rules therein. Full stop. Next para. Learned senior counsel Shri D.R. Ravishankar, appearing for the petitioner, points out from the impugned order that although the judgments of this court in the case of Mahiboob Saab versus State of Karnataka reported in 2022/3 AKR 663 was pressed into service, and it was pointed out that this court has held
Para 41 of the judgment.
Para 41, my lords.
in paragraph number 41. ಏನ್ ಹೇಳಿದೆ? That such impugned order are in the teeth of the law settled by this court in the case of Ittal money. ಎಲ್ಲ ಇದೆ ಅದು citation Ittal money.
Not sir. ಇದರಲ್ಲಿ citation ರೆಫರ್ ಮಾಡಿಲ್ಲ. I just.
How can it be without referring to the?
1 minute, my lord.
ಆಮೇಲೆ please please give the citation.
Please, my lord.
That the order appointing or transferring an officer to the post held was not perceived, was not preceded by an order of removing the officer from the post on the ground of his ineligibility to hold the post. Full stop. In that view of the matter, it was held that in the absence of an order of removal, the case of the petitioner was squarely covered by the law laid down by this court in Hittalmani's case, and which has been relied upon by the learned counsel for the petitioner, both before the tribunal and before this court. However, the tribunal has culled out paragraphs number 43 and 44 of the said decision. Full stop. It is submitted that in paragraphs number 43 and 44, certain directions were issued by this court based on the facts obtained therein, and such directions do not constitute the law laid down by this court. Full stop. Learned senior counsel would therefore submit that despite earlier proceedings, more particularly the application filed by one Dr. Suresh Chavan in application number 5312 of 2023 against the very same petitioner who was arrayed as respondent number 4, the tribunal however rejected the contention of the applicant therein that the petitioner was holding the post of District Health and Family Welfare Officer, for which he was not ineligible. Full stop. It was pointed out that in the said order, it was clearly indicated that if the petitioner was ineligible to hold the post, appropriate action will have to be taken by the competent authority to remove him from the said post and thereafter proceed in accordance with law. Full stop. Despite such observations, no orders were passed by the competent authority removing the petitioner from the said post. Full stop. On the contrary, a general order of transfer has been passed, and therefore the petitioner is entitled to question the same on the ground of violation of the provisions of the transfer guidelines. Full stop. Next para. For contra, learned counsel, Shri V.R. Sarathi, appearing for the contesting respondent, submitted that consequent to the impugned order dated 3/9/2024 and the dismissal of the application filed at the hands of the petitioner herein, the respondent authorities have issued notice of counseling
on 3/12/2024.
and by notification dated 4/12/2024, the petitioner has been appointed and posted as
Chief Medical Officer. Chief Medical Officer.
Chief Medical Officer Allah.
Casualty Medical Officer, I'm sorry. Casualty Medical Officer.
Casualty
CMO.
Medical Officer at the government hospital, Soraba, Shimoga district.
By the competent authority under the Act.
Full stop. The learned counsel would therefore submit that at this juncture, after the competent authority has conducted the counseling and has given a posting to the petitioner, this court should not set aside the impugned order, which would enable an incompetent, ineligible officer to work as the district health and family welfare officer. Full stop. Next para. Having heard the learned senior counsel for the petitioner, learned counsel for the contesting respondent, learned government advocate, and on perusing the petition papers, we are of the considered opinion, having regard to the facts noticed herein above, that though the learned senior counsel is right in his submission, that there being no challenge to the original order of deputation or posting of the petitioner as the district health and family welfare officer, on the ground of ineligibility. And therefore, the petitioner could not have been transferred without the competent authority holding that the petitioner is ineligible to hold the said post and merely transferring him contrary to the provisions of the transfer guidelines, we have to say that having regard to the admitted fact that the petitioner being ineligible to hold the post, we cannot pass an order at this stage to put back the petitioner to the post of district health and family welfare officer. Full stop. We also are required to observe that despite such observations coming from the Karnataka State Administrative Tribunal, on 15th of April 2024, in the application filed by Dr. Suresh Chavan, nevertheless, no action is taken by the first respondent, state government, to pass necessary orders holding that the petitioner is ineligible to hold the post. Full stop. We are therefore constrained to observe that the first respondent, state government, and the competent authority are not taking proper steps even after the courts pointing out to the discrepancies in the matter of transfers and appointment of the officers. Full stop. If timely action was taken by the competent authority pursuant to the orders passed in the case of Dr. Suresh Chavan, bracketed Supra, the petitioner would have been removed from the said post, which he is said to be ineligible to hold, while giving a proper posting to the writ petitioner. Full stop. All these unwanted action could have been avoided, if the competent authority had taken note of the observations made by the tribunal in the case of Dr. Suresh Chavan, bracket Supra. Full stop. Next para. As stated earlier, at this point of time, when counseling has been held and the petitioner is given a posting at Soraba commensurate to his eligibility, this court will not venture into quashing the impugned order on the ground of technicalities. Full stop. Next para. Consequently, the writ petition is dismissed.
Observation of administrative post requires to be fulfilled on the basis of qualification. This will solve the issue. This will, otherwise it will perpetuate the.
Yes.
Much obliged, my lords.
ಅದು ರಿಪೋರ್ಟ್ ಆಗಿರ್ಬೇಕಂತೆ ಶ್ರೀ PG ಹಿತ್ತಲಮನಿ ವರ್ಸಸ್
My lords, it's writ petition number 43919 of 2016, my lords.
petition number 43919 of 2016 dated
Please, my lord.
23rd of August 2016. ರಿಪೋರ್ಟ್ ಆಗಿದೆಯಾ?
Much obliged.
ಆಯ್ತು 45 ಯಾವ್ದು ಇದೇನ್ರಿ ಇದು?
I am beneficiary, my
ಹಾ
beneficiary are not made party in the land accusation.
My lord, this is that matter which your lordships had heard at length on
yes,
the
yes.
question of whether
Ah.
the beneficiary.
Ah.
Now, my lord, your lordships had
What
on
happened that
19.
the information was given, isn't it?
Yes, yes, that has been given and the appellant has been, was required to respond to that. But otherwise, your lordships have heard this matter substantially, my lord, nothing more needs to be done. Because, my lord, I'll tell your lordship why that order was passed was because they made an oral statement that we have been picking and choosing. So your lordship passed an order on 19th of November directing us to directing the state to
Yes,
place
yes.
on record all those details of pertaining to this very acquisition, this particular notification.
Yes,
So accordingly, my lord, the state has filed that chart. My lord, it's a one-page chart. Your lordships have that?
Some time, my lord.
So you have gone through that information.
Lord, my client's information is that, my lord, they have provided about 8 to 10 matters, my lord, in the whole, it's a canal. My lord, he says there are more, my lord, matters. And in this also, my lord, they have said that, my lord, for example, one matter, my lord, on the serial number 1 is said to be settled by Nigam, which is valued at, my lord, 2,10,000 and odd. There is no appeal or writ against that.
No, it is this very matter, my lord. This 1 and 2 is a very matter out of which this appeal arises.
Not about the merits of the matter on your appeal. It's not that.
Yes.
That's right. That's the one. My lord.
For
Serial
the
number 1 and
purpose of
2.
considering whether ಇದು KB general ಯಾವ್ದಿದು?
KNNL.
KNNL is beneficiary or not.
Yes.
Correct.
For that purpose,
Yes.
we had called
Yes.
for this information because you
Correct.
said,
Yes.
no, the state government itself has been clearing the
That's
award amount compensation.
I said KBJNL is clearing the amount. The lordship may see the chat. I said, my lord, KNNL is clearing the amount.
If KNN is clearing, then
When they're clearing amount in respect of other
they would
matters.
support their contention that it is a beneficiary.
No, my lord, my case is, my line of argument was, they cannot pick and choose. Wherever they want to clear the amount and wherever they
No,
want.
that's a different, see that is on the main matter.
Yes.
About your,
Correct.
whether the compensation has to be further escalated or not.
That's right.
That
That's
is not the
merits.
issue.
That's right.
That is not the issue. The issue is, this is a writ
My
appeal,
lord,
isn't it?
yes,
Writ
may,
appeal.
may I, my lord, clarify? There is some
My lord,
confusion.
the issue, as your lordship rightly says, the issue is whether whoever
Lord,
is
it
to
not-
pay the
They had
compensation.
filed a writ petition. They
Yes, we had filed it. That's
Yes,
right.
Lord, they had filed the writ petition
That
was
writ petition has been allowed.
allowed. I filed
Yes.
my lord writ appeal.
Yes.
Lord, why this was called for was, my lord, I gave certain judgments where, my lord, their appeals were remitted back and court observed that if there are any compensation satisfied in respect of similarly placed matters, you cannot award less than that. My lord, on that basis, your lordships, my lord, wanted to, my lord, get the information whether all these matters, what is the status, have you appealed or challenged all the orders? And
The learned senior counsel made it very clear that this issue has to be decided by this court.
yes,
As
my
to
lord,
whether,
I'm
as
not,
to whether KNNL can be considered as the beneficiary and whether it is the requirement of law that KNL had to be made a party
Party.
even even before the reference court.
Lord, anyhow,
Without, because the provision itself is very clear.
yes, Lord, I'll clarify. my-
Provision itself makes it very clear.
ಇಲ್ಲ, there is a difference, my lord. ಅದನ್ನ I'm trying to.
Beneficiary,
ಹೌದು. ಅದು
there cannot be any doubt that a beneficiary has to be a party.
ಇಲ್ವೇ ಇಲ್ಲ ಸ್ವಾಮಿ. That's, I am not in complete agreement that beneficiary has to be
Therefore,
made as a party.
we have understood your submission that KNN is not a beneficiary is your submission.
ಹೌದು. ಹೌದು.
But the contention of the KNN is that we are beneficiary. So that question has to be decided by the
Yes,
court.
sir.
My lord, your lordships have anyhow, my lord, taken it as parted. My lord, I have no, my lord, grievance. My lord, I want to address this.
Lordship may treat it as parted because the lordships have invested so much of
Already
time on
treated.
this.
It's already treated as parted. My lord, I
Yes,
am
yes.
not of that. Lordship may fix a date, my lord, so that my client also gets, my lord, the information regarding what are the matters where already these amounts have been satisfied, or my lord, the other, I have also produced, my lord, certain other judgments as well, my lord, to substantiate my claim. That I will address, my lord, by either VC or I'll make it to, my lord, Bangalore.
Lord, the problem is my learned friend makes oral statement across the bar that they are picking and choosing. And then, my lord, the court's attention is diverted.
That
We
is
have
why
spent so
we
much
call
of,
for information.
yes,
If
because he
all
made a
the
statement.
Claim has been settled only by KNNL.
Yes.
Then it is clear that they are right
Correct.
to say that
Correct.
we are the beneficiary and that is why
Correct.
we are paying the compensation.
No, that
Absolutely.
was not the ground on which your lordships, my lord, wanted this information.
That was the ground on which we wanted. We wanted because you
I'll
said,
convince, my lord.
the state government itself is clearing the compensation in some matters.
I'll try to, my lord, clarify that aspect.
My lord, I just one sentence, my lord, just,
If you accept that, yes, in all these matters, the
Yes.
KNNL only has been
Yes.
clearing the compensation, then we can proceed to pass orders.
Yes. Yes.
My lord, I'm on a different, my lord, point.
Absolutely, my lord, that will cut short the whole controversy.
See, what submission you are making is on a different point. What
I
the
will-
learned senior counsel is asking is that this issue as to whether KNNL can be considered as a beneficiary is something that has to be decided. Because they filed the writ petition on that ground.
If your lordships are.
You are making a submission which is a little different. In some cases, they have been.
Yes.
There is a specific direction by the Honorable Supreme Court while remanding the matter in the second remand order, saying that this is how we want the court to proceed. And in that direction, the court has specifically said that the court is supposed to infuse, my lord, uniformity is one part.
My lord, he is making a statement on the merits of the
I
matter,
will
my lord. We are not concerned with that. My lord, he is saying that if you're under the same notification, same
On
village,
the merits of the
maintain
matter, we have heard
uniformity.
you. We wanted certain clarification because you said
Yes.
in some of the matters, the state government itself has made the payment of compensation.
No, my
So
lord.
we called for this information from the SLAO as to who has made the payment. That information is now placed before the court.
ಇಲ್ಲ ಸ್ವಾಮಿ ತಾವು ಆ ಕಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಇದನ್ನ ಕಾಲ್ ಫಾರ್ ಮಾಡಿಲ್ಲ. I'll get that order as well, my lord. My lord, I'm not, my lord, getting away from this court, my lord. Let this court only, my lord, decide. I only request that, my lord, I will conclude, my lord, whatever I want to say, because, my lord, this will have a repercussion on, my lord, many cases. At least this exercise, what is done by this court, my lord, now, calling for, my lord, whether similarly placed matters, they are satisfied or not. That exercise should have been done by the, my lord, learned single judge. And, my lord, the direction of the Supreme Court, my lord, in this case where they sought for a clarification saying that that direction is not tenable. And the Supreme Court, my lord, again clarified that this is how you are supposed to act in these cases. I'll just read that, my lord.
All right, we'll see. When do you want the matter to be listed?
The second or third week of, my lord, I'll make it to, my lord, Bangalore, my lord, any fixed. Second week or, first week is, my lord, the vacation only. After 1 week after, my lord, the reopening or. Or 17.
The request of learned counsel for the appellant. Release this matter for further hearing.
17th, if it is, my lord. Fridays, my lord, the combination.
On 17th of January.
Very well.
There is an interim order.
On the serial number 52, your lordship.
There is an interim order.
Order granted earlier stands extended to next date of hearing. In the end,
Serial-
who is that?
Serial number
person?
52, your lordship.
Come today?
One submission, your lordship.
Huh?
Today, my client is paying some amount, your lordship. What is this?
You could have made a submission day before yesterday itself if he was there.
There was
Why do you want to get matters adjourned?
not your lordship for
How much is he paying? Let him pay.
Yes, no.
ಯಾವ serial number?
Serial number is 52, sir.
This 20,000 is
Serial
52.
For 52 na,
Yes, yes.
the respondent has paid a sum of rupees
20,000.
20,000 to the appellant today. Full stop. Comma, in the presence of this court. Full stop. List this-
final hearing on
release this matter after winter vacation.
Much of it.
Sign ಮಾಡ್ಬೇಕು, sir. ನೀವು amount ತಗೊಳ್ಳಿ.
48.10 ಅದರಲ್ಲಿ ಮೆಮೋ ಫಾರ್ ರಿಟರ್ನ್ ಆಫ್ LCR ಹಾಕಿದ್ದೆ ವೆಕೇಶನ್ ಅಲ್ಲಿ ಹೋಗಿ ಬಂದ್ಬಿಡುತ್ತೆ ಫಾರ್ just enable the claimants to withdraw the amount.
FD amount has
Kept in FD has
matured. Months.
48 point
1 months.
9 and 10.
I'll one also months. 48.1 also months.
Trial court records to
Yes.
be returned.
Transmitted to the
Tribunal.
ಬರ್ಕೊಳ್ಳಿ.
One
Memo file ಮಾಡಿದ್ರಾ?
house.
I have false IA months.
Learned
48.1.
counsel for the appellant
Oh.
has filed a memo seeking the trial court records to be transmitted to the tribunal to enable the claimants to get the amount released. Full stop. Next para. Accordingly, office is directed to return the trial court records to the tribunal, and after necessary orders are passed, releasing the amount to the claimants, comma, the trial court records will once again be sent back to this court. Please, yes.
48.1 also months. Same 48.1 months.
Huh?
I have 48.1 I have filed the application. Your memo ಹಾಕಿದ್ರೆ I file IA months.
Yes.
Lord, item number 50. I have been requesting for posting it for orders.
ಇವಾಗ ಆಗತ್ತೆ.
2 IAs are pending tomorrow or day after.
So,